Well, hello everyone, and welcome to One Civil Law. I hope you're having a great morning as always. It is Thursday, March the 15th, May the 15th, not March, May. Those sound like the same month. May's the new month, March or something, I don't know. Anyways, welcome to May 15th, the Ides of May, someone would say. Yeah. And we are tuning in once again for the Canton retrial. Hope you're having a great day. I'm having a great day. Everything is wonderful and awesome in an uncivil law land, and I hope you're having a great time. I am having a great time. We are waiting for Karen Reed to start. We are expecting the criminalist from yesterday to continue her testimony. That was exciting with her wonderful lab procedures and the question, what would you say that you do here? Because it was unclear at many points what she does. It's like we collected samples, but we didn't test them. I handed the samples off to someone at the Massachusetts State Police. I don't know who. I don't have a log or record of it in any way. I don't test for DNA. What's DNA? And so forth and so on. She was fun and incompetent, or at least it's unclear what she does with her time. I don't know. Have you ever done solo cups before? No. Have you ever done them since? No. Yeah. Do you think that is it too much to ask her? Do you think this is a pile of stupid? That's probably too argumentative. Oh well, if wishing made it so. Do you have any sense of embarrassment relating to this case? Yeah, that might be too much too. Oh well. Yeah, she's a scientist too. Maybe those are things you learn at Scientist 3. Maybe that's where that picks up, at Scientist 3. I don't know. Oh, yeah. Incidentally, by the way, if we hit 550 likes before 11 p.m., 11 a.m. Eastern time, we'll do a merch giveaway. So it is coming up on 8 a.m. on it's coming up on 9 a.m. on the East Coast. So you got about 2 hours. So if we hit 550 likes before 11 a.m. Eastern time, we will do a merch giveaway. So something to look forward to. Tell your friends, encourage them, maybe get some cool merch. It'll be fun. Yeah, there we go. All good. Everything is good in the hood. Good in the hood. Oh, Lord. Smooth Brain is back on the stand. You better believe it. 100%. Smooth Brain is back on the stand. Spinny Fan is back. Spinny Fan is back. That means it's time for a little bit of the Spinny Fan song. We welcome Spinny Fan into our lives.
Only fan knows that they killed a man, an officer, a friend. Only fan knows Karen's innocence. Only fan is outraged till the end. Only fan, this shit goes round and round. 34 on the lawn they found a man falling in the snow, and only the McColberts know.
It is a banger. It is a banger every single time. It is a banger every single time. It is one of the most glorious things in this trial. Awesome. Oh yes, and there are no emoji limits. Hopefully, yeah, I removed all the emoji limits from the bot. So feel free to use as many emojis as you want. Just more emojis, all the emojis. We still have a prohibition on excess capital letters, but you can use all the emojis. Just use more emojis. And incidentally, you can create more emojis because we have some trash emojis. because I created them. We just have some trash generic emojis, so no problem. We'll get rid of some of the crap emojis and replace them with better emojis. So if you'd like to help us create some better emojis, please join our Discord. Remember, they have to look good when they are, 10 pixels by 10 pixels, basically. So, you have to make sure they look good when they're as small as they are, which is challenging. Right. You have to remember to design them to look like, yeah. So all that good stuff is happening and is amazing in every way. Yeah, Miss Shorty for creating the OnlyFans song. That's pretty epic. She didn't create it for me, but she did create it, and it is epic and wonderful. Don't forget to hit that like button, help us get to the goal, and also retweet the pinned tweet. That also helps the things. State's case is going about as well as we all anticipated. We know we're definitely well and deep into the shit sandwich portion of the trial. In case there was confusion, this is kind of what we expected. This is the dumping ground for the stupid. It's like the press conference on Friday. It's the take out the trash day. This is the take out the trash portion of the trial. Man. Hey, 10-month checkup on your knee. That sounds awesome, Tony. Cool. Very good. Also, if there's some good Karen Reed memes that you're aware of, we do have a meme channel now on the Discord, so you can share your memes in the meme channel, and that would be fine. We could do meme reviews. Yeah. I mean, if there's enough meme reviews for us to do a meme review of, yeah, absolutely. We could do some meme reviews during break. 100%. That'd be fun. Thank you, EMJH111, for hitting that join button. It is only 99 cents a month, and it is appreciated. Yeah, I don't know whether or not it's clear that she was framed. It's just clear to me that she didn't do it. Yeah, someone has to convince me that it is plausible, and the more plausible, the better would be nice. Someone has to convince me that it's plausible that a 7,000-pound vehicle traveling backwards at 25 miles an hour can hit a guy with enough force to create a disabling injury, but not enough force to create torn ligaments, broken bones, or even bruising. It's like someone has to convince me that's possible. I'm not buying it. Right? Because even if she hit him, unless the injury caused the death in a causal chain, it doesn't matter too. So even if you assume she hit him, it's still not enough unless the injury itself, of course, caused the death or was a substantial cause, to be more legally precise. So if, the disabling injury caused him to be unable to stand up and he died from hypothermia, that would do it, right? The ultimate cause of death is the hypothermia, but the causal cause of death is the disabling injury. She caused the disabling injury, so she's responsible for the hypothermia, right? That's not that complicated legally. We understand this concept. That's not hard, right? That's fine. But, you still have to convince me that she hit him with enough force to create the disabling injury. If she didn't create enough, even if she hit him, if she didn't create a disabling injury, then the causal chain doesn't work, because you need the thing to lead to the death. It's not that hard. So, you know, you have to convince me that, so either the act itself didn't happen or the causal didn't happen as a result of the lack of bruising. Take your pick. Either way, it's an attack on the mens rea element. Yeah, and if you think that those marks on his arm were caused by pieces of shattering taillight, it's like I've got a bridge to sell you. Something else is going on in this picture, man. And it is proof beyond a reasonable doubt, lest I have to remind you. So not only do you have to convince me it's possible, you have to convince me it's possible with enough assurance that I can get the proof beyond a reasonable doubt. And seeing as basically at this point, I have basically have proof the exact opposite way around, you have a long way to go. So, right, if proof beyond a reasonable doubt is 95%, when it comes to like the actus reus, it's like 5%. So it's basically proof beyond a reasonable doubt the other way around. So that's not a problem. You only have 90% to go. No problem. Chloe ran over him. I buy that. That makes sense. I don't know what happened. I don't know what happened. I don't know if she was framed or just incompetent. You should never put just incompetent past the thing, right? Isn't that one of those laws? It's like never attribute to malice what can be attributed to incompetence. Yeah. It's one of those truisms. So is it the police are corrupt, or are they just completely incompetent? You never put incompetent past everyone. Never put incompetent past people. You know, most people are not malicious. A lot of people are incompetent. And then even if you somehow assume that everything in fact happened, the state, of course, still has to prove it. And then you get into the solo cups and the evidence logs and the evidence floating around in someone's trunk and so forth and so on. So it's like, which of these many cuts do you like in order to get to not guilty? It's like, which do you like best? You know? And, maybe that means she gets away with murder, but, so be it. If the state can't prove it, they can't prove it. So does that mean she gets away with murder? I don't know. State has to still prove it. They can't do it. It doesn't make any sense. It doesn't make sense to my mind. Literally make it make sense. Literally make it make sense. In a way that, of like, I actually have to think about it for a second. That'd be nice. And then, of course, as to what the jury will do or yeah. I mean, what I think and what the jury thinks are definitely not the same thing. And it's always prudent to remember that. I still think, if we had to assess the probability of conviction, 60% seems like a reasonable number. Like, this is all the shit portion of the case, although I kind of forgot how bad the shit portion of the case was. But yeah, this is all the shit portion of the case. So if they, the end really strong with what their physical evidence is, if they shift all the physics stuff into their rebuttal case, they put on a bit of a show. And then, of course, Proctor just becomes their huge liability. But we already know about Proctor. If they can perform a magic trick and make him disappear, they're going to try. He has a lot to make disappear, though. He's a tall guy. Yeah. And also, at some point, hopefully today, we will see the formal indictment and also the probable cause statement against your good friend of mine, Becky with the big butt, clerk of court from Colton County, South Carolina. So we can see all the fun things that she's being charged with, along with the probable cause statement there, too. It'd be nice. A B-Fish ceiling fan company? One thing at a time. I'm not done on the watch thing yet. I figure I've got at least two, maybe three more attempts before I give up. Then I might need to get a new hobby. How hard could it be? He said. It's turned out reasonably hard. Not for at least the reasons I lack the fine motor control. Oh well. Have I Googled how other people keep their hands steady? Not really, but I just have essential tremors. So I just lack the fine motor control. And there's nothing to Google. It's just I just don't have the ability to do it. You know, not all of us are all abled in every single way, you know. As far as disabilities goes, this is a pretty minor one, but it does seem to interfere with this exact thing that I'm trying to do. So we'll press on. You have 3 fake Breitlings you can work on. Nice. A wrist brace. Wrist brace isn't a bad idea. I have wrist braces. I could give that a shot. A mountable magnifier would be helpful. The magnifier I bought kind of sucks. I've also got my chicken dish in the crock pot. Assembled that this morning. So I got my chicken food in the crock pot slowly cooking. I went back to the cream of soups recipe. So I got 5 pounds of chicken thighs with various cream of soups. I went with the low sodium versions this time to try to cut down the sodium. You know, yeah. When does the trial start today? It starts when it starts, man. It starts when it starts. It is beyond my ability to control. I could start a popular brand of cardboard-based drug game called Magic the Gathering. I'm still having the love affair with the watch I recently bought from China. So, and the band I put it on is nice. Is there a big Supreme Court case today? There's kind of a big Supreme Court case today, but not really. The headlines are much bigger. Well, it's big, but not in the way the media is reporting. So I will be your source of value here, okay? There actually is a big case today that's at the Supreme Court, but it's not big for the reason the media is reporting. The media is reporting it wrong. What are the odds, right? But that's okay. I'm an expert. I'm here to help. So the Supreme Court today is hearing an oral argument. The media is telling you the case is about birthright citizenship, but it's not really. It's not really about birthright citizenship. So that's the way the media is. Like, the Supreme Court is hearing oral arguments about whether or not, people born to illegal aliens, born in the United States. Our birthrights are citizens by birth. Birthright citizenship is on the line. Okay, that's not really what they're talking about. But that's what every media source is telling you they're talking about. But they're not really talking about that. What they're really talking about is the scope of injunctions. Because the trial court or the court of appeals, as the case may be, probably the trial court, the district court, put in an injunction, and which they do, it's routine. But there's been this lurking question about the scope of these injunctions. And so the Supreme Court is taking up this issue. And for reasons that are perhaps ill-advised, they decided to take up this issue inside the vehicle of a birthright citizenship case, which, to be honest, was probably a mistake by the Supreme Court. They probably made a boo-boo. I mean, it doesn't really matter for them what the vehicle is. It doesn't really matter. It's just the optics were not great. So they probably should have found, and it would have been easy, they probably should have just found something more banal that they could have decided this issue on. About when a district court issues an injunction, what is the scope of that injunction, or what can be the scope of that injunction? And that is really the issue they're trying to decide. But every media source is reporting it as birthright citizenship. That's not really what they're talking about. I'm sure it will come up. I'm sure it will be mentioned during the oral argument. But that's not really what they're talking about, and that's not really what the decision is going to be about. But they will use the words birthright citizenship in the oral argument, and they'll use it in the opinion, and then people think that's what it's about, but it's not. That's why the vehicle was ill-advised, because it's misleading about what the issue is. The Supreme Court wasn't trying to be misleading, I assume, but that's where we're at. In any event, we will absolutely cover the oral argument at some point, because it's a very big issue for the lawyers. It's an incredibly important legal issue. It's an issue that impacts all cases of all descriptions. So depending on your point of view, you can make a credible argument it's actually bigger than birthright citizenship, depending on your point of view, because injunctions are all cases facing all issues, all of them, all the cases of every description. It's a procedural mechanism, and so it impacts everything. It's kind of a big deal. So so it's a big deal. And also, I think it's very interesting because I can't really find a good answer. All the answers I've considered are kind of bad. They're just which is the worst, which is the least bad, which is the least bad answer. So, but it'll be interesting because if we listen to the oral arguments and we read the briefing, maybe someone has a better idea about how to solve the problem with the injunctions. Our current solution that we have is not great, but all the other possible solutions are like, yeah. Yeah, it's definitely a big deal. It's just a big deal for reasons that are not what the media is talking about. Yes, Paris, I've absolutely been suggesting for quite a while the Supreme Court has to take up this issue. Yeah. This has been an issue that's been percolating for quite a while. The Supreme Court really needs to resolve this issue. Apparently, we've decided to resolve it now. It's a little sudden in some ways. But, they probably have a pretty decent idea about what they want to do. So we'll see. We are 3 subs away from 147,000. Excellent. Will they actually resolve it? Well, the word resolve could be understood to be like that the issue is like done and disposed of. So will they come up with a ruling that will end that will end the issue? Probably not. If by resolve you mean will they clarify or provide additional guidance that will hopefully in some sense establish the boundaries with some additional clarity, then sure. If right now it's kind of foggy, right? If by resolved you mean we're going to know exactly where the lines are, yeah, no, probably not so much. If by resolved you mean it'll be a little bit less foggy, hopefully.
Okay.
What's now opening ABC?
You are unmuted.
I was told counsel wanted to see me. Okay.
Sidebar. But I don't think they're going to punt. I don't think they're going to punt. One of the reasons that they're doing this, although not the only reason, but one of the reasons they're doing this is because Congress is simultaneously considering legislation to address this issue. And the Supreme Court, all things being equal, would prefer to preempt the issue and deal with it themselves. So one of the things that's motivating that, although, of course, this issue's been percolating anyway. So this issue's been like, it's not just that Congress is getting involved. Congress is getting involved because Congress is getting frustrated with the situation. It's so like, yeah, it's like, okay, yeah, we need to do something about it. So I don't think they're going to punt, because if they punt, then Congress probably acts, and they don't want Congress to act. They would prefer to come up with a solution, whatever it is. So, yeah. Yeah, it seems very implausible they'll punt. That they'll come up with a less than 100% clear solution, that's pretty plausible. That they'll actually resolve the issue and tell us exactly what the answer is, I don't know about that. That'd be nice, but probably not. Probably some sort of vague, amorphous test that won't really help anything. I don't know. What's the issue? We were talking about the U.S. Supreme Court. The Supreme Court today is having oral arguments on the scope of injunctions. The media is telling you that they're having oral arguments about birthright citizenship, but they're not really. So the media is not reporting it correctly. The media is saying that the U.S. Supreme Court is having oral arguments about birthright citizenship. They're not really. What they're really having oral arguments on is the scope of injunctions, which, by the way, is just as sexy, at least to the lawyers. It's just as sexy. It's not as sexy to the general public, but to the lawyers, it's just as sexy, if not sexier. But I'm definitely going to cover the oral arguments because I'm obviously incredibly interested in what the Supreme Court's going to say on this issue. Everyone's very interested in what the Supreme Court's going to say on this issue. The injunction issue is as pressing, as important as Chevron is. I don't know if I go that far, but it's definitely something that needs to be resolved in some way. Chevron was my bane. And I haven't quite reached bane territory with injunctions. It's just like, we need to do something. Not this is the devil incarnate. Yeah, so I don't know if it's quite on the same territory. But, hey, reasonable minds could disagree, to be quite fair. Because, of course, Chevron was about all administrative cases. So, I mean, it covered the entire executive branch. So Chevron was pretty big. And I guess the national injunctions really only pop up in administrative cases, too. So, I mean, yeah, this is really only an issue if the federal government is being sued. So I suppose in that sense, they're equally important. They involve all administrative lawsuits. All right, so the court, please. Yeah. You got your hoodie today? Excellent. I hope you enjoy your hoodie. Vinny Polteron is in there. Exciting. Chevron was just batshit crazy. Chevron was just nuts. I'm glad Chevron is dead. I'm very happy Chevron is dead. Chevron can stay dead forever. Next, if we could work on Wickard v. Filburn, that'd be great. A man can dream. A man can dream. Have I seen this case? Fair. Fair. National Firearms Act. The predicate is not there for the National Firearms Act. It's just not it's not there. It's not, the predicate is just simply not there. The Supreme Court doesn't need to take up the National Firearms Act. What they do need to do is they need to take up like 5 Second Amendment cases every year for the foreseeable future. We just need more groundwork. And the groundwork is going to be fairly banal. National Firearms Act is like 15 cases down the line, to be fair. I don't really think you want the Supreme Court trying to deal with the National Firearms Act right now. It's just, you just don't have the foundation to deal with it. You need 15 other cases to even deal with the National Firearms Act or the gun or any of those stuff. They just need to take 20. They just need to take 20 essentially random Second Amendment cases. They don't have to be big. They just have to do them. We just need more foundational work. Then we start talking about the National Firearms Act. It's premature to talk about the NFA. What's Wickard? Wickard is a case that gives Congress a lot of power when it comes to commerce. Too much power. U.S. v. Miller is a trash fire of a case that's best ignored. It is literally hard to read. I've read Miller multiple times, and I'm still not sure what it's trying to say. It is not well written. I've had people tell me what they think Miller says, and their readings are very plausible. But I think it's a bit of a Rorschach test, to be honest. Miller's just a bad case. Miller's best ignored. Miller's best. They can't all be bangers. There's some First Amendment cases that are best ignored. I can't tell you what they are because we've ignored them. See, that's the thing. Like in the not every First Amendment case is a banger. Not every First Amendment case can be something like Tinker, or something like that. Not every First Amendment case can be a banger. There's some shit First Amendment cases too. I just don't know what they are because there's so many good First Amendment cases. I don't have to worry about it. The problem is that I don't have enough Second Amendment cases, so I can't ignore Miller. I need 20 cases so I can ignore it. I can pretend Miller doesn't exist. That's what I need. I literally don't know what Miller says. It's just not well written. It didn't hurt, of course, that Miller's counsel didn't show up. Miller died, and then his lawyer refused to show up to the Supreme Court because he wasn't being paid. The only person that showed up to the Supreme Court was the U.S. government. And then it was a shit opinion.
All persons have any business before
It's best
Beverly
ignored.
County, Justice of the Norfolk Superior Court, and for the county of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning again, counsel. Good morning again, Ms. Reed.
Good morning, jurors.
We thank you for your patience. Once again, we worked out something here this morning.
All right, Judge. I don't know what you need to do, but when you say good morning, jurors, can you please not say it like a kindergarten teacher? I don't. Okay.
Rather than having you watch us over at sidebar, so we appreciate your patience.
I do have to ask you those questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or no.
Obama Law, did you want to join me today? I don't know if you're available. And also MG Law, if you're available, I'm happy to have either of you join me. I could use the company. I can use the sanity. Let me know.
Affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Thank you. May we have Ms. Hartnett, please?
Be happy to? Cool. I'll drop you a link.
Remind you, you're still in the room.
Yes, thank you.
Good morning.
Good morning.
Drop me a thing on Twitter. I'll send you a note back. I'll send you a link back. Send me a DM on Twitter. I'll send you a link back.
Go right ahead, Mr. Lessie.
Thank you, Your Honor. Good morning, Ms. Hartnett, and welcome back this morning.
Good morning.
Your Honor, if I could please have Exhibit 145 that is in evidence
Okay.
Published.
Yes.
Mr. Wolk?
MG Law, just let me know when you're available. I'll send you the link too. That's fine.
Ms. Hartnett, you will recall discussion about the taillight from the Lexus that was discussed on both direct and cross-examination yesterday?
Yes.
And you recall the discussion with regard to the weather that was in existence on or about January 29th. I'm not going to go into it at all. I just want to sort of refresh and reorient to where we were on that topic. You recall that?
Yes.
And I am now going to reference specifically what you referred to yesterday, I believe, as the inner part of the taillight, sometimes the inside of the taillight. Do I have that parlance correctly?
Yes, that's correct.
Thank you. So my question is, did you find any sand or salt or any other debris in the inside portion of that taillight?
No, I did not.
Now, and you can take that down. Thank you, Mr. Wolf. You recall discussion about shards of taillight? Do you recall that discussion at all in your testimony?
No, I'm sorry, I do not.
Okay. I wasn't certain whether we had that parlance. So my question is, to your knowledge, was there any testing of any taillight alleged to have been found at 34 Fairview for biological material?
No, there was not.
And could you just please state what your definition is, inclusion, when you refer to biological material?
Those items were not processed in the criminalistics unit for any type of biological, meaning they would not tested for blood, semen, saliva, or a skin cell collection.
I'm sorry, I missed the last part that you...
Or a skin cell collection.
Now turning and changing topics, there was a T-shirt and a hoodie of the decedent. Do you recall that?
Yes, I do.
And are you okay with my parlance of T-shirt, the yellow or orange T-shirt on the one hand, and then the gray
The word
hoodie sweatshirt?
The word
Is that an
parlance is
acceptable
too
parlance
sophisticated
you?
for this time of
Yes.
day. I need you to use a different word choice.
So,
Parlance is
with
too much for this
regard
time
to
of morning.
those two items, if I could, Your Honor, have published what is already in evidence.
It's too early.
Exhibit 151 and 150. And Mr. Wolk, if we could please put those side by side.
How about the word nomenclature
Alrighty,
instead?
so-
Ooh, we'll
Is it
upgrade
correct that what's on the left is the right sleeve of what we refer to as the hoodie, and on the right is the, what color would you like to call that t-shirt?
Orange, please.
All right, so the orange t-shirt. Is that what we're looking at up on the screen?
Yes, so it's the right sleeve of the gray hoodie and the back of the orange t-shirt.
Thank you. Am I correct that you included a handwritten note on your report that you found, quote, debris from each of these two items, or from these two items collectively?
I don't handwrite notes on my report, so I'm just confused about where you're asking that.
Okay, I'll ask a different question. Hopefully it will be clear. Did you find debris on either of those two items of clothing?
Yes, I performed a debris collection on each of those items and combined them.
I'm sorry, it's not your fault, it's mine. There's a HVAC noise I can't hear. If you
So
could
can we
speak up
turn
just
the
a
air
little.
conditioning off, please?
I'm okay with
I can
it.
speak
It's
up.
just if
I'm
you could
sorry.
speak up a little. I don't want to
Of course.
discomfort people. Can you move the mic?
Yes, I can speak up. My
If you
apologies.
could speak a little louder, that'd be great. Thank you.
Yes.
Can you
How
repeat your
loud is
answer,
the
please?
HVAC in this
Can you
room?
repeat the question? I apologize.
Sure. Did you find debris on these articles of clothing?
Yes, I took scrapings from each of these items of clothing and combined the debris. Yes.
Also, why do you need an HVAC? Are you trying to imply
With
that
regard
OnlyFan
to-
isn't enough? OnlyFan isn't enough for you?
Scrapings. Can you
Dick?
describe how the term scrapings relates to these two items of these two items that are on the screen?
Yes. Scraping is the mechanism I use to remove any debris that was remaining on both the sweatshirt and the t-shirt. I held each up over my lab bench. I took a long metal spatula and scraped any debris that was on these items into a small glassine packet.
Is it correct that you do not know where the debris came from specifically, other than it came from one or both items of both of these two items?
Yes, that's correct.
So the debris could be from just the hoodie, it could be just from the t-shirt, or it could be a combination of the both?
Yes, the items were packaged together, so they were already commingled. So there was no way for me to determine which debris came from which item, and it would be misleading to label them as such, so I combined them.
Exactly where my next point was going to go to, thank you, and my next questions. So what, if anything, were these two items contained in when you got them?
They were contained in a brown paper bag, and they may have been contained in a larger box, but I don't remember off the top of my head.
So when you got them and you saw them for the first time, using your term, they were commingled together, correct?
Yes, that's correct.
And was there any debris in the bottom of the bag?
There may have been. When I examine something on my bench, I also shake out the bag to ensure that nothing is left behind and that everything is examined and accounted for.
Now, am I also correct that there is no description of the actual debris that you found? For example, you didn't specify whether it was little fibers, little hair, little pieces of this or that. Do I have that correct?
Correct. I did not do any examination on it. I just packaged it.
And therefore, you didn't note whether any of the debris was a plastic or a plasticine nature, correct?
Correct. That would not be part of my analysis.
And there was no marker put on any part of the debris that was recovered. Is that also correct?
I labeled the debris with an item number. I'm not sure what you mean by marker, if that's what you mean.
Parts of debris, in other words, there wasn't separate identification or markers for separate pieces of debris.
No, I did not separate out the debris.
There was no photographs taken of the debris?
Not by me, no.
Do you have knowledge of whether there was a photograph taken of the debris by anybody?
I do not.
So you have, as you sit here today, you have no knowledge that there's a photograph of the debris.
That's correct, I do not.
When you received the hoodie and the T-shirt that's depicted as 150 and 151, they came in together, commingled with some debris at the bottom in an evidence bag. Is that correct?
I'm not sure if there was debris at the bottom of the bag. What I can say is that there was debris on the items, and I did shake out the bag. I don't have a memory of anything coming out of the bag. I don't know.
So there could have been debris at the bottom of the bag when you shook it out, you just don't recall.
Yes, correct.
If we could, Your Honor, please have Exhibit 154 already in evidence published?
I feel like I'm either already qualified or overqualified to be a crime scene technician or lab worker in Massachusetts. You know, maybe there's a second career for me.
And let's keep it there for a moment, and then I'm going to ask Mr. Wolk for you to zoom in. Ms. Hartnett, do you recognize this generally, and then I'm going to have it zoom in so you can read it, as an evidence bag?
Yes.
Now, Mr. Wolk, could you please zoom in, starting from the top, so that Ms. Hartnett can fairly read this? And if you could, Ms. Hartnett, just take a moment to read it, and then I'm going to ask you some questions, but I want you to have a fair opportunity to read it. Let me know when you're done.
Okay.
And if we can then scroll down, Mr. Wolk, so that Ms. Hartnett can fairly read the rest of what's on there.
Okay.
Thank you. Now, Mr. Wolk, if you could just leave it where it is now. With Your Honor's permission, I don't see a need to keep the lights off, can have that on, but if
That's
Ms.
great.
Hartnett needs
Lights on,
it,
please.
you'll just let us know. So, is this the evidence bag that the T-shirt and the hoodie were in when you received those items?
To the best of my recollection, yes.
You see the name of collected by someone there. Can you read who that states it was collected by?
Yes.
And state what that is.
It says TPR Proctor.
And are you able to conclude what the TPR stands for?
Generally, we use that to abbreviate trooper.
Right. So that is former Trooper Proctor that it says collected by, correct?
That is what's written on the bag, yes.
And the date of the collection, if we can just, Mr. Wolk, just focus in on that. Thank you. The date of the collection is January 29th, 2022, correct?
Yes, that's correct.
Is it a fair conclusion from this evidence bag and your experience on the matter to conclude that former Trooper Proctor was the person who collected the evidence and put it in the bag?
I have no knowledge of who actually collected it and put it in the bag. I can only read what I see on the monitor.
In terms of,
Can you though?
and
Can
if
you
we
read?
could, Mr. Wolk, please take that down and put back up the side-to-side images and depictions of the T-shirt and the hoodie. Do you know the journey, if you will, of those two items before you received them?
No, I do not.
The debris that you ultimately saw on the hoodie and the t-shirt, and that which may or may not have also been additionally in the bag, do you know where that debris would have been picked up from?
No, I don't know the source of the debris.
And you were not provided with information as to the potential source of that debris, correct?
No.
Were you aware of whether or not the debris, or excuse me, whether those items had been on the floor of an ambulance or a floor of a hospital?
No, I do not have any information like that.
Is it important to maintain the sanitary condition of evidence generally to avoid contamination?
We do our best to avoid contamination once we receive items into evidence, yes.
And what are some of the protocols that are used to avoid contamination of evidence, generally?
Generally, wearing gloves, putting items in packaging, bleaching any materials or utensils that we're going to use, or using disposable materials, sterile materials when possible or necessary. We also wear lab coats when processing evidence.
Is another protocol or technique to separate out pieces of evidence to prevent cross-contamination?
Sometimes we will separate pieces of evidence. If the items are already mixed in with each other, then the items are kept together, can be kept together.
Do you know the chain of custody of
Yep.
Do you know the chain of custody of either the hoodie or the t-shirt?
I only have record of the chain of custody from when it was delivered to the lab.
So before any delivery to the lab, you do not have knowledge of the chain of custody of either of those two items?
No, I just know which detective unit dropped the items off.
And which detective unit was that?
Norfolk Detective Unit.
What I would like to now do is to, we could now take that down. Thank you, Mr. Wolf. I want to sort of speciate, if you will, separate out the evidence
Speciate. That word's way
that
too
you have
sophisticated
talked
for what we're
about
trying to
so
do here.
far, so that it's clear what you submitted and what may have been submitted by others to the lab. Do you understand that concept generally?
Yes.
Thank you. So what I'm going to do is to give categories, and if you would be kind enough to say, I submitted it by some other person, that would be helpful. Any items that were collected from the vehicle, who submitted those to the lab or brought them to the lab?
I did.
The swabs from the red Solo cups,
I submitted the swabs.
the drinking glass that you were presented with at Canton PD,
I submitted that item.
the two clothing items that we just saw on the screen, the hoodie and the t-shirt.
Those were submitted by the Norfolk Detective Unit.
Were there also any fingernails that were part of the investigation and that you had knowledge of?
Yes.
Describe what those were, please.
Fingernails may be collected at the medical examiner's office, and they're clippings from the top of the fingernails of the victim.
And were those submitted to the lab?
Yes,
And by whom?
by the Norfolk Detective Unit.
He uses the word
And
whom.
the phrase known
who says
blood
whom anymore?
standards, are you familiar with that phrase?
Yes.
Can you tell the jurors, please, what that means?
Fonzie,
A known
Fonzie,
blood
Fonzie.
standard is a sample of blood that is collected from an identified person.
And which person were those known blood standards related to your knowledge in this matter?
We received a tube of blood that was identified as belonging to John O'Keefe.
And with regard to the fingernails and the known blood standards, who submitted those to the lab?
The Norfolk County Detective Unit.
So am I correct to conclude that for those items that you submitted to the lab, you knew sort of their journey, if you will, but that those items that were submitted by, I think you referred to as Norfolk County, was your parlance?
Yes, correct.
You don't have knowledge about those other than that they were submitted by them?
Prior to them arriving at the lab, correct. I have no knowledge of what occurred, where they were stored or anything like that before that.
My brain has apparently decided the word parlance is funny. So if I keep laughing,
And
you'll
no
forgive me.
knowledge of those items not submitted by you would include no knowledge of the chain of custody of those items, correct?
No knowledge prior to them being received into the lab. That is correct.
Your Honor, if I may have a moment,
Two
please.
crimes,
Probably
one
be
cop.
30 to 45
Excellent. Plus
seconds.
1
Thank you.
point. Very good.
So the questions I have for Ms. Hartnett at this time, thank you for answering my questions, Ms. Hartnett.
Okay.
Thank you.
Excellent.
All right, Mr. Brennan, any redirect?
You want to try to salvage this? All right. Good luck.
You mentioned that you had an opportunity to observe a paper bag that had red Solo cups in it,
Yes, that's correct.
and the red Solo cups had a coloring of red in the cups.
Yes.
You'd never seen blood preserved in cups like that before?
No.
Your Honor.
To the form, sustained.
Had you ever seen blood stored in cups like that before?
No.
No,
Do
I
you know
wouldn't
the
think so.
circumstances of storing that blood?
Can you rephrase that question, please?
When the blood was stored in the cups, do you know the circumstances?
Sorry, Mr. Brennan. Your Honor, objection. Can we have a sidebar, please?
It's too early for that. Too early for sidebars. Or is it? What is the acceptable starting time for sidebars? That's a good question. We got to start slow, though. Mimosas, I think. Not screwdrivers. I don't know. If we do sidebar every day, guys, we're going to have a real problem. You know, it's just, I don't know. Nah.
The coloring in those cups, do you know firsthand what that comprised of, what the item was?
Are you asking me if I knew what the contents specifically of the cup
Yes.
were? No, I do not.
And so the red cups with the red spots stored in them, do you know the circumstances surrounding the effort made to try to preserve that evidence?
Can you just be more specific in what you mean by circumstances?
Sure. Do you know where those red cups came from?
I was told they were collected from the scene. I don't have firsthand knowledge of the collection.
And you weren't at the scene that morning, were you?
No, I was not.
Do you know that what the circumstances or the challenges were that morning?
No, I'm not aware.
You said that you respond to active scenes and sometimes, like in this case, after the event happens?
Yes, that's correct.
Is there a difference when you're at an active scene as opposed to when you arrive at a scene that is past the event?
I would say multiple units are working at the same time, attempting to document, preserve, and collect evidence.
You were asked a few questions about the top back of the Lexus SUV.
Yes, that's correct.
When you were first asked the question, you were asked if you had studied that area, and you said you didn't recall if you looked at that area.
I did look at the area. I looked over the entire vehicle, but I didn't know anything specific in that area, no.
When you say you looked over the entire vehicle, did you look over the back of the vehicle as well?
Yes, the only part I did not look at was the roof of the vehicle.
Did you study all sides equally? Did you spend time with the entire vehicle?
I believe I made an effort, yes, to look at the entire vehicle.
When you studied the back of the vehicle, not the right side or left side, the back, middle, did you find any hair?
I did not note any hair, no.
Did you find any scratches?
The only scratches I noted were ones that I had spoken of previously on the right.
When you looked at the left side of that Lexus, did you find any dents or scratches?
Nothing that I noted, no.
Did you find any hair on that side of the car?
Not that I noted, no.
Did you find any dents, scratches, or hair anywhere but on, other than the right side quarter of that Lexus?
I did not note any. I also did not examine the interior of the vehicle.
You said that you removed the hair. What do you do after you remove the hair?
The hair is placed into a small glassine envelope, then placed into a larger manila envelope, and then I signed and sealed it, gave it the appropriate case number and item number, and then secured it in our storage room.
Can that hair be further tested?
Yes.
Is that something you would do or a different person?
I don't perform testing on the hair. I performed a microscopic examination of it, and then additional testing can be performed by a different unit.
Let me ask you some questions about where you found the hair. You saw the two different angle pictures yesterday that you described.
Yes, I saw 2 pictures of that hair yesterday.
You were also shown some video where the car had snow and ice on it. Is water a conduit? Does water ever act as an adhesive?
Objection, Your Honor.
Watch the form of the question.
Okay. Why don't I show you a similar video that you were shown yesterday, but we've clarified it so it's more clear. I'm going to ask you to take a look at video 125. Can we stop that, please? And can you see that's 5:51:54 p.m. on 1/29/22?
Yes.
When you first saw this vehicle, it didn't have that snow on the right back near that taillight, did it?
Objection, Your Honor.
Ask it differently, Mr. Brown.
When you saw this vehicle for the first time, did it have that snow packed into the back right of the car?
No, to the best of my recollection, there was no snow on the vehicle when I saw it.
And the hair where you found it, you see the red back taillight, the piece of red that's showing?
I do see that, yes.
In reference or relative to that red, was the hair to the right, left, below?
I don't recall at this time.
Okay. Do you see the ice or snow on the right side quarter panel of that Lexus?
I don't see it on the quarter panel. I'm not sure what you're speaking
Okay.
of.
If we could move that video forward.
Do you know what a
please, to
quarter
702.
panel is? Do you know what a panel is? Do you know what a car
And then to
is?
749, please. Stop. Go forward just a little bit, please. Stop. Okay. There's still remnants of snow. Did it look like that when you first saw it?
No, I believe I did not see any snow on the vehicle when I saw it.
If you could fast forward, please. Thank you. You can take that down. Thank you. You were asked if you had any information about when damage occurred,
Yes, that's correct.
and you offered us you don't have no idea, right?
Objection, Your Honor.
I'll allow that.
No, I do not know when the damage occurred.
You were asked whether or not damage existed on that car prior to that day, prior to January 29th, 2022. You remember that question?
Yes.
Did you know there are ring videos of that car from January 28th, 2022?
No.
I want to show you some photos and ask you a few questions. If we could have 147C, please. If you could close up. Do you remember what that's a picture of or a photograph of?
Yes.
What is it?
That is a tear that was on the right sleeve of the gray sweatshirt.
The threads coming from the side of that hole?
Yes.
Those threads, could you pull those threads and pull them out by hand if you wanted to?
Can you repeat that question?
If you pulled on those threads, could you pull thread from that hole if you wanted to?
Objection, Your Honor.
I'll allow that.
I don't know. I didn't attempt to pull at them at all.
Did you examine them to see if they were woven or loose, those threads?
Yes.
Okay, and what were they?
They were loose. The fibers had started to separate up from the shirt. Separate and weave. I don't want to say they were separated from the shirt completely. The weave was starting to separate.
If we could have photograph 57. '57, 57. Are those the red cups that you saw?
Yes.
And what color is the fluid inside?
I noted there was red-brown stains inside.
Okay, and do you see that white object, the rag or the paper towel?
Objection, Your Honor. Go.
Yes, sustained.
Well, you were asked about, you can take that down, you were asked about who had custody of items. You only have custody of items once you receive them, right?
Yes, that's correct.
If somebody had access to that rag and dipped it in those cups and then smeared it on the taillight,
What kind of question is
and
this
you
now?
went and tested, would you potentially be able to find that red liquid on the taillight?
Objection, Your Honor.
Compound, speculative.
If
Also bullshit.
strands of cloth were pulled from those clothing and placed in the taillight area, would you know when they were placed?
Objection, Your Honor.
Sustained.
When you get to a scene and you examine an area, if you don't see it firsthand, is there any way you can date when items are placed on an object?
I'm sorry, can you ask that one more time, please?
Sure. When you look at an area like a taillight, if you found blood or cloth or another item in that area, would you know when it was placed in that area?
Objection, Your Honor.
I'll allow that.
I think there are really just too many variables to say either way.
There's too many variables to say whether you know or not? Okay.
An item like blood or cloth was placed in that area. Is that something you would be looking for in your examination?
In which area?
Say the taillight, for example.
If there was an object placed in the taillight, would I be looking for that? I would be looking for any item evidence. I'm not specifically looking for anything. I'm just looking for anything that would potentially be evidence.
Thank you. I have no further questions.
Anything further, Mr. Lissi?
Briefly, Your Honor. If we could, Your Honor, have 147C republished.
Oh, dude.
Would it be acceptable to move it along if Ms. oh, you have it? Okay. If we could have Ms. Gilman, I have just one question, Your Honor. Thank you very much, Ms. Gilman. 147C, I believe it.
Okay, I think you already had it up there.
No, it's this one, yeah,
Okay.
exactly. Thank you, Your Honor. Do you recall Mr. Brennan asking you just moments ago a question about this depiction?
Yes.
And to be clear, this is the right sleeve of the gray hoodie, correct?
Yes, that's correct.
You didn't perform any analysis of this area of the right hoodie, did you?
I performed damage analysis on each of those tears on the sleeve.
Right, but you didn't perform an analysis as to the source of that item, what it could be, correct?
Can you rephrase that question, please?
Sure. You didn't do any analysis of what could have caused that hole in the sweatshirt, did you?
No, I did not.
No further questions. Again, thank you for answering my question.
Your
All right,
Honor.
Ms. Hartnett, you are all set.
I wanted to correct something from
Oh,
the
dear.
record yesterday. I wasn't sure when was
Oh, Christ. What are we doing now? Oh, my God. All right.
appropriate to do that.
Okay, do you recall which lawyer asked you the question?
Yes, Mr. Lessie asked me the question.
Your Honor, are we going to proceed along that?
So why don't I see you outside?
Thank you.
The witness has additional exciting comments. Revision to her testimony. Very fun. Very fun. Exciting and fun. Revisions. Good times. If this turns on the sticker reflection thing, though, I'm quitting show business. You'd object to her? I don't know if I'd object or not, to be honest. If she wants to provide exciting revisions and show herself to be like less than fully trustworthy, I don't know. I don't know what my thought would be on the issue if I'm the defense lawyer, to be honest. I could ask some follow-up questions about why didn't you say this the first time, and are you an idiot? I don't know. I have to think about it. Thank you very much by the way, for joining us. As always, we
All
do
right,
appreciate
so
you spending time
Ms.
here.
Hartnett, I am going to let you step down because questions from both sides are completed.
Okay,
So
thank you.
you, though.
Aww. No exciting revisions. Aww. Aww.
Okay, Mr. Brennan, who is your next witness?
Next witness is Dr. Scortibello.
Okay.
May I?
Yes.
Thank you.
Who you now testifying? Who this? New witness. Who this? Who you? Medical examiner? This isn't the OG medical examiner, is it? Is this the new exciting medical examiner? Yeah. This isn't the OG medical examiner, right? This is OG medical examiner? Oh, okay. All right, fair enough.
Why don't I see counsel at sidebar, please?
All right, more sidebar. Exciting. We have a medical examiner apparently of some variety testifying. Not sure whether it was the OG or not. I don't know. We'll find out, I guess. I don't know what's going on. Please make sure to hit that like button. If we hit 550 likes by the top of the hour, 11 o'clock Eastern, we'll do a giveaway. Tell your friends, hit the retweet. It helps bring attention to the channel, so forth and so on. Good times. I got a DM today from Scott Betterow. We're looking at potentially having a discussion on Saturday. Should be interesting. We see the case very differently. So, in terms of our relative assessments of how the state is doing. So that could be an interesting discussion with different perspectives. That could be fun. Also, I need to check my Twitter DMs more in general because I have old DMs I haven't checked, and yeah.
Yes.
You solemnly swear the evidence given to the court and jury in the case now and here is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good morning, Doctor.
Good morning, Aaron.
All right, Mr. Brennan, whenever you're ready.
Is this just the same witness that was literally just on the stand just now? Is this also the crime scene lab technician, but just wearing different glasses? I think it might be the same person. Lol.
Thank you, Your Honor. Good morning. Could you please introduce yourself to the jury?
Good morning. My name is Irini Scoribello. That's spelled IRINISCORDI-BELLO. I am a medical examiner employed by the Commonwealth of Massachusetts.
How long have you been a medical examiner for?
In the state of Massachusetts since December of 2016. In general, I have been a medical examiner since 2008.
Did you attend medical school?
Yes, I did.
Where did you attend medical school?
I completed medical school in New York City at the Mount Sinai School of Medicine, now known as ICANN School of Medicine.
Did you attend a residency?
Yes, I completed my residency in anatomic pathology at the Mount Sinai Hospital.
Is that what you specialized in during your residency?
Yes.
After your residency, did you go right to the medical examiner's office or did you work anywhere else?
After my residency, I completed a one-year fellowship in forensic pathology that was done at the Office of the Chief Medical Examiner for the City of New York. And then I went to work as a medical examiner.
Is there a certain type of doctor you are? Do you have a particular?
Yes, I am a forensic pathologist.
I'm all the doctors,
What are your
baby.
duties at the medical examiner's office?
My duties and responsibilities at the medical examiner's office include performing examinations and autopsies to determine the cause and manner of death in cases that fall under our jurisdiction.
How many other doctors work with you at the medical examiner's office?
I think there's close to 20 of us. I don't know the exact number.
The medical examiner's office, are you responsible for all counties in Massachusetts as far as doing examinations and autopsies?
No, my primary location is in Westfield, Massachusetts, where one of our satellite offices is, and we cover Worcester County and the entire western part of the state. There's 3 offices in the state, the one in Westfield, the one in Boston, and the office at the Cape, in Cape Cod.
You mentioned
The
that
office
part
at
of
the
what you
Cape.
do is to try to determine manner and cause of death.
Yes.
I use the word
Does the
autopsy
office at the
generally
Cape
without
involve vodka and
too
cranberry?
much detail. Can you describe for the jury what the process is when you're trying to determine the manner and
I hope
cause
so.
of death?
You would like me to explain what an autopsy is?
Please.
An autopsy is a large surgical procedure with 2 main parts.
I'm half tempted to mute her testimony and just give my own exciting answers to the questions, just because I'm in a snarky mood. It's like, I'm going to replace her answers with my own answers. What's an autopsy? Well, we try to figure out why the guy died, cut him open a little bit, look at some organs, weigh them sometimes, take some pictures, try to figure out why guy dead. What's your next question, lol?
Autopsy is the internal examination where we make surgical type incisions on the body and we examine the internal organs of the neck, the chest, the abdomen and the pelvis, as well as the head and the brain.
This
This
guy's
autopsy
dead.
procedure,
Why?
and this depends on the kind of case we're doing an autopsy on. Might include other studies such as taking evidence, toxicology, which is done on almost every case, and any additional dissections or any additional steps we might feel we have to take. But that's, in general, what an autopsy is.
Do you ever seek the assistance of any other doctors or professionals that have specialties in your determination in an autopsy about manner and cause of death?
Yes, absolutely. We often, like I mentioned before, we perform toxicology on almost all our cases, and those samples are sent to the toxicology state lab. We also have a board-certified neuropathologist and cardiac pathologist in our office, and very often we will consult with them in determining cause and manner of death.
Are cause of death and manner of death the same or 2 different things?
They're 2 completely different things.
Can you explain to us what the difference is between the 2 of them?
Yes. Cause of death refers to the disease or the injury that initiates a sequence of events that ultimately leads to someone's death. So that disease or that injury
You mean cause
can
means
be
cause? Thanks.
a natural disease such as atherosclerosis or coronary artery disease, or it can be some sort of injury. The manner of death has to do with the circumstances that led to the death. So there are 5 manners of death that we use in our practice. The most common one is actually natural. Natural means that the person's cause of death, the disease that killed them, was due to natural causes. And that would include heart disease, diabetes, cancer. All those are natural processes that take place in the body that lead to death. And so the manner of death is natural. If trauma or an injury is involved, then we have to decide I'm
going to need you to speak to me in a less condescending way, like I'm not a complete fucking idiot. Please. Okay? I'm going to need you to not speak to me like I'm a total fucking moron.
back up. If trauma or an injury is involved, then the manner of death is no longer natural. And therefore, it could be that the trauma was inflicted in an accidental manner, in which case the manner becomes accident. If it was inflicted by another person, with the intent to cause harm, then the manner becomes a homicide. And if the trauma, and when I say trauma, I should include both physical and chemical trauma, chemical when it comes to intoxications due to drugs, et cetera. If the trauma was self-inflicted, then the manner of death is suicide. So we have natural, accident, homicide, suicide.
And then mystery box.
The fifth one
Mystery
is
box.
what we call undetermined or could not be determined.
Yeah, mystery box.
That is when the circumstances in a case are not entirely known or clear to us, and the information that we have does not support one manner of death over another. In that case, we classify the manner of death as undetermined.
When you are conducting an autopsy and making an analysis and attempting to reach a conclusion, you said when you looked at in a case, is your case and what you do different than procedure in a prosecution's case?
No.
Can you repeat the question? I'm not sure I understand.
I can. When you're making your determinations about cause or manner of death, do you have any limitations?
Okay, so the cause of death is something that is
Do
determined.
we have any limitations? Well, I'm not God, although I'm a doctor, so sometimes I can't tell the difference, lol.
By the autopsy. That is my opinion or our office opinion as to the disease or injury that led to that person's death. So that is, I don't have any major limitations unless we're dealing with cases where, the body's decomposed and we're not able to do, all the testing necessary. But in most cases, the cause of death depends on my findings during the autopsy. The manner of death, yes, there are limitations because it's circumstance driven. And so the circumstances might not be known to us at the time of the autopsy. They might not be known to us ever. And therefore, while the cause of death is my medical opinion, the manner of death depends on information I get from other people.
Are you always able to reach a conclusion on manner of death?
No, that's why I said that in cases that we cannot, that manner of death is classified as undetermined.
I want to now ask you about whether or not you examined John O'Keefe.
Yes, I did the autopsy on Mr. O'Keefe.
When you examined Mr. O'Keefe, did you work with a team or by yourself?
First of all,
No,
is
we
he
always
dead?
work in a team.
I mean, is he dead would be a pretty good question to ask. I mean, I guess we're assuming because we're doing an autopsy, so I guess we're assuming he's dead, but is he dead would actually be a reasonable question. You got to establish that the man is dead.
The team is made up of the medical examiner and a medical-
Never forget to ask the really basic questions as a lawyer. Sometimes, they could burn you. So you got to ask the really, really basic questions like, is the man dead?
examiner's assistant that helps with the actual performance of the autopsy.
Have you ever done an
especially,
autopsy on someone who wasn't dead?
When we
That'd
examine
be
the head.
interesting.
And then, of course, we work with the toxicology lab and, in this particular case, our neuropathologist.
The medical examiner's office, is that a division of the Massachusetts State Police?
No,
Is it a division of the Norfolk County District Attorney's Office?
no,
Is the medical examiner's office independent?
yes.
When you conduct an autopsy, are representatives of law enforcement or district attorney's office able or allowed to attend an autopsy?
Yes, they're usually allowed to attend the autopsy if they wish.
Is that an uncommon practice?
No, it's not uncommon.
Would you remember when your autopsy of Mr. O'Keefe occurred?
Yes, I performed the autopsy on January 31st of 2022.
If you have notes,
Yes, I do.
I think you'll be able to use them, but we'll just want to indicate that you're reading from your notes if that's the case. Thank you.
So you can use your notes, Doctor, just.
Thank you.
Thank you, Your Honor. When you began the autopsy of Mr. O'Keefe, do you know who, if any, representatives from the Massachusetts State Police or the Norfolk County District Attorney's Office were present?
I don't remember their names. I do believe there were 2 individuals, and every person who attends an autopsy has to sign a log, and their names would be logged in our records. I don't remember their names.
What is the role of law enforcement relative to the actual physical autopsy? Do they have any role?
No, they're not part of the autopsy. They don't have a role. Their role is to observe. Sometimes they will ask questions, and based on my findings, they might, go on and do their investigation.
Does your office photograph things of interest, like injuries on the person that you're doing the autopsy on?
Yes, we do.
Is law enforcement allowed to take their own photographs as well?
Yes.
Did you in fact memorialize your findings in this case?
I did.
Are there a number of different ways in which you memorialize your findings?
Yes.
I'm sorry.
I took notes, physical notes, pen and paper. There's a report that's issued within 90 days of the completion of the autopsy, and then photographs, digital photographs.
You mentioned a report is due in 90 days. Is that often referred to as an autopsy report?
Yes.
Why 90 days?
That is the standard that is set by the National Association of Medical Examiners. We're part of NAME, and therefore we try to have a finalized report for all our cases within 90 days, because we know that families are waiting for these reports, and therefore we do our best to finish a report within 90 days.
Did you in fact complete a so-called autopsy report in this case?
Yes, I did.
In addition to the autopsy report, well, included in the autopsy report, do you make handwritten notations about locations of injuries?
Yes.
And share with us how's that done. Is there a picture or a graph?
There's a diagram, a body diagram that we use to mark the location of injuries.
May I approach, Your Honor?
Yes.
May I?
Yes.
Do you generally recognize what these documents are?
Yes, these are my diagrams from Mr. O'Keefe's autopsy,
And could you just very basically describe each one of them?
some of them. Yes, the first one is a body diagram. A lot of things have been whited out, but it's the diagram that I would use to make note of any injuries. The second one is a diagram of the face and the skull. I would also use this diagram to make notes as to any injuries on the face. And the third one is a diagram of the inside of the skull, what we call the base of the skull, as well as different views of the brain itself. Again, I would make notes to point out different injuries.
Thank you. As you are noting injuries in your autopsy report, these diagrams, they start off blank,
They start off blank, and then they're filled out as we go along.
and you fill out all the details you find important in your report?
Correct.
For reference, and to assist us, I have some blank diagrams that I may ask you to point out things on the blank diagram for us.
Okay.
And Your Honor, I'd ask permission, I've spoken to defense, to use these simply as a chalk.
Sure.
Chalk!
No objection, Your Honor.
Chalk!
Before you begin an autopsy, do you seek any medical
What
records
everyone else would
available?
call demonstrative.
Yes.
They call it chalk.
When a case is called into our office, depending on the time and the day that it is called in, our intake department, who are the people initially on the phone taking the information, will start asking for both medical records as well as police reports. So in the morning, when we start the autopsy, it's possible that we have some records. Sometimes if a decedent is brought to us
We should
from the
probably have a
hospital, there
chalk
might be some
emoji.
records that come along with the body. But
Actually,
to answer your
that's
question,
pretty
yes,
good.
we
I'll
always
create one.
ask for medical records, what we call PCP records, which are primary care physician
Oh.
records, any records from a hospital where the decedent may have been, and investigative reports, police reports.
Do you recall whether you had access to John O'Keefe's medical records from Good Samaritan Hospital?
I did have access, yes, in the day, I believe the day of and the following day.
May I approach, Your Honor?
Yes.
Subject to any later reactions, I would move the Good Samaritan medical records into evidence.
No objection, Your Honor.
Exhibit 155.
We're going to try to see if this works as an image for chalk. Let's give this a
This
shot.
time, I would move for identification all photos of Mr. O'Keefe's injuries at Good Samaritan Hospital. This is for identification.
Okay.
Exhibit JJ for ID.
What am I trying to
Further,
do?
This time, I'd move for identification.
You know it's going rough
All
when
OCME officers
your
have
brain is not
photos.
quite working, right? The cylinders aren't quite banging. It's like, what am I doing? Why am I trying to do it? What's happening? Trials get to you after a while, man.
One more. Your Honor, at this time, I'd move all CSSS autopsy photos for identification.
I haven't put a lampshade on my head yet, so I got that going for me. Yet. Although my head is so big, I need a really big lampshade. That's a limiting factor. So,
With the court's permission, Ms. Gilman, if you could put up the diagram, full body. If you could enlarge that a little more. Thank you very much. Could you explain this to us?
Yes, this is the diagram that we use during every autopsy. As you can see, we note the name of the decedent. Every case has its own number. In this case, it was 22-1697. And then we take note of, as I mentioned, during the external examination, physical characteristics such as hair, eyes, teeth. And then on this diagram, we would note any scars we see on the body, any tattoos we see on the body, any injuries we see on the body, and any therapeutic interventions. Those would be things that are sometimes done either by emergency medical personnel or at the hospital. Everything would be noted on this diagram.
Now, if you could take us through, I'm going to ask you, we'll go body part by body part, if that's okay. I'm going to ask you to begin with Mr. O'Keefe's face.
does the diagram of the person have to be so unflattering? I mean, who drew this diagram of a person? Has the person who drew this, and have they ever seen a person before? What the hell?
The front of his face. And if you
Yes.
could enlarge that, Ms. Gilman? Thank you very much. Did you notice any injuries on Mr. O'Keefe's face? And if so, could you, I think there's a pointer available for you, doctor? If you could
Yes.
point out on the diagram what you observed.
So on the diagram, well, first of all, there was medical intervention on Mr. O'Keefe that included an endotracheal tube that had been placed to help him breathe. But once all the intervention, all the medical devices were removed, I observed on his right upper eyelid a 1 centimeter laceration. So as we're looking at the diagram, this is the right side and this is the left side. So on his right eyelid, there was a small laceration. I also observed abrasions on the anterior and the left aspect of the nose. So the nose would be here on the front and the left aspect. Abrasions are scrapes. Lacerations are tears in the skin. I should probably explain that. Then there was some bleeding and some swelling of the eyelids of both eyes.
Does that complete your analysis?
For the front of the face, correct, yes.
May I approach, Your Honor?
Yes.
Doctor, I'm showing you a photograph. Do you recognize what's in that photograph?
Yes, this is a photograph of Mr. O'Keefe's face.
Does that photograph depict any of the observations or injuries you made that you just described to the jury?
Yes, it shows the small laceration that I noted during the autopsy on the right eyelid. You can see some of the swelling and some of the bleeding over his eyelids. And that's pretty much all I can see because it's a side view.
Is there an apparatus?
There is what we call an endotracheal tube, as well as a C collar or a C stabilization collar. That's something that would have been placed on him by medical personnel.
All right, move this into evidence. I'd ask for the instruction.
Okay.
No objection, Your Honor.
All right. So, folks, during the testimony of Dr. Scorti-Bello, photos will be introduced to you. They're photographs of John O'Keefe that Dr. Scorti-Bello from the autopsy. So you'll have them in the jury room with you. I'll put them in an envelope, or I'll ask that they be put in an envelope. So if you don't want to look at them now, you don't have to. At some point, we'd ask that you make sure you look at it.
How you doing, man?
These photos are not pleasant, and you may find that they're
little
graphic.
quiet.
But what's important for you to know is that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not based
can't
on
really hear you.
pity or sympathy
I mean, I
for
can
Mr.
barely hear you,
O'Keefe,
but
which
I'd
might
have
be
to really struggle
occasioned
to
by
hear
these
you.
photographs. So consider the photographs only as they draw your attention to a clinical, medical status or to the nature of Mr. O'Keefe's injuries or to the nature of the incident itself. So they'll be displayed up on the screen for
You can hear him, but I can't. Okay. Well,
That's
that
weird.
makes my life difficult.
Thank you.
So they're going to introduce autopsy video or autopsy photos.
Yeah. I guess I can hear you when the court isn't speaking.
Let's go
It's
into
just
the
the
show the
relative
jury.
volumes.
Oh, that's good.
Doctor, can you point out the injuries you were describing by using the diagram, or when you were using the diagram?
We can suffer together.
That's all right.
So the laceration, the small laceration that I...
Why don't you just introduce yourself to the crew?
I'm Chris. I'm a licensed attorney in the state of Alabama. I have been for almost 15 years, mostly criminal law. Doing a lot of civil stuff now. I do in-house counsel work back into criminal law. And yeah, I'm happy to be here. My name
Sweet.
is Chris. So you can find me at Bama Law on YouTube. And I guess now on Twitter too. So
Twatter. Yeah.
Well, Sean calls it that. I think it's a good, I can't call it Twitter. I can't call it X. So I don't know what else to call it.
Previously described would be here on the right upper eyelid of Mr. O'Keefe. You can see some discoloration that's bleeding under his eyelid and what I would describe as swelling. The endotracheal tube and the neck collar are also present here. And the other injury, which I noted, was on the front and left side of his nose, which you cannot see here because this is looking at the right side of his face.
He's describing literally what they did in
Take that
the
down,
ER to
please.
save him.
You mentioned that there was something about his eyes that was notable.
Yes,
PPL
there
hemorrhaging?
was bleeding or hemorrhage, as we call it, on the eyelids, as well as swelling.
I'm going to ask you more detail about that
Well, he got
later,
hit in the
but
head.
was that observation important in your ultimate diagnosis or
Yes.
conclusions? May I approach Your Honor?
Yes.
I have never seen a judge this biased in my life. I mean,
Yeah, it's pretty sharp.
Photograph, do you recognize that?
if I were
Yes,
counsel,
this
I'd
is
just have my
another
hair at her
picture showing Mr. O'Keefe's face. Again, the medical intervention is present, and you can see more clearly now the discoloration on the upper eyelids.
Is this vantage point helpful for your ultimate conclusions and diagnosis?
Yes.
Your Honor, move this into evidence.
No objection, Your Honor.
Exhibit 157.
With the court's permission, I'd like to
rose.
show this to the jury.
Yes.
P645, please. Doctor, could you point out what was significant regarding Mr. O'Keefe's eye area?
So I noted that there was discoloration, that's bleeding, that's blood, that's under those eyelids. The eyelids appear puffy, that's what we call edema or swelling. And then also there were two abrasions, two scratches on Mr. O'Keefe's nose. You can see one here and then the other one on the more front part of his nose.
Okay, could you take that down, please? If we could move down a bit to the chest and stomach area, did you make any observations about this area, Dr. Scotabello?
The observations that I made on the chest were that there was, as I mentioned before, there were defibrillator pads on the body, and there was an abrasion that's very commonly seen in people who have undergone resuscitation. Internally, that abrasion and the whole resuscitation apparatus was associated with some anterior rib fractures, which are also seen in cases of resuscitation, but I didn't make any other notes in terms of trauma on the chest or abdomen.
I'd like to move to the arms and the hands, if we could come down just a little bit. Let's begin with Mr. O'Keefe's hand or hands. Did you make any observations regarding Mr. O'Keefe's hand or hands?
Yes. On his upper right arm, I noted that he had a superficial abrasion. So it would have been, you can
Could we move that down a little bit,
move it
please?
down a little bit. Yeah, thank you. Doesn't seem to be doing a very good job. Okay, somehow doesn't want to
Sorry
work.
if that's not working well.
Who
It's
drew
projecting here,
this?
but not on the actual picture.
Well, it's better than a retarded fourth
Maybe
grader.
a second pointer?
I can do it here.
Okay, great.
Yeah.
Actually, no, it's not.
So
I give it
on
that.
the right upper medial arm, that would be the
Yes.
inner side of his arm, there was
It's gender
a
neutral.
superficial abrasion. Again, that's a scrape. Then on his right posterior arm and forearm, so not exactly.
Who gave this woman a laser
on
pointer?
this aspect of the arm, but on the back side of the arm, which would be in the back of the diagram, there were multiple abrasions, which I described as ranging from 2 to 3 millimeters and up to 7 centimeters. Then, if you could move the diagram down, please. Again, there is a back to this diagram. I don't know if you could put that on the screen. There we go. So this is now the right side, and this is the left. I noted that there were 2 bruises on the back of his right hand, also a faint scratch on the back of his left hand. And then moving down to the lower extremities or the legs, if you could please show the front, there was a small abrasion, a small scrape on the side of his right knee.
May I approach, Your Honor?
Yes.
Doctor, I'm handing you a photograph. Do you recognize what's in that photograph?
Yes.
What is it?
This is the back of Mr. O'Keefe's right hand, I believe.
Is that fair and accurate depiction of how his hand appeared when you examined him?
Yes.
Will this is evidence, please?
No objection, Your Honor.
Okay.
Exhibit 158.
With the court's permission, I'd show P647 to the jury.
Okay.
Yeah, looks like a dead dude.
And could you explain, you said there were 2 bruises. Could you point those out for us?
Could be from IV.
Yes.
Postmortem.
There's one here and one here.
Although technically they do it in
Did you
AC,
attempt
so I don't
to
think that's IV anymore.
assess those, determine whether you could conclude or opine on a cause of those?
No, I did not. Well, I take that back. I'm sorry. So this particular one has 2 small little pinpoint
Looks like
defects
fangs.
in the middle, which we sometimes see when emergency personnel tries to get access to a vein for fluids, for intravenous fluids.
I have never seen them do
but
that
I
in a
did
trauma, and I
not
worked
put that
in a trauma
in my
room.
report. I just described
hand
it
is not what you
as
use.
a contusion.
You go to the
Is
AC,
it common to
the
see
elbow
that
area.
type of
Yeah.
coloration where medical personnel put
You get blood
intravenous
in the hand.
or other types of support into somebody's hand?
Yes, it's very common for the skin to bruise when someone tries to get access to a blood vessel.
The
Through the
other
hand,
coloration
as opposed to,
that
like,
is
the arm.
unrelated to those 2 small points, would you have a description of what those are?
No.
It's the Keystone Cops meet the Keystone
I'd
ER.
also like to show you exhibit number 1.
Or the leg, or, so many other options.
The neck.
Exhibit number 1, please. Thank you.
Yeah.
I mean,
You use the word superficial. What does that mean?
yeah, I'm
Superficial
expecting her to
means
blind
that
somebody.
the abrasion is
No
on
bet.
the superficial layers of the skin,
I'm gonna-
really the epidermis and sometimes the dermis,
Cartman
but
scream.
there's no penetration of the skin.
When you're assessing to determine whether there's any penetration, do you measure the length of the wound or
Well,
the abrasion?
penetration would be measuring the depth. If there was actual penetration,
Those
I would
do
have
look
to
French,
measure how
I
deep
admit.
into the skin.
Don't look
For
like
example, when we assess
Eastport crime scene 2 decades
stab
ago.
wounds, we have to measure the depth of the
They're
wound.
weird.
In this particular case, you can see that these are scrapes or scratches, and there's no exposed underlying fat
Convince me
or,
a car did that.
muscle.
That's the problem.
And therefore, to answer your question, I measured their length and gave a range, but I did not measure their depth.
As a routine practice during an autopsy, doctor,
Are
if there was
taillight
penetration
covers
or
made of
depth,
plate glass?
would you, as a
No, the
routine,
plastic
measure that?
produced massive damage, though.
I would make
That's how
a
it
note of
broke.
it.
Are there any such notes in any of your autopsy findings or reports about depth?
No, I did not make a note on the depth of these ones.
You can ask my BMW's rear
Do you
tail light
have an
and why I
opinion
had
to a
stitches.
reasonable degree of medical certainty as to how those superficial abrasions occurred?
I do not.
And I asked you about the hand, which we just saw, and I should ask you the same question. Do you have an opinion to a reasonable degree of medical certainty how that coloration, aside from the medical intervention, do you have an opinion to a reasonable degree of medical certainty how the other discoloration happened on Mr. O'Keefe's hand?
I can state to a reasonable degree of medical certainty that that's a bruise, a contusion, but I cannot tell you how it occurred.
And to summarize finally what we've been through so far, regarding the scrape on Mr. O'Keefe's right eye, can you provide an opinion to a reasonable degree of medical certainty how that scrape occurred?
No, I cannot.
Well, that was useless. I don't think he expected that answer.
You mentioned for us that when you looked at Mr. O'Keefe's legs, you observed bruising on his, or a small scratch on his right knee.
Correct.
I don't want to summarize it. Can you describe that
Can we turn
more
the lights on,
specifically?
please?
Thank you.
Yes, I described it as a 1/2 centimeter abrasion on the right lateral knee.
Did you see any
A
marks
half
or abrasions
centimeter?
on his left knee?
No, I did not.
What?
Was that like a
Was
quarter
the
inch?
mark scratch on Mr. O'Keefe's right knee on the inside or the outside of the
Yeah,
knee?
about that.
It was on the lateral aspect, which would be the outside.
Thank you. May I approach?
Yes.
The dog bites are kind of unique. I mean, these don't look like dog bites.
Doctor, I'm handing you a photograph. Do you recognize what's in that photograph?
Yes,
What is it?
this is a picture of Mr. O'Keefe's lower extremities, his legs.
Is it a fair, accurate depiction of how his knee appeared when you did the autopsy?
Yes.
All right, we'll get to the evidence.
There's probably an
We'll go
abrasion
further
that big on my legs right now, if I had to look.
Probably from that watch you did the other day.
It could be.
I think the hand is, you just need to swage the hand.
With the
to
court's
get it
permission,
fit.
I'd like to show the jury 9467.
Was it too tight or was it too loose?
It just wasn't going on, and it was.
You used the
just
word
having
lateral,
problems,
and you
it
talked
was a
about,
disaster.
Get a new set.
Abrasion or a scrape.
I bought
Could
6
you
sets of
Look at
hands.
this
Oh,
photograph.
damn, you may have a,
Mark Skillman,
opinion
and could you
issue
Point
then.
out to the jury
On the
and
movement.
explain what it is that you saw.
Yes.
Oh,
you
it could be
you
I
can
fucked up the
see
movement. That's
abrasion
definitely
here
possible.
with a little bit
Yeah.
of
Is it a
adjacent
TMI or a
discoloration,
Seiko?
but this is what I was
actual
describing.
movement? Is it?
If you could zoom back.
I
up,
don't know
please.
who actually make it supposed
Look
to
on
be
the
a
back.
tin
Didn't
hand,
see
but who
any
knows?
similar type
Look on the
bruising
back
or
rotor.
abrasions
If
on
you
the
see
left
the
knee.
letters TMI, it's out of the Malaysian factory,
Nice.
which it probably is. SII. would
During
be
your
quicker.
autopsy, did you notice any injuries
grieving out on watches.
internally to Mr. O'Keefe's rib area?
Yes, I did note that there were rib fractures on.
What are you sporting today?
A San
Anterior, that would be the
Martin
front.
Pelagos homage since
of
my ex-wife
his
took my
fourth and
tutor,
fifth
Pelagos.
ribs.
Okay.
So would that be his
Swap them back.
left or
You'll she'll
right
never
side?
notice.
It would be
Yeah,
both the
well,
right and the left, and it would be
I suffer
the
daily.
part of the rib that is
I
closer
love
to
your
the sternum.
Zen homage, though.
Yeah, I'm loving it a lot
Is there
too.
a number
Love
of
it.
ribs that had fractures, or are they connected as one?
The fourth and the fifth.
It definitely speaks to
both
me.
on the right and the
I'd
left.
rather have it than like a Black
close
Bay
to
or
the
something
sternum.
generic.
Oh yeah. Oh God, yeah. I'd love a real one.
Have you, in your experience, seen ribs fractured during first aid or medical intervention?
We fracture them all the time.
Very often, yes.
Yeah. That's a
Given your
stupid question.
experience and your study of Mr. O'Keefe's body, do you have an opinion to a reasonable degree of medical certainty how those rib fractures were obtained?
I believe those rib fractures were due to resuscitation.
That makes sense.
Probable.
And you have that opinion to a reasonable degree of medical certainty?
Yes.
If
I
you're
don't think
doing it
people-
right,
Yeah, if you're
if you're
doing,
doing
it
it
right,
right.
you're gonna crack them. It's inevitable. 3 or 4 at least.
I'd like to show you a different diagram, one of...
You can't hear what the court is saying? Who
head
can't you
area.
hear what is saying what? You have to be more specific.
You say,
in
it
chat.
sounds perfect.
Yeah, I know it sounds perfect to you, but how it sounds to us is not how it sounds to chat, which is fucking
Got it.
annoying.
Yeah, that is.
Enlarge
annoying.
the bottom right. Thank you. Using that diagram, could you assist us, doctor, and explain to us any observations you made about the back of John O'Keefe's head?
Yes. The main observation was a laceration that is a skin tear on the back of Mr. O'Keefe's head to the right of midline. So this would be the midline. The laceration was somewhere here, is what we call the right occipital area. And associated with that, there was an abrasion over it that
Why can't she just
would
get
have
up
been
and
here.
walk and point?
So this was what we call a compound injury, an abraded laceration.
We'll turn in a few moments to your autopsy observations about the inside of Mr. O'Keefe's skull. But first, I want to just show you a photograph relative to what you described to us. May I approach, Your Honor?
Yes.
Watch face puncture wound. That's a good text.
You recognize what's in that photograph?
Yes, this is a picture taken at the time of autopsy. This is the back of Mr. O'Keefe's head. The hair has been shaved off so that the injury can be clearly photographed, and it's a laceration with an associated abrasion.
Thank you. Your Honor, move this into evidence.
Okay.
No objection, Your Honor.
Here.
Exhibit 160.
Kurt, how many think weeks this trial will go?
6 to 8, I think, was the projection, but
10.
depending on what the defense is doing, because the last time the defense had like 2 days, and I think they're going to dump a lot more into the defense case.
They've got to.
Plus, spends quality time with Proctor, so
I was about to say that. They've got to call him.
When you examine the laceration, do you measure it?
Yes,
And did you measure it in this case?
I did measure it.
How long was the laceration?
I measured it as 2.5 centimeters, which is close to an inch.
Do you examine a person's body before you begin to intrude? Do you examine the outside of a person's body first, or is there a certain procedure or order?
Yes, the external examination is done first, and the internal examination is done second.
I want to show you that photograph that you just recognized, and I would like you to explain what you see to the jury. Ms. Gilman, with your assistance, thank you.
This is the laceration that I noted, and this is the scrape that's associated with it.
Take that down, please.
I'm surprised he hasn't asked whether or not they were pressure wounds, like pressure cuts that you get from boxing. A lot of times people get them when you get hit in the head.
After you make observations, what are your next steps in an autopsy?
The internal examination, after the external is performed and pictures are taken, then we proceed with the internal examination of both the, as I mentioned before, the torso, the body, as well as the head.
I'd like you to take us through the internal examination. Did you have a chance to look internally behind the laceration you saw on the back of Mr. O'Keefe's head?
Yes.
And when you did that, could you describe for us what you saw?
Yes. The way we examine the head is we make an incision with a scalpel behind the ear from one side to the other. That allows us to reflect or pull back the scalp, and that will expose the skull underneath. We do this carefully so that we don't disfigure clearly the face. And when we reflected and when we pulled back the scalp, I noted that there was blood, what we call hemorrhage, under the laceration or associated with the laceration on the back of the right head. And then furthermore, there were skull fractures associated with that laceration, abrasion on the right side of the head.
Okay, so he fell and hit his head on the ground.
Were the skull fractures in the same or different area?
The skull fractures were in multiple areas of the skull, what we call the base of the skull. Imagine the base of the skull is sort of a bowl, and the brain sits on top or in the bowl. When the brain is removed, you can have a very good view of the base of the skull. So when the brain was removed and we were able to look at the base of the skull, I noted that there were multiple fractures that appeared to be originating from the area of the laceration, or what would correspond to the area of the laceration.
When you made your examination of the fractures in the skull, did that lead you to your opinion, or was there more you needed to look at before you came to an opinion about the cause of death?
Well, that was part of the findings that led to my opinion. But yes, I removed the brain, and
He's probably
as
dead at
is
that
our
point.
protocol. I saved the brain in a special solution called formalin that allows the brain to become a little harder, so that our neuropathologist in Boston could go ahead and examine it. Because
Brain's
when I
made of
did look
nothing
at the
but
brain,
fat, so that's why they do it.
I noted that there were injuries. There was bleeding on top of the brain, and therefore I saved it. The brain ultimately went to our Boston office, and our neuropathologist, Dr. Stonebridge, examined it and issued a report.
Did you engage in any type of analysis on your own about any injury to Mr. O'Keefe's brain?
I noted the kind of injuries I could see superficially on the brain, and I have looked at the brain after it was fixed and pictures of it, but I did not issue a report on it. The whole point was for our neuropathologist
I don't like the way she
to
says the word
examine
brain. It must be
closely
the
and issue a
accent or
more
something,
detailed
but
report.
it's weirding me
I
out.
have a few more photos. Would now be a
Well, she's not
appropriate
French.
time for a break.
Blaine.
Yes.
Oh, Jesus.
Jurors, why don't we take
Jesus.
15 or 20 minutes?
That's like 30 to 40.
Court all rise for the jury.
Oh, God. Cue the OnlyFans.
OnlyFan is the best part, man.
It is the best. OnlyFans is good. Oh, my God.
Only the best OnlyFan content here at Uncivil Law, I'll tell you what.
Oh, man. I've never seen so many sidebars. I've never seen so many interruptions.
Yeah,
in
no.
a trial.
Yeah, I'm not a sidebar fan. It's like You know, if I think I'd go the other way. If I'm a judge, I'm like, yeah, speaking objections, fuck it. I'm not doing sidebars. That's fine. I don't care.
Yep. And they never declare what the objection is. And I get it if they've got, predetermined type motions in limine or whatever. That they're referencing in the judge.
Maybe they're doing like hand signs.
It's like baseball. Yeah. At this point, anything's possible. I've just never seen anything like it in 15 years. It's just blows my mind.
Yeah, well, going back to the issue of what you said about bias earlier, it's like for me, it's just the way she treats the two sides. It's day after day, right? It's like on any given day, the judge is going to have a bad day.
Sure.
They just decide that they don't like you on that particular day. But like when you see it day after day, and she just treats the state as the golden child and defense as this corrupt element with the whole like ethics issue. First of all, I don't even think there was an ethics issue. I don't think it existed. Second of all, even if it did, what the fuck? We're trying to make this such a huge issue. I don't know.
And the punishment was a joke. I mean, so it obviously wasn't as big a deal as she made it to be. And I think it was on both sides. Because I didn't watch the first trial, but I think they've had issues on both sides for both. So I mean, things happen. The way that the experts were paid, and it's like, well, I screwed up. It would have been better had they just fessed up and be like, I fucked up.
Have you ever seen a voir dire of a fact witness in the middle of a trial?
No.
That was good.
No.
I was like literally voir dire hearing what the fuck. That was my notation.
I don't even. That's not a thing. Like I've never heard of voir diring anybody in the middle of a trial.
No, that was good.
The judge, I mean, I practiced in not podunk, but I have, and then the judge would have been like, "Nope, keep it going. Keep going. We ain't got time. I got to get home. I got lunch. I got to get some supper in me. I ain't got time."
Yep.
I mean, have you kept up with Lori Vallow?
I mean, just a little bit. I watched parts of her trial, and she did better than I expected as a pro se.
yeah.
I have to give her credit. I mean, I've seen lawyers do worse.
I know. Yeah, that's what I was gonna say. I've seen much worse. Her motion the other day was she wanted to be unrestrained in the courtroom, and I'm like, yeah, your body count's gotten up there. I highly doubt that's gonna occur. Although they did let her have lunch with her lawyers, like upstairs or something.
Oh, that's nice.
Yeah, I thought that was sweet of the judge, but everything else got denied. So,
have you kept tabs of Sarah Boone at all? She's always hilarious.
Oh my God, I've had clients like her.
She's great.
Oh yeah, I've had clients like her though. It's like, you're gonna do what I want. It's like, well, you are the captain of your own ship. If you want to run it into the freaking coral reef, that's fine. But I would have quit too. She's a loony. She's a loony. I have never seen anybody like that. Not to that degree. I've had clients like her where it's like, you're going to do what I want. I know the law. It's like, what the hell am I doing here?
I mean, strictly speaking, you can say no, fire me.
Yeah, I do. I have.
It's like, no, I'm doing it my way. Fuck you.
I mean, I've taken their check literally and be like, oh, here's the payment. And be like, yeah, there you go. Have a good day. The door is right there. Don't let it hit you where the good Lord split you.
Mm-hmm. Yeah.
It's just not worth it. Even if it's a big payday, it's like, no.
I want to be a judge, but I don't think I could be a trial judge. I don't know that I can deal with all the bullshit of all the minutia. I don't know if I could deal with all this minutia bullshit. It's just
well, I mean, you'd be able to handle it though, because you would deal with it a certain way. I mean, look, as long as you don't care about being appealed.
Oh yeah, no, I don't care. That's fine.
And every judge I've ever dealt with, they're like, "Oh God, I might get appealed. Oh no."
Yeah, fuck it.
That's my viewpoint, and I have dealt with without naming names in Eastern Alabama. He's retired now, but he was a JAG officer as well, and he had that viewpoint. It's like, I don't care. Let the Alabama Court of Civil Appeals overturn me. Okay.
Yeah,
my decision.
Turns out.
Yeah. And I don't even think they ever
posted.
did. Yeah. Yeah. He's like, meantime, we're still going.
Yeah. Yeah.
I bet they're on a piss break.
I also want to try to do the chess clock even in a criminal trial. See if I could pull that off. That'd be good. It's like we're having this much time. You figure out how to spend it. Let's see if I can make it comport with due process guarantees.
This is bad, dude. This is so bad.
Stop wasting my time. Stop it.
Oh God. It's like did she say it was a sidebar or what or are they just taking a break?
I think they're just taking their morning break, doing a little stretchy stretch.
Oh my God. I've practiced in 1, 2, 3, now 4 states.
Mm-hmm.
Pro hack in 2 and actually criminal in 2, but and one of them is Kentucky. And they don't believe in bathroom breaks. I'm pretty convinced that it's a requirement to be a judge. You have to have a catheter.
Mm.
Like 12 hours was not uncommon. Straight.
That's hardcore.
Yeah. And I'm like,
I've done long periods as a streamer where I haven't gone to the bathrooms, but yeah,
I just don't get it.
That's hardcore.
Either that or they wear a diaper up there. I don't know.
Mm.
I mean, how do you go 12 hours? No food. You know, it's crazy.
Yeah.
We didn't do that in Alabama. That's no. There was lunch or dinner, as we called it.
The difference between dinner and supper?
Dinner is a larger meal between 11 and 3, and supper would be a lighter meal in the evening.
Okay, there you go.
Yeah.
I grew up in South Carolina, so I understand.
Yeah, I grew up in Augusta and Atlanta, and then moved to Alabama. So my parents are from Alabama.
$20 from Florida Dad. Bama law. First time seeing you in channel via Kurt here. Southern defense idea. Members of jury. Could a woman who can't back out of the driveway could a woman who couldn't back out of the driveway without hitting a vehicle really have the skill to hit a human in reverse? Yeah, lean into the sexism. I'm loving it. Let's go for it.
She could have got lucky. I don't look. I'm probably going to get flack, but all of my clients were guilty of something. Something.
Yeah, probably.
But not always provable. I don't doubt she did it. It wouldn't surprise me in the least. But they can't prove it.
No, they can't.
They've not proven anything other than she can't drive, maybe. Or somebody.
I'm still back to if you can tell me how she can hit him in a disabling way without also causing bruising. If you can say how both those things are true at the same time, that would be a really great start. I'm having a real hard time with that one.
He almost looks like he fell from a pretty good distance, almost. You know, like down something, which would explain the arm abrasions.
Yeah.
Yeah, Lori did go off. That's what I meant. Rose was pointing out. Lori went off on the judge. Wow. Yeah. Talk about disrespectful. Holy moly. I was surprised the judge. Well, I mean, what are you going to do? Hold her in contempt? She's already in freaking prison.
Exactly.
How many life sentences now? Like 5, 4?
Yeah, like the Darryl Brooks thing. I can't really hold him in contempt, so I got to come with other solutions. And then he waived his right to an appellate lawyer, and he wants to go alone. I can't wait to read his brief.
Oh, my favorite are federal pro ses. They're my favorite. Where the prisoner uses like every square inch of paper is used. Like literally, it'll be like front and back, like multiple because they have to. These are those stubby pencils they're writing with, It's but they're interesting.
Yeah.
I don't think they're coming back. I think they're going to lunch.
They fled the jurisdiction. We all want to flee the jurisdiction.
This shit. I'm out of here. This is brutal. Here I am.
Does Aruba have extradition? Maybe she can go back
Aruba.
there.
Jamaica, Bahama. Oh God, I'm old.
We're all old. We're getting older. It's a very sad thing.
Older. I try to say older, not old.
And then the Supreme Court today is also doing oral arguments on this scope of injunctions.
That's
going to be interesting.
Yeah, I don't know how I fall on that because I do like the fact for a district court to be able to go, okay, nobody gets to do squat. We're done. It's because, like with the pistol brace issue,
Mm-hmm.
that affected everyone, millions in every
Mhm.
state. And I think finally I had to join the Gun Owners of America. And even it was one of them that had the injunction just to fall under the injunction because it was only Fifth Circuit. It's just,
Yeah, I mean, all the answers provide problems.
yeah.
It's like every possible answer that I can see provides a problem.
Yeah.
And so it's just like which of these things do you not like the most?
Yeah, as far as the immigration one, the birthright citizenship, I think it's still going to come back to the Art case.
Well, that's certainly going to be a very huge element of the thing. Yeah.
I think the court, I forgot, I counted in the video I did. I think it's like 4 or 5 times they specifically referred to his parents as lawful residents. Lawful. So I think it almost acts like that they were just taking it as, well, this is for granted. They were here lawfully. They left. He didn't.
In Van Ark?
Yeah, Kim Won Ark. Yeah,
Kim on Var. Yeah, that's true. I mean, at the time though, we didn't really have immigration law as such at that point in history.
Till
It was pretty open borders even at that point in history.
Have you ever looked at the immigration certificates prior to 1906?
Not really.
Okay. This is interesting. I was in it when I was in law school. There was a jewelry store down the street, and a family, Dennebergs, owned it. And their great grandfather, it was 1903, but he had his certificate of citizenship. Literally, it said certificate of citizenship, state of Alabama, Mobile County, the circuit court of, and it says Charles Denneberg hereby absolves all allegiance to any prince, king, title, nobility, etc. And it finally had blank, and it wrote in Tsar of Russia. But they were all in. You can pull up many of them. They were all issued. We didn't do that until we gave it up in I think it was 1906, 03 or 06. We gave it up to the feds. So the states, and the 14th Amendment reads that way, that it arises from the state. So you've got to be a citizen of the state and then the federal government.
Well, they're definitely distinct concepts. I mean, the 14th Amendment certainly reflects that.
And so I've never thought that there was birthrights. I mean, even the Art case goes into, well, it doesn't apply to diplomats, doesn't apply to, political people that are here politically. So if it doesn't apply to them because they're not subjecting themselves to the jurisdiction, why would it apply to someone who's coming in and leaving illegally?
Yeah, that's a good question.
It doesn't make sense because you have to subject yourself and be like, I'm here, I'm staying, I'm not going anywhere, I'm legal. My kid's going to be born here. Not like, unfortunately, a lot of the Chinese, they come here literally on a visa for tourism, pregnant, to have a baby.
Yep.
That's a problem.
It is a problem. It's absolutely a problem.
Yeah. And I don't know there's an easy answer. It's not going to please everyone. The easiest answer is Congress, but they're just not going to do it.
Yeah. Good luck.
Is the state calling Proctor this time? They need to.
It looks like the answer is no. It feels like a strategic mistake to me.
I do too, because if I'm the defense, I'm going to call him and keep him up there for 5 days.
Yeah, right. Exactly. Like if you're the state, you can call him. You can get ahead of everything. You gain a little credibility. You soften the blow a little bit.
Mm-hmm.
It's still gonna suck, but it sucks less.
Yeah, you always do that in a trial. You always bring it. That's the first thing, day one. I've even said things. Nobody likes my client. Nobody likes him. He's not a likable dude. But that has nothing to do with whether or not he did something.
The Diddy defense strategy.
Yeah, I mean, the guy just sits there and he's like, it's like a mad ape. It's like, nobody's gonna like you, dude. He's like, I just like this. It's like, well, okay. I mean, you just got to put things out there and explain it to them. The jury understood. So sometimes it works. I don't think they have a choice. I think it's going to come back and bite them in the butt.
Yeah, I think so too. I think so too. And then it's the only question of like, yeah, whether it's like, yeah, I'm going to rehabilitate him on cross. I'm like, okay.
No.
I don't think so.
No, that's like crossing a victim or a victim's mother. I had to cross it was a victim of a rape and a shooting. And she lived, thank God. And yeah, it was just like, thank you. I have no further questions. I'm done. I don't even want her to open her mouth. I mean, I really don't. And so,
Yeah.
you know,
Strategic considerations, man.
yeah, when they did the mother, I was like, oh, that was brilliant. They just, oh, thank you. We're good. What are you going to ask the mom? Nothing.
Yep. It's like when Jackson thought it looked like he was going to get up and cross-examine the parent here of mother of
right.
Keith. I'm like, is he really going to do this? There's no fucking way he's going to do this. Just sit down and shut your fucking face.
Yeah.
Fortunately, that's what he went with. So I stepped off the ledge.
That's what I was the same way. I was like, oh God, don't. Last thing you want her doing is breaking down crying. Nope.
Yeah. But I mean, we kind of understand all the liabilities of the state because they were all present the first time. What we don't really fully understand is testimony from new exciting medical examiner. Who this? We don't have aperture yet and what they're going to say.
Yeah.
And we don't have the dog trainer turned dog bite expert who is going to do his best Cesar Romano impression and say that, that this dog or something didn't do it because he's a dog behavioralist expert. Therefore, he understands something about dog bite wounds. I don't understand how any of that's supposed to work, but okay.
He's going to turn into rehabilitating Eric Cartman,
Yeah.
Taco
So I'm
dealer.
like, yeah. So if I'm the state, I guess my strategy here at this point is to I don't call aperture in my state and chief. I call them in my rebuttal case. Try to end really strong with some really strong sciencey sounding stuff and hope for the best. So aperture is the last witness I call and hope that I can end really strong.
Yeah,
that sounds plausible.
Yeah, if you want my honest opinion, I wouldn't have recharged her.
Well, no. I mean, I'm not sure I would have charged her in the first place, given this bullshit of a case.
Yeah.
This is pretty fucked up.
Yeah. I at first, when I first heard it, I was like, oh, she did it. This is stupid. And then I heard about all of the police malfeasance. I'm like, holy moly.
Pieces of taillight appearing and disappearing, ghostly presences, backwards video, no logs. They have not invented crime of log technology. Who would you give the evidence to? Don't know.
Yeah.
Was a Massachusetts police officer? Yeah. How do you know that?
He had a gun.
How do you know it was? They were wearing a uniform? Did you check to make sure it wasn't rented from Party City?
Yeah. Yeah. It was pretty bad. Especially when they were holding up that dude was holding up the little boxes with the pieces of it.
Yeah. I collected swabs from the cups.
Yeah.
I didn't test them though, but I collected them.
How do you not test and swab the light for DNA? If that's your assumption that his arm, goes up and the light, I guess the tail light hits that, and that's their assumption, there's going to be DNA there. I once had a case where a guy steals a car, goes joyriding, doesn't destroy anything, it gets returned. He left a cigarette butt in the ashtray, actually multiples. They tested the damn cigarette butt.
Wow, what a logical thing to do.
Right. But
what a reasonable and logical thing to do. Amazing.
Or a stolen car. He's like, they'll never do it. I'm like, dude, it don't cost much anymore for a DNA test. They're going to do it. Boom, they did it. He's like, well, they got me. Yeah.
Yep, I'll do it.
It's just not difficult.
Have you been following Koberger at all?
A little bit. I think he's probably the perfect example of a psychopath that you could get.
Yeah.
I don't know the evidence. Fill me in because I've kept up a little bit. But
It's thinner. It's thinner than I would like. So the best piece of evidence is they have the knife sheath of they believe the murder weapon, which has touch DNA of him on the knife clasp, presumably the little button that has DNA. Which the knife sheath was found like on the bed of the victim. I think possibly under the victim, although I won't swear to that detail. but that's like their best piece of evidence. And then after that, it kind of gets a little bit murky. They have Amazon purchases of things that might be used in crime scenes, like masks and stuff like that. That Amazon purchases.
Oh,
They've
Ted
got
Bundy
like
accoutrement.
They've got Ring camera footage of a car that might be his car, but it's like one of 6 model year. So I'm like, okay, that's not as solid as I'd like it to be.
I'd probably
They
just go with the
have
sheath.
they have evidence of him like in the area on his cell phones, but on the night in question, like the cell phone was off or otherwise not reporting.
And those only
You
give
know.
you a specific sector. I mean,
Yeah, and also like so there's a circumstantial case to be made. It's a little thinner than I would like. Someone has suggested there's evidence of him stalking the address. I don't know what evidence there is of him stalking the address. If there's that would be helpful. But
What's the theory
what
why
strikes
he-
me as the most interesting detail to me is apparently there's none of the victim's DNA in his car. That's interesting to me because you're talking about a quadruple knife murder, and apparently a fairly quick one on the time frame.
Well, you'd
right?
be surprised at how little. I guess people don't realize this, but you'd be surprised at how little blood. Because, like I said, I did crime scene work. How little blood will come out on a knife.
Yeah,
you'd be surprised.
Okay.
If they throw it, don't come to Georgia. We're full. If they throw the knife away, there may not be any transfer. It just depends. Depends on how bloody it gets.
Yeah.
A little blood looks like a lot in a crime scene. But from what I gathered, from what I have read, it was pretty bad.
Yeah, I mean, it seems a little sketchier than I would like for the quadruple knife murder with the death penalty, but maybe when you lay everything out, it makes a more convincing case.
Oh, I don't think he'll get death. I'd be shocked. People are too afraid to do it anymore.
For the quadruple knife murder?
Yeah, it wouldn't surprise me. They come out and go life.
Fair.
Now, if he was in the Southeast, probably. Idaho? I don't know. I'm shocked they even had a damn death penalty. Of course, doesn't California still have one legally?
I think technically.
Technically? In fact, I think the governor, actually issued a death warrant, and they executed a dude before he left office. I'm not mistaken. I could be wrong.
Right. So yeah, Koberger should be interesting to follow. It should be interesting to
When's
see
he go
the
to trial?
pictures. Oh, I don't know that it's any time in the immediate future. I think they're stuck in Plims for a while.
Yeah. That's what I would figure.
Probably next year sometime.
This trial may go into next year.
This trial that we're watching?
Yeah. With the way they're going. I mean, somebody has to have said something to the judge at this point. One of the counselors. They had to. I mean, it's every damn in 5 minutes. It's sidebar.
Yeah, sidebar. Yeah. My understanding is Koberger is going to be televised. We will absolutely cover it when it does. Not for least reasons. I'm very interested. I'm very interested to see the case develop because, I think that it's an interesting case.
It is.
And so I'm going in a bit skeptical, but I'm very willing to be convinced. And of course, the state might have evidence that they haven't told me about, which would help a lot too. So that would be nice.
If they're smart, they do, and they're holding back.
Yeah.
But, I don't know.
And maybe it'll be like they'll introduce some things. I'll be like, oh, okay, never mind.
Yeah, he's screwed. He's hosed. Yeah. He's going to get his boots smoked. I think that's what they call it when the prisoners will say, oh, he got his boots smoked because they all wear boots. Yeah.
In prison?
Yeah, for the most part.
Okay.
Yeah.
Right.
Yeah, the county jail, they all have slippers, but you get to prison, it's, yeah. If they get into a fight too, they always have to make sure their boots are laced, so. There's a lot. I always joke with people, I would much rather have an institutionalized convict or anybody who's been out that's a convict, somebody who has served a large amount of time because there's a set of rules and they don't deviate from the rules. One of which, don't lie to your freaking lawyer.
Mm.
Criminals lie to their lawyers constantly, and convicts don't. They'll just flat out tell you, "Hey, just give me a deal. Just give me a deal." And the hardest part, I guess, of being a lawyer is dealing with plea bargains. I hate them because the state should be, if they want to charge you with first-degree murder, you better have enough damn evidence to charge first-degree murder, not to do it to get manslaughter. I hate that because guys will go up, literally take a lesser, and they've not done it. The elements are not satisfied, and they have to go up and, depending on the state, that, if they have to do a colloquy, they've got to lie and say, "Well, I did, this," or my favorite is, "Well, I didn't do it, Judge. But I'm taking the plea," and the judge is like, "No, we're not. No, we're going to trial. You shouldn't have said that." So
Yeah, you have to be guilty, So
yeah, you got to be guilty of defense. So it just sucks because you're put in that bad spot as a lawyer to go, "I need you to lie."
You can't say that to your client.
I know you can't. I know, but you got to tell them and say, if you say, because that's what they're wanting, X. They want X. I want the plea. Well, it doesn't quite fit. If you go in and say, "I didn't do it," or that, you have to. Otherwise, you're in trouble on that too. So it's a no-win situation on them, but not every state's that way. Like some states make you go in and basically tell the story of what happened.
Yeah.
Alabama doesn't. It's
okay.
just, if it's open, voluntary, and etc. Did you do X, Y? Did you first degree murder? Did you blah 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 blah? And they'll read the warrant or the indictment. Yep.
I think I kind of prefer it where they ask the defendant basically to tell the story, basically in your own words, just tell us what happened. I prefer that. It gives a little bit more confidence in the plea, I think.
Yeah, and it destroys a lot of pleas. It destroys a lot of them. I'll be honest, because you'll have guys plead out to stuff like, what was it? Oh God.
But from a legal posture, it should destroy the plea, though. That's the thing, though. It's like but I live in a legal purism land. It's like I want the law to be followed, and it's like, yes. So I want you to get up and tell me what happened, because if you don't meet the elements of the crime, then of course I'm not going to accept the plea. And if you say that you didn't do it, of course I'm not going to accept the plea, because that's the legally correct thing to do.
You are correct. Unfortunately, when you have, say when I left the PD office, when I was at 435, 436 live clients, meaning that it's not like a doctor's office where you see the 1,000 files. You're like, "Oh, wow, this guy's making bank." And he is. But, they don't call every day. You've got tons of calls coming in daily of these people. And you're you're drinking out of a fire hose. That's all you're doing. And so, yeah, it's rough, though, to get those pleas started.
Back to session immediately.
So you wanted to see me?
Immediate sidebar?
Over here?
Yep, immediate sidebar, of course. Let me see those sidebars emojis. You guys knew it was going to happen. Immediate sidebar, not 2 seconds. You guys knew it. Give me those sidebars in chat. 100%. That's the world we live in. I'm banning sidebars in my courtroom. Uh-oh. I'm putting it in the standing rules. No, you cannot have a sidebar. Fuck you.
The next trial I do, I've got one coming. It's a hokey one, contract case in Georgia, and it's I think I was tell the judge before we start, no sidebars, just chew me out. That's fine. Just say no. We don't need sidebars. Let's work it out. And most of this should be done, and I'm guessing they've done motions in limine.
They had lots of motions. Motions were flying. This is definitely not. They were definitely not scared on the motion practice.
That's from what I've gathered. Yeah. So we should give.
This is going to be a mistrial, isn't it? That's what happened. This is going to be a mistrial, and we're doing this all again. What do you guys do in April of 2026? Put it on your calendars.
If this guy was not a cop, I'm just being honest, this trial never happens.
How many times do you think they retry him before they're like, you know what, we're just embarrassed, we can't keep doing this? Do they understand embarrassment?
No,
Okay.
they should because they've already gotten it. But no, I say 3. I say they'll retry her because he was a cop. If he wasn't a cop and he was, I hate to say this, some poor white or black dude, just normal dude.
Why do I think there would be a mistrial? Because it's our fate. That's why I'm thinking. It's our fate.
Yeah.
And we're doomed.
We're gonna suffer. Suffer.
Yeah. I'm sure it'll get third time's a charm, though.
How many Menendez trials wasn't it 2?
Yeah, there was 2. Yes.
Yeah. And of course, they just got resentenced.
Yes.
Oh man, that's a hard one. It's a hard one. I don't think they.
I haven't really dived into it to have an opinion.
I remember it. I was like, what was I, 13 or so? And I've worked cases with similar modes of execution, and I can't get over that part. It's brutal. It's utterly just, it's brutal. But I don't think they're going to be a threat to the society if they were released. I just don't. So I don't know. Maybe 30. Was it 36 years they've been in?
Mm-hmm.
90. Yeah, 89 or 90, somewhere there. Yeah. It's not a long time though for double homicide. I can tell you that. Guys get less though. I will say that.
Yep.
They get far less. You know, I've seen a lot of them that I thought, oh, he should get a death sentence.
The case was in such fucking shambles. The last trial, that like when the defense makes, the ubiquitous motion for, directed verdict at the end of the state's case, I'm like, yeah, I'm really thinking about it. I'm thinking about it pretty hard.
Yeah. Yeah. I've never seen one granted. But
yeah, but it was fucked up. It was pretty fucked.
It's pretty bad. Yeah. I've never seen a cop get fired for dishonoring the agency. What was it exactly he did? Did he mess with the evidence?
Well, he was drinking on the job and then drove a car was one of the counts.
Oh, God.
So he was drinking and then drove his cop car was one of the counts. And then one of the other counts was the text messages, I think, relating to Karen Reed to his boss, basically saying no nudes and she's retarded and leaky balloon nut and some other bullshit along with that. And there was also a third count, which I don't think was related to this case. I think it was related to something else.
Damn. So he ain't gonna be a cop ever again.
No, probably not so much. No.
Yeah, he done. Probably shouldn't, but he was definitely in charge of that. I love how that the Russian dude was up there for like 15 days. I can't think of his name. Russian sounding name. What was this guy's name?
What case you're referring to?
This one. The guy was just testifying.
Oh, the Yuri
Bukaki.
Yeah. That guy.
Yeah, Bukaki. I love how he would never say who was in charge. Like nobody ran the investigation. It was just random.
Yeah, he's just the case officer.
Yeah.
What is the role of the case officer? Basically the lead.
Yeah. I think the CIA calls that, and that's the lead guy. He's your lead field agent. Pretty sure.
It's even more stupid because in the official memo, I think firing him from the head of the police department, whatever his title is, colonel, I believe. They referred to he referred to him as lead detective in the memo. So it's even stupider. It's like the literal head of your department called him the lead detective. I think we could concede the point.
He wasn't gonna do it. He just wasn't gonna do it.
I'm half surprised they're not calling that guy to the stand. That'd be hilarious.
That would be.
Who are you? I'm the head of the Massachusetts State Police. So is this fucked up? Yeah, kind of, sort of, yeah.
Is this guy bad? Yeah, somebody in the chat said if this had been a cop on somebody's lawn, we wouldn't be here. He's all right.
I'm going to give you those. Those were both marked for ID. So one will be coming into evidence and one will be a chalk. So you may need
the chalk.
Have them available for the witness.
And the courtroom setup is just bizarre.
Yeah, it's weird.
Although I've had one where literally the jury was where the defense is, and my back was to the judge, and it was the most like you constantly just like you know, it's like somebody's staring at you the whole time, and they are. It's bizarre.
You consider stand wherever you're more comfortable, doctor, for now.
What are we doing now? We're sitting, we're standing, we're doing a little exercise, we're riding the witch's broom. Nice emojis, by the way, just Rhonda. I'll switch it out just as soon as the witnesses start. I'll switch out these emojis. I appreciate the effort. Thank you. Assuming the witness ever starts, that presupposed that there will be a restarting of the testimony. That was my fault.
Yeah, get your confidence.
And we're talking and we're mulling around. We're having a little caucus time, I guess.
Did you get that email I sent you? I wonder if the Red Sox are going to make the World Series. I don't know. It would not surprise me if that's what they're discussing.
Yeah.
Just shooting the shit. I think people think a lot of the times these people hate each other. They don't. They can. Don't get me wrong. They can. Like Bruce Harvey, who was on the YSL trial. That, yeah, I've had first dealings with. Yeah, that guy. Yeah, he's legit. He will hold a grudge. He's a good attorney. Isn't Jackson a pro hack?
Yes.
Where's he from?
California.
Wow. Wow, that's an expensive trip. Oh my god.
Alessi, and ironically, the juror turned defense lawyer are the only lawyers that are admitted in this state, I believe. Everyone else, I believe, is pro hac.
Holy really?
Yeah.
Huh.
Which is pretty funny.
No, he would not. If somebody was in the chat posting he'll get another job in another district. No. If he gets his certification yanked on the state level, at least that's how it works in Georgia. And
speaking of which, just Rhonda, do you have a picture of Alessi or no? Because I see Yannetti and Jackson. Do we have an Alessi? We got to have an Alessi picture.
Let's see.
Yannetti is a Massachusetts lawyer. Maybe it was, yeah, well, okay. Most of them are not. Most of them are pro hac and doing it for free at this point.
I don't know who's paying the bill. Somebody's going to be paying their freaking hotel bill. I guess they do it for notoriety. That's the only thing I can come up with. Oh, for crying out.
They're doing it for justice.
Oh my God. What the hell is... They just stood up.
This is the exciting parts of trials. This is the good stuff.
This is why you had me, because you're miserable.
That's why I need help. I need company. I need someone to talk to. I can only have so many conversations with the fan.
Oh man. Hey, well, speaking of watches, I did a PT 5000, and I'm telling you, it even had ETA stamp marks.
Okay. Do you make watches too?
Yeah. Yeah. I play
Nice.
with them. Yeah.
All right.
I actually oiled it. If you oil the PT 5000, it's fine.
All right.
If you don't,
Doctor, when we left off, you had described all the injuries to the exterior of Mr. O'Keefe, and we had talked about your observations of both the fractures in his skull and also your observation of Mr. O'Keefe's brain. You mentioned earlier that you use other resources, other testing.
Hello.
Did you ask for any type of assistance on toxicology analysis for Mr. O'Keefe?
Yes, it is routine, and it is protocol to submit toxicology specimens to the lab for examination.
May I approach, Your Honor?
Yes.
No.
Thank you, Mr. Brandon. Doctor, I'm handing you a document. Do you recognize that?
Yes, this is the report of toxicology from the State Police Crime Lab for Mr. O'Keefe's autopsy.
Have you seen that document before?
Yes,
Is that a fair and accurate depiction of the report we saw before?
yes.
Do you want to introduce this as the next exhibit, please?
No objection, Your Honor.
Thank you.
Exhibit 161.
Thank you. I have that in front of me. Thank you very much.
Thank you.
I was amazed at the snowblower technique to unearth.
In your
Thank you.
experience, Doctor, are you familiar what the toxicology report and the testing involves?
I'm sorry, what was your question?
Are you familiar in your experience with what is involved in a toxicology test?
In general terms, yes.
And if you studied Mr. O'Keefe's toxicology report, was that important or part of your analysis in your ultimate conclusions?
It was one piece of evidence that I took into consideration, yes.
Lady, we know he was drunk. Everyone was
In the
drunk.
toxicology testing, is there a search to see if there are any type of drugs or medications in Mr. O'Keefe's blood?
Yes.
Okay, and was there any?
There were no prescription medications, there were no illicit drugs in his system.
In a toxicology, is there also a testing for blood alcohol content?
Yes.
What is the difference between ethanol in heart blood and ethanol under 1102?
In vitreous humor?
Yes.
So we usually submit multiple specimens for toxicology. Some of the specimens are used for screening of classes of different drugs, and then other specimens are used to confirm, the presence and quantify a particular drug. So in this particular case, the lab tested the heart blood, which showed that it had an ethanol level of 0.21 grams per deciliter. And they also tested the vitreous, which is the fluid that sits behind the eyeball. And in that specimen, the ethanol was slightly higher at 0.28.
Thank you, doctor.
All right.
It's getting up there.
Yeah.
After your autopsy and observations of Mr. O'Keefe's body, inevitably, did you come to a conclusion
Inevitably.
about the manner and cause of Mr. O'Keefe's death? And I'll ask you first about the cause. To a reasonable degree of medical certainty, did you reach a conclusion about the cause of Mr. O'Keefe's death?
Yes, the cause of death was determined to be blunt impact injuries of head and hypothermia.
I knew it.
You
So he died
mentioned two
mostly of
different
hypo.
things, blunt impact and hypothermia. Was
Correct.
there a primary cause of death in your opinion?
The blunt impact injuries of head.
Hypothermia, was that sufficient to be a primary cause of death, in your opinion?
In the absence of head trauma, hypothermia is a cause of death, but I'm not able to make that determination in this case because we do have the blunt impact injuries of head.
So if I understand, you are not saying to a reasonable degree of medical certainty that hypothermia was the cause of death?
Not the primary. It contributed, but the primary cause of death was blunt impact injuries of head.
Did you learn what Mr. O'Keefe's body temperature was when he was brought to the hospital?
Yes, some of the medical records stated that his body temperature was 80.1, I believe, degrees Fahrenheit,
Oh, he had been dead.
And what is a normal body temperature?
98.6.
Thanks.
What's the temperature of a dead guy?
Regarding the blunt force injuries as the cause of death to Mr. O'Keefe, at some point when you were conducting your autopsy, or even at the end when you drew your conclusions, were you able to reach a conclusion as to the manner of Mr. O'Keefe's death to a reasonable degree of medical certainty?
No, I was not.
After you complete your findings, including the manner of death and the cause of death, even if undetermined, are you required by statute, by law, to file a report or a document?
Yes,
And what is that document?
it's the death certificate.
Did you do so in this case?
Yes,
When you file a death certificate, do you include your ultimate conclusions regarding cause and manner of death?
yes. There is a death certificate that is issued immediately after the autopsy. The death certificate is a document that is necessary for the family in order to make funeral arrangements and proceed with their plans. So a death certificate is always issued at the end of the autopsy. If the cause and manner of death are known at that point, they are stated on the death certificate. If they are not, or if we need to do additional studies, then both the cause and the manner are listed as pending. And that death certificate is sufficient for the family to make arrangements. Later, as we get more information, as we get more results from our studies back, we issue an amended death certificate. So that amended death certificate will have a cause and a manner. The amended death certificate, in this case, stated that the cause was blunt impact injuries of head and hypothermia, and the manner was undetermined.
May I approach, Your Honor?
Yes.
Doctor, I'm handing you a document. Do you recognize that document?
Yes,
And what is it?
this is the final or amended death certificate for Mr. O'Keefe, stating that the cause of death is blunt impact injuries of head and hypothermia, and that the manner of death could not be determined.
Do you recognize that document as accurate?
Yes.
Your Honor, move this into evidence, please.
No objection, Your Honor.
All right, thank you.
Well, we finally have proof he's dead, so that's good.
162.
Took long enough.
After issuing the death certificate and after the 90 days passed, have you done any further study or investigation on this case, doctor?
No.
Thank you. I have no further questions.
Mr. Leslie?
Did she say propanolol?
Something like that.
That's a blood pressure medicine.
Mm-hmm.
Okay.
May I,
somebody-
Your Honor?
Yes.
There we go.
We have not had the pleasure of meeting, so good morning, Dr. Scordi-Bello.
Good morning.
With regard to cause of death as opposed to manner of death, Is it correct that a forensic pathologist is tasked with determining that cause of death that includes contributing factors, injuries, and circumstances regarding the medico-legal death investigation? Is that a fair statement?
Yes.
And I'm using the term medico-legal. Is that a term that you're familiar with?
Yes.
And is it correct that medico-legal means, particularly for medical examiners, that there's a medical aspect to the investigation that you perform, and there's also a legal aspect or a law enforcement aspect to it? Is that correct?
Correct.
And that's a little different than what physicians usually do, right? Because isn't it the ordinary course that it's mostly just medical, but medical examiners by statute and law need to have both of those prongs taken into consideration? Do I have that right?
Yes.
So, in other words, the forensic pathologist, which you've indicated you are, is tasked with determining the cause of death, which answers the question as to why, in more layman's terms, why did the individual's body stop functioning at a particular time, correct?
Yes.
So more broadly, the cause of death is generally defined as the disease or the injury that resulted in the death of a person.
Correct.
So let's now, if we could please, move to the manner of death. And I'd like to summarize, I know you covered it on direct, but I want to put it in a slightly different context, and hopefully I'll get it right. So medical examiners, as you've stated, are also tasked with, if they can, determining the manner of death or the circumstances under which the death occurred, correct?
Correct.
So manner can and does involve the circumstances under which the death occurred.
Yes.
And that causes one to go the medical examiner to go beyond just medical analysis. You take into consideration other factors which we'll get to. Is that correct?
Yes.
So you talked about, and I'm just going to go through them quickly, but if you could just check me on this, the 5 main categories of manner of death. So you talked about natural causes, correct?
Yes.
You talked about accident.
Correct.
You talked about suicide. You talked about homicide. And then the last category, undetermined. Do I have that correct?
Yes, you do.
So what I'd like to do is to focus on the undetermined category. And my understanding is, Doctor, that that's where you landed, that's where you concluded with regard to manner of death of Mr. O'Keefe, correct?
Correct.
So undetermined is a term that is used and that you use, and does that mean that when the information pointing to one manner is not more compelling than other reasonable possibilities, or the death investigation lacks sufficient information to opine on a manner of death, at the time of death, the certificate is signed? Is that generally correct?
Yes.
So, as we've talked about, I'm just trying to follow or just develop some logic and see if this is in agreement with you, that as a medical examiner, you're specifically tasked with conducting that medical legal investigation, and what we've just talked about is a bit of the method of analysis that you go through for that, correct?
I conduct the autopsy, and I request information information from the investigative body that is out there investigating the other aspect of the case, not the body itself.
Yes. So, is it correct that there's 4 general components to a forensic pathologist death investigation? Is scene investigation one of the components?
It depends on the jurisdiction where you practice. Scene investigation is part of forensic pathology in certain jurisdictions, and it is the responsibility of the district attorney and law enforcement in other jurisdictions. In the state of Massachusetts, we are responsible for the autopsy, and the DA's office and law enforcement are responsible for the scene investigation.
Excellent. So scene investigation in the state of Massachusetts is not within your domain in the office of the medical examiner. That is the domain of the district attorney in law enforcement, correct?
Correct.
Yes,
How
she's
about
just dead body lady.
another aspect, forensic autopsy and laboratory testing? That's within your domain, correct?
Correct.
And how about police reports and witness statements?
That is not under my jurisdiction. That is under the district attorney's office and the police.
Do you consider information, nonetheless, from police reports and witness statements in your analysis?
Yes.
And do you also consider, even though it's not within your jurisdiction in Massachusetts, do you also consider information about scene investigation?
Yes.
So it's correct then that you consider, whether it's within your jurisdiction or not, you consider scene investigation and police reports and medical statements, correct?
Yes.
And then forensic autopsy and laboratory testing is right within your jurisdiction, and therefore, of course, you consider that. And then lastly, medical history and hospital records, is it, therefore, am I correct that that's something within your jurisdiction and that you consider in performing your forensic pathologist death investigation?
Yes.
So now let's move on to the application of those principles. So in order to conduct a proper medical legal investigation, the medical examiner has to have certain qualities, if you will. Is one of them being well-grounded in general medical knowledge?
Yes.
Is another appropriate training and experience in forensic pathology?
Yes.
In other words, you wouldn't want a specialist, for example, in cardiology without anything more to be conducting a death investigation. Is that correct?
I would not want them to be conducting an autopsy, correct?
Right. Would you want a neurologist to conduct a death investigation?
Personally, or are you asking me that? No, I don't
Not a good
think
idea.
every physician has their specialty and their training. And forensic pathologists are trained to perform autopsies, and cardiac surgeons are trained to perform cardiac surgery.
Would you want a neurosurgeon
A giant
to be
dump on
conducting a death investigation?
To be performing an autopsy? No.
So you wouldn't want a neurosurgeon to perform an autopsy?
No.
Because you don't believe they're qualified to do so, correct?
I don't believe they've had the appropriate training to perform an autopsy.
Going back into the many qualities of a medical examiner and attributes, they also have to have the ability to form opinions based upon all the available information using the scientific method along with sound reasoning. Is that a fair statement?
Yes.
And you're familiar with the term scientific method?
Yes.
And is it fair to say that the scientific method generally is sort of a systematic pursuit of knowledge that involves recognition and definition of a problem? Is that fair?
Yes.
Is it also involved the collection of data through observation and experimentation where appropriate?
Correct.
Does the scientific method also include the analysis of data?
Yes.
Does the scientific method also include the formulation, evaluation, and testing of hypotheses?
Yes.
And does it also, where possible, include the selection of a final hypothesis after considering other hypotheses?
Correct.
So what we've just discussed is a fair explication, a fair explanation of the scientific method.
Correct.
And the scientific method is part of the autopsy and forensic pathology analysis, correct?
Correct.
Now, applying one concept, that medical legal concept we talked about, just holding for a moment, if you could, the medical and going to the legal, if you will, law enforcement that you said in Massachusetts is not under your jurisdiction, but nonetheless you consider information arising from it.
Yes.
Are you familiar with a person named Michael Proctor? Is that name familiar to you?
Yes, it is.
And at one time, Michael
And the
Proctor
shitting
was
begins.
a trooper, correct?
Correct.
And so, did former Trooper Proctor inform you of the working law enforcement theory at the time of the investigation of this matter, namely his working theory, a collision of a motor vehicle with a pedestrian? Did he inform you of that?
Of course.
He informed our office of that, yes.
He informed your office. And is it fair to say that he informed your office or provided that information to your office in or about February of 2022?
That information, part of that information was provided to our office at the time of the autopsy. One of the pieces of information that had come in, and there were multiple sources calling into our office, providing information, was that this was a possible person struck by a motor vehicle.
And the time of the autopsy, if I have it correctly, was that around the end of January of 2022?
The autopsy was January 31st.
Your Honor, if I could, with your permission, please publish a photograph which Your Honor has and the parties have stipulated, or that's in evidence. And this is the one. May I approach, Your Honor?
Yes.
May I show that to the witness?
Okay. All right, so we will mark this as the next exhibit. There's no objections to Brendan?
No objection.
Okay, so we'll mark it first and then you can display it.
Thank you, Your Honor.
Exhibit 163.
Thank you. May I, Your Honor?
Yes.
Thank you. Dr. Scordi-Bello, if I could hand that to you, please. You could take a look at it, and when you've had a fair opportunity to look at it, if you could just look back up, and I'll proceed at that time.
Yes, I recognize the picture. Well, I've never seen this picture before, but I know what it's depicting.
Thank you.
Recognize it. I've never seen it. That's
What
good.
is depicted in that picture?
It's a picture of two individuals standing in a morgue setting, which looks very similar to our morgue at the Cape Cod office.
Very good. If you could just hold that for a moment, and with the court's permission, could I publish that for the jury?
Okay.
Thank you. Mr. Wolf? And if you could please zoom in on the two individuals in that picture. Dr. Scordi-Bello, do you recognize any of the individuals in that picture?
To be perfectly honest, no, I don't.
With regard to the person on the right, do you recognize that person?
No, I don't.
And you said you recognize the setting, correct?
Yes,
And you, if I heard you correctly, you said this is the Cape Cod facility?
it appears to be, correct.
Right. So you testified earlier, if I recall correctly, that the autopsy was performed at the Cape Cod facility of the Office of the Chief Medical Examiner?
Yes, it was.
And you're normally in, as I recall, the Westfield, in an office that covers Western Massachusetts and Westfield?
Correct.
But you were at the Cape Cod facility, as I understand it, because there was a staff shortage and you had to travel down to Cape Cod for this. Is this correct?
Correct.
So you weren't at your normal home base sort of facility. This is a facility that you went to for this autopsy, correct?
For this autopsy and multiple others, yes.
Yes. And you were covering a staff shortage, and that was the reason you went to Cape Cod, correct?
Correct.
And what's depicted in this picture are two individuals. For two individuals to be present, is there a protocol that they had to follow to be present for that? Like a sign-in or an authorization?
Yes, there is a sign-in sheet that individuals have to put their name and their shield number and before they can come into the autopsy room.
So they have to put a shield number down, correct? You mentioned a shield number.
Yes,
And does that therefore mean that even though you don't know who they are, that they are with law enforcement? Are you able to determine that?
correct. I believe they were with law enforcement.
So those two individuals were with law enforcement, but you don't know who
I
they
don't-
are
I
specifically.
don't know who they are specifically and what their actual position was.
But they were with law enforcement.
I believe, if my memory serves me right, there was a person from crime scene investigation and someone from state police.
Thank
But I'm working on a 2+ year memory.
Fair, that's fair, that's fair. I'm not going to ask you more questions to probe the memory. We can take that down. And, yeah, we are finished with that. If you could hand that to the, thank you. Now, we were speaking about former
Guys
Trooper
like 'em.
Proctor. Do you recall former Trooper Proctor sending you a copy
And here we
of
go.
scene photographs and wanting to schedule a phone call with
Here we
you
go.
so that he could explain the status of his investigation? Do you recall that?
Yes,
And that occurred
He's the lead.
approximately in March of 2022?
yes, approximately.
Right, and the method of communication of that was that by email, to the best of your recollection?
I requested that our medical legal investigator, we have our own investigators at the office that are responsible for obtaining medical records and sometimes being the liaison between us and law enforcement to get reports. I requested that she contact whoever was in charge of the investigation and set up a meeting, a phone call. So since it had already been a few weeks since the autopsy, I wanted to make sure that if there was any additional information that could be provided to me, I could take it into account because I had 90 days to issue a report and a death certificate on this case.
Now, you've mentioned the 90 days on direct, you just mentioned it now. Is the 90 days a hard and fast rule, or is it just something you aspire to as a matter of good practices?
It's not a hard and fast rule. It's something that as an office, we try to achieve. Again, the reason being that there are
Yes, we're on cross.
family members, next of
Somebody
kin
asked
that
which one.
are waiting for these reports and these death certificates for various reasons. So is it possible to go over the 90 days? Absolutely, if necessary. But we do try to finish our part in those 90 days.
So it's possible to go past the 90 days, but there would, given the considerations you just articulated, there'd have to be a pretty good reason why you'd want to do that, right?
Correct.
And in this situation, you concluded that you had sufficient information on the medical side and the legal side to come to the conclusions that you needed to come to. Is that fair?
Well, I had sufficient information on the medical side because I did the autopsy and I had those findings. I did not have sufficient information that pointed to one manner of death over another manner of death. And therefore, I stated that the manner of death was undetermined.
Exactly. So the manner of death is undetermined, and I want to, if I could with you, pursue that a little bit in a moment. But when you came toward the end of that 90-day period, you had information from the law enforcement side on their theory of what had happened, correct?
Correct.
So what's the
I'll
ground?
let that one stand.
Jesus
Are you
Christ.
You
Yes, I
had
guess.
performed all of the medical investigation and analysis that you needed to perform, is
Like
that correct?
foundation.
Yes.
There wasn't something more that you wanted to do on the medical side? You had mentioned, to be fair, you had Dr. Stonebridge involved as well. You had what you needed on that side, correct?
Yes.
And you therefore concluded on the manner of death that there was a not more compelling or more likely than other reasonable possibilities. Is that fair?
Yes.
So in furtherance of that, on April 14th of 2022, you issued a death certificate, correct?
Yes.
And please feel free to check your report of any dates or any other particular as I go through.
Okay.
Okay. I think he's going to try to.
I issued my final report on April
Yeah.
14th, correct, and I would assume that the death certificate
Proctor was
was
pushing her
on
to
or
do it.
around that same day.
Yeah, that's definitely where he's going.
Yeah, that's definitely where
That's
he's
definitely
headed.
part of the theory of the case for 100%.
Now, to back up a little bit with regard to the autopsy, as you stated, it was conducted, I just want to do a little bit of a timeline, on January
like this dude,
31st of
Leslie. Is that his name?
2022.
I
correct?
really like him too.
Yes.
Yeah.
And
He's a lot more controlled.
we
Yeah.
Jackson
discussed
sometimes I
that
think goes
the
too hard.
body of Mr. O'Keefe
Yeah, I
was
tend to be real polite.
presented to the Cape Cod location,
Guy's real
correct?
polite.
Yes.
And you
Tactical.
also discussed that
Kill him
you
with kindness.
brought Dr. Stonebridge to work with you on this matter, correct?
She didn't physically come to the office. The way Dr. Stonebridge was involved is at the time of autopsy, when the brain was removed, having seen that there were injuries, I saved the brain in a special solution, and then the brain was transported to our facility in Boston. That's where Dr. Stonebridge examines the specimens. And after examining the brain, she issued a report.
Who asked Dr. Stonebridge to become involved in the matter?
I did.
And Dr. Stonebridge is triple board certified, correct?
Correct.
She's a forensic pathologist, correct?
Yes.
That means she's achieved board certification in forensic pathology like you?
Do you know that?
I do.
I'll allow that.
Yes, she is board certified in forensic pathology.
And she is board certified in general pathology, correct?
Yes.
And she's board certified in neuropathology, correct?
Correct.
Can you briefly describe to the jury what neuropathology is?
Neuropathology is a subset or specific additional training in forensic pathology where the person spends a considerable amount of time, usually 1 to 2 years, examining brains. And learning all about the diseases of the brain as well as trauma to the brain.
Now, you asked her to be involved, as you indicated earlier, correct?
That
Yes.
person should have done the autopsy instead
And-
of her.
You determined that she should be involved because there was a brain injury, correct?
There was trauma to the brain, correct?
Trauma to the brain. Is it a fair characterization that Dr. Stonebridge is sort of the brains of the brain area of autopsy? Is that fair?
Sustain the objection.
That was too
Yeah.
cute by half.
So,
That was a good one.
with regard to Dr.
She still sustained the
Stonebridge,
objection.
would you agree that she's really
I
uniquely
sustain that
qualified in
objection.
some ways? Or,
That's too cute.
How would
That's
you
too
describe
cute.
her
No.
qualifications, Dr.
It
Stonebridge?
was too good. You got to let it go.
With regard to Dr. Stonebridge, what did she do?
I'm going to
Here we
see
go
you at
again, another one.
sidebar.
Sidebar!
There we go. Oh my God! It really was. Are you kidding me?
No, of course I'm not kidding you. No,
Oh my
sidebar.
God!
No, we don't kid about sidebars around here. First of all,
Jesus
I would
Christ.
like to say thank you to everyone who's here. We passed 147,000 subs while we were,
Awesome.
listening to the stupid. So I want to thank you all for joining me and being part of the stupid. You being part of the pile of the stupid as the uncivilians is, you
Oh.
can say you're proud members of the pile of the stupid. That's what we're over here doing. So we
Congrats.
appreciate the 147,000 of you who are here. Also, for those of you who haven't noticed, we have some new emojis now. We have some wonderful emojis relating to the defense lawyers and chalks and all kinds of things. So the emojis are being updated. I want to see those emojis in chat. More emojis. More emojis. Give me more emojis. And of course, we can't let go of the fact that we do have some wonderful merch items for you, including some wonderful glasses for your sidebar, because you need to have your own sidebar glasses. We've got these wonderful sidebar drink, whiskey, and wine glasses, and also coffee mug. So you can have your choice of these items. We got this wonderful sidebar drink whiskey glass.
Ooh.
Look at that beautiful wine, that beautiful sidebar drink, man. Wow. All your whiskeys will instantly taste better by this glass. And of course, we have Bev's sidebar drink wine glass. You can use it for wine. You can use it for sangria. You can use it for margaritas. You can use it for a little mimosa in the morning. Whatever you want to do. You got so many wonderful options for you. Please pick up your sidebar drink merch that we've got, along with, the coffee mug and the shirts and the stickers. And of course, Yuri Bukaki's lunchbox, comprising crowns as stickers. So we got that for you as an option. And of course, Spinny Fan, the only fan, stickers, mugs, and hoodies. Because we stan only fan. It is by far and away the most reliable thing in this trial. It's not even close.
Yeah. And there it is. I got to get the
thank you for the people who helped to create the merch. Jinx created a lot of those merch items. Thank you so much. And thank you as well to Rhonda, who made those beautiful emojis for the defense lawyers. That they were awesome. Appreciate it. Thank you. You guys make it fun.
I didn't know you had merch. That's awesome.
We do have merch. And of course, perhaps the best merch is the classic, which I will share with you once I find the right screen. Too many screens.
The greatest merch.
The greatest merch of all the times. Greatest merch all the time. But the best merch is, of course, your choice of Evidence Solo Cup Clear.
Yes. That's it.
And also, we have the You Are Muted, You Are Unmuted coffee mug. See, it's got two sides, so you can just twist it at your desk and let people know when to shut the fuck up. It's great. And then, of course, we've got Evidence Solo Cup in glass, 100% glass tribute evidence cup for all your evidence collections need, property of Canton PD. But it can be yours for a low price of $19.95. Buy it today.
I'm going to have to go get the coffee mug.
You know you want it.
Yep. Oh, here we go.
May I?
I appreciate you having me, by the way. Thank you.
Dr. Scorti-Bello, have you, are you aware of an attorney name, or excuse me, a doctor named Azik Wolf?
No, I'm not.
Now I'd like to move on to another category. Based on the information that was presented to you as part of your examination and analysis, is it correct that you presume that because Mr. O'Keefe's body was found in the snow and his body temperature was 80 degrees, that he died from hypothermia as one of the causes?
I reached that conclusion after performing the autopsy and after seeing some findings that were consistent with hypothermia and then combined with the information that was provided to me about Mr. O'Keefe's body being found in the snow, I came to the conclusion that was one of the things that contributed.
Did you consider whether there may have been other reasons as to why his body reached that temperature of 80 degrees? sort of applying the scientific method and seeing if there were other reasons?
Other than being out in the
Dead?
snow? No, I do not.
Do you know whether there are other alternative reasons how his body could reach the temperature of 80 degrees?
People can become hypothermic for other reasons such as sepsis, but in this particular case, I didn't have any reason to believe that that was part of the circumstances.
You're familiar with the medical phrase differential diagnosis, correct?
Yes,
And a differential diagnosis is a term that's used by doctors to pursue other potential causes of a medical injury. Is that a fair general statement?
yes,
So, for example, if somebody is having difficulty breathing, a doctor may say, I think it's the heart is their primary hypothesis, but they may want to differentially diagnose this and look at the lungs. Is that an example of a differential diagnosis that let's look at the lungs to see if that may be the problem? Is that a good, fair example?
in the example you're giving, yes.
So, applying that concept, and do you believe the concept of, well, applying that concept to this situation, did you perform a differential diagnosis as to the cause of the death and question whether there was hypothermia as any cause of the death of the decedent? Did you make that analysis?
I looked at the anatomic findings that I had at the time of autopsy, the information that was provided to me based on the circumstances and where the body was found, and I came to the conclusion that there were hypothermic changes in Mr. O'Keefe's body.
So, you just used the phrase hypothermic changes. Did I hear that correctly?
Yes,
Can there be hypothermic changes without a cause of death being hypothermia?
Sure.
yes, of course.
So, you can have signs in the body of hypothermia, but you can also conclude that a cause of death is not from hypothermia, correct?
If the person is deceased and I am examining the body and there are multiple
With the person's not deceased and you're examining the body.
things that I believe contribute
How
to
about
the
that?
death, then I tend to include all of them. Meaning that if this was a drug intoxication
Yeah,
and the
contributing
body
factor.
also showed signs of hypothermia, I would include both of them on the death certificate because there is no scientific way of teasing out whether
Yes.
it was just one or the other or both. In this particular case, I had two processes that were going
she's
on.
really trying
One
to-
was the head trauma,
Say it.
and the other
Wait,
one were these hypothermic changes.
Yeah.
I put all that together, and again,
She's having a hard time with this answer.
included or took into account the investigative information of where the body was found, what the temperature was when the body was found,
gave you that
whether
info?
the person was still alive or not, and I came to the
I
conclusion
have a
that
feeling his
the
last
cause
name's
of death was blunt
proctologist.
impact injuries of head, and I included the hypothermia because I saw during the autopsy that there were changes consistent with hypothermia.
So I want to break that down a little bit if I could with you. So you testified on direct, and I think you alluded to it here, that the primary cause of death, use that phraseology on direct, was blunt force injury. Is that correct?
Blunt impact injuries to the head, yes,
Blunt impact injuries to the head, and that's the primary cause, right?
correct.
And then there's, and I'm not clear on what you refer to on direct as a secondary cause of of death of hypothermia, but you've used a little different phrase in some of your answers, and I want to make sure I got it right. Hypothermic considerations, can you repeat what it was?
I said hypothermic changes.
Hypothermic changes, and we agree that you can have hypothermic changes without a conclusion of hypothermia, correct?
No, hypothermic changes are what I'm referring to are actual things that I can see in the organs that are consistent with hypothermia. They're anatomic findings. They're things I can see with my eyes.
So you can, I'm sorry, did you finish?
And those changes suggest and are consistent with someone being hypothermic.
Okay.
As you sit here now, with regard to, you used the phraseology consistent with hypothermia, signs of hypothermia, that's what I want to pursue just a little bit with regard to
They
further
obviously
information.
hypothermia be the cause, I suppose.
We got started on this by asking whether you used the concept of differential diagnosis and hypotheses to determine the cause and manner of death. And you said in one of your answers that you relied upon law enforcement information, correct? Is that
Yes.
part of it? It was, you brought that up, you're the one who said you relied upon that, correct?
Yes.
And you've brought that up on your direct testimony and earlier in the cross. Is that correct, that you relied upon the investigation of law enforcement? So,
Sustained.
so now what I'd like to do is to ask you whether, using the concepts of differential diagnosis, scientific method, did you consider whether Mr. O'Keefe could have died somewhere other than where the body was found and
Fair
been
question.
moved and placed in the snow? Did you consider that?
Sustained.
May we approach, Your Honor?
How's that an improper question?
Approaching a bit.
It's not
Thank you.
improper.
Yeah, like how can you do that?
What, if any, alternative diagnoses did you apply to Mr. O'Keefe?
I thought they were doing a
I
sidebar.
don't understand your question.
What alternative scenarios did you look at, if any, for the cause or manner of death of Mr. O'Keefe?
I'll allow
How's
that.
this? Yeah, how's this? This sounds like. Did you?
At the time of the autopsy, I documented injuries and signs of hypothermia. I was provided with a set of circumstances,
Biased, Bev.
and
Like
at
that.
the end of the investigation, or at the end of, my timeline, I concluded on the cause, but I did not conclude, or I did not determine a manner. The manner would be the circumstances you are speaking about, whether I considered other causes or circumstances. That's not how it works. I don't come up with
Well, then tell
hypothetical
us.
scenarios on how those injuries occur. I try to state the
fuck is she
injuries,
saying?
describe the
Double talking
injuries,
jive.
state the cause of death and why that person died. And then I use all kinds of other investigative information that is provided to me to determine
By
if
Proctor.
I have enough
God, she's
to
like afraid to say
make a
anything. She's gonna say it
determination on the
wrong.
manner.
Did anyone provide to you any alternatives as to the finding of the body of Mr. O'Keefe in the snow?
Personally, to me, no.
Did you ask for any alternatives to the nature and location of the injury or death of Mr. O'Keefe?
I asked for all the information that was available.
Understood, but my question is, did you ask for any alternatives to the information that was provided to you as regards the location of the injuries? Did anyone provide you any alternatives to where the injuries could have occurred?
No.
So,
I'm going to let the
Asked and
answer
answered, I
stand.
think
So
he
the
said.
answer is no, so there's no evidence of
Yeah.
that. So next question.
so you talked about the information you had at the time. What time is that?
The information at the time was a preliminary police report and verbal communications
And
regarding the circumstances of how Mr. O'Keefe's body was found.
And when I asked about the time, I'm not calendar time. Was this January, February, March, April of 2022?
The preliminary police report was on the day of the autopsy, and then information, I don't remember exactly how long, but in the weeks following, information was, coming in.
Do you have the ability to amend a death certificate?
Yes, I do.
And you can amend a certificate if you obtain further information with regard to the circumstances surrounding the death. Is that correct?
That's correct.
In your previous answers, you were talking about the information you had at the time. And I'm concluding that the latest that would be is April of 2022. Is that correct?
Correct.
Have you obtained or been provided with further information? In other words, information
bet you have.
after
Yeah.
April of 2022?
She's under a lot of stress.
Regarding the cause or manner of death.
What do you mean, have I been provided?
She keeps closing her eyes for long
Has
periods to come up with.
someone
She's having to think.
physically
Instead of just answering, she's having
provided
to think of it.
me with a report on different circumstances?
Well, what I'm just talking about is any other
May just be her,
information that
though.
you have received and therefore considered.
I think it's a little bit her, to be
in terms of
honest.
The analysis with regard to the
May
cause
be.
or manner of death.
Received in what way?
Here's what I'll do. I'll be a little more specific.
Omnisciently,
Um,
telepathically.
What I want to do is to get at the head injury of the decedent, okay? Is it fair to
Did the
say
crime
that
scene
the
talk to you?
head
I hear that's
injury,
popular.
you called it a traumatic, state what you phrased that as, because I want to use your phraseology.
Blunt impact injuries of the head.
So blunt impact injuries of the head. Is it fair to say that that was a very severe?
Yeah, but which
injury?
killed him first?
It was a severe injury, correct?
And would Mr. O'Keefe had been rendered unconscious nearly instantaneously with death following shortly thereafter?
It's very possible, yes.
Is it more than possible? Is it probable that that's what would have occurred?
I can't tell you how quickly he would have been rendered unconscious, but at some point after that injury, yes, he would have been rendered unconscious.
Is it possible he could have been rendered unconscious immediately?
So she's answered it this way. I think you need another person for that. Let's move on from that, Mr. Lessie.
You made your own determination of the cause of death, correct?
Yes, that's my job.
Understood.
Hypothetically.
And what I want to do is to pursue the basis of your determination. So You used the phrase brain impact injury,
Blunt impact.
a blunt impact injury. Have I got that correct?
Blunt impact injuries of head, yes.
Of head, right. And that's your conclusion, correct?
Yes.
Based upon your conclusion, did you make any determination as to whether the decedent would be able to carry out any purposeful movement after that injury?
Define purposeful movement.
Sure. I'm talking about
Drag
the ability
himself,
to
maybe?
perhaps manipulate their hands.
I don't know.
Did you make any determination
smart.
as to whether they would be able to engage in any cognitive functions, meaning processing things and making decisions?
I did not make that determination, no.
Did you observe any pattern to the injuries to the head of the decedent?
A pattern? I observed that there were injuries to the back of the head as well as other internal injuries to the base of the skull, as well as the brain.
Your Honor, if we could please publish, I'm just going to check to make sure they're in.
These definitely don't sound like injuries from just backing into
If we could, Your
someone.
Honor, publish 160 that is in evidence. But before we do, Mr. Wolf, I would like to approach Your Honor and let you know in case there's anything further
Okay.
that needs to be done. Thank you.
Is there, did you show it to Mr. Brown?
It's already been agreed to as in evidence. and it
Okay.
is in evidence.
Oh, it's in evidence?
Yeah, I just wanted to make sure if there was any statements that Your Honor wanted to make. And if not,
So why don't you come over here because, why don't you come over to side?
Sidebar.
Sidebar. Sidebar.
Sidebar is best bar, baby.
I'll
Don't
open
hate
a
it.
I'm gonna open a club called Sidebar. That's what I need to do.
With an R or an H, though. That's the
Oh,
real
an
question.
H. No, it'd be a sidebar. Yeah.
Yeah, exactly.
Yeah, it'd
Yeah,
have to be an
100%.
H. Yeah. Do it in like Podunk, Alabama, where what?
Yeah.
It'd probably go over pretty well.
Yeah, there's possibilities. Cheat on your regular bar with sidebar.
Don't take the real bar. Just don't pass the sidebar.
Yeah, that's
Forget the
right.
regular bar.
Yeah, qualifies you to practice law in some jurisdictions.
Yeah. Oh God! I still wait for the knock at the door of the postman. And be like, a letter from the Alabama bar. Be like, we're so sorry. You really didn't pass the bar exam. Do you ever have
Yeah.
those worries?
No, not really. But
Yeah.
I used to have a nightmare every once in a while. I haven't had in a while that I didn't graduate high school, and somehow it was coming back to like undermine my entire college degrees and stuff.
All right, that's weird. That's a bad one.
And it's like
Damn.
go all the way back to OG. Like, yeah.
Shit, that would be rough. That would be
Yeah.
brutal. Oh, that would be brutal.
Well, I guess it was even more interesting because in Virginia, at least at the time, they didn't tell you your score if you passed. So I was like, I didn't know. Like,
I didn't
how well
either.
I did.
Yeah, Alabama
Yeah.
don't either. I had to order it. Yeah. We did the UBE, and I got in, and they give a man. I shit myself literally. They had added like 11 subjects, including banking and finance. I'm like, that wasn't even in the study guide. Luckily, nothing was on there that was outside of it. But wow, I was like, this is stupid. Total
Banking
waste
and
of time.
finance.
Yeah, banking and finance law. I was like, that's not a thing. Like, that's not.
Are we talking like UCC, like one of the less, like
No.
UCC 9 or something like that?
No, it didn't, and at least it didn't specify.
Okay.
So maybe that was their. Maybe that was their point. I'll never forget that. I was looking at stuff going in the hotel, going, "Oh my god, oh my god." Oh, in Elba. Opened it up in Elba, Alabama. Oh, yeah. I won't be far from that. A few days.
I'll come to the great state of Alabama, work a case with you sometime.
Yeah, it'd be great. It'd be fun.
Your Honor, this is bullshit.
Yeah, I have said that, but I knew the judge fairly well. Actually, I had a judge once that said this is bullshit on the bench. He was in the process. I think he retired like a few years later, but it was funny because it was as soon as he said it, he was like, "Oh." We all laughed, thought it was funny.
This judge apparently called someone an asshole under her breath the other day. Unclear who she was.
Did she
referring to.
really?
Yeah, apparently. On context, we're thinking one of the defense lawyers she was calling an asshole.
Shit, it happens.
Mm-hmm.
I don't take offense.
You're the one that's creating these rules, Bev, by the way. If you don't want as many sidebars, just like you could do it differently. You can change your mind. There are other ways.
Yeah.
How about you state the basis of your objection from the bench?
Oh, Rose. Yeah, Gunnersville is great. I actually practice in Marshall County. I actually know Steve Marshall. He was the prosecutor in Marshall County, and he's now the AG of the state.
There you go.
Nice guy. Nice dude. Good prosecutor. In fact, one of the best judges I ever went before was Judge Jolly in Marshall County. He wouldn't even, he was so good, he would not even, not supposed to, look up the criminal defendant's background. Like he came in totally just blank. He's like, I don't want to know. I don't want to know.
Fair?
Yeah.
Fair?
Oh, dude, man, he was greatest. Oh, man, that was a good judge.
If I don't need to know, why no? Yeah.
Yeah. They all do it, though. That's what sucks. It is weird to see the defendant go up there.
May I, Your Honor?
Yes.
Thank you. With Your Honor's permission, I would like to publish Exhibit 160.
Yes.
Thank you.
I'm going to put a cap in the total number of exhibits. Just put a hard number on it. Can't have more than
Dr.
this number.
Scorti-Bello, if you could please draw your
carefully.
attention to what is depicted on both screens. Pick whatever screen is most convenient for you. And what I want to do is to go over what is depicted there, and I'd like to start with just some basics. What is that white rectangle that is on the photograph?
This?
Oh, no.
Yes.
That's a ruler.
His eye out.
And what's the purpose of the ruler?
Really?
To show a scale. When I measure the injury, I use the ruler to document that.
And if you could please draw your further attention to what I will refer to, and you use your own term, but just to start it, the horizontal line that is appears to be a laceration. You know what I'm referring to?
This, yes, this is a laceration.
Right, so it's fair to say that that's a laceration.
Respond to
Correct.
it. I think they're just
And
lazy.
just so we get
These
all
state
that's
girls.
depicted on this, you referred to earlier up above that, the red area, is that an abrasion?
Yes.
And do you also denote to the left, almost like a J-type item going vertically up? Yes, and going up. Do you see that?
Yeah, that I did not note that specifically. I just noted the whole injury as part of the abrasion.
That's my point. So you didn't make a separate note of what appears to be a J, and it might be easier to see it in the screen over there. It's your conclusion, but is it easier to see there?
Yeah, I can see it.
Yeah, and so you didn't make a separate note as to what that was in your report, correct?
No, I did not.
Come on, dude.
Do you consider that an abrasion or something else?
I believe that's Still an abrasion.
Do you conclude that that J is different in any manner from the abrasion that you've noted above the laceration?
I believe it could be part of the whole abrasion, or it could be something different.
Fair enough. Would a fall backwards on a flat frozen ground produce a circular and not a linear abrasion as depicted here on the back of an injured person's head?
Can you repeat the question?
Sure.
Because you don't know the answer.
Assume a fall backwards on a flat frozen ground.
Grounds.
Would such a fall and impact
Sidebar.
present that type of pattern, or
Speculation.
would it present a
Wouldn't surprise
circular pattern, perhaps with something like a starfish in the middle?
Starfish.
I'll allow that. Can you answer that?
I wouldn't allow it.
I can
Incoherence.
say that a fall backwards could very well produce that injury.
My question is more specific,
Oh dear.
and that is a fall backwards
I changed my
where
opinion
the
in this
person
guy.
impacts the back of their head on flat frozen
be here
ground.
for a while.
Would you expect that type
Ugly starfish.
a laceration from that type of a fall? Not
The only
just
starfish
a
I'm
general
interested
fall
in is when
backwards,
someone gets
but
tased.
specifically
Then
a
we can
fall
chant,
backwards where the back of the
"Starfish,
head hits
starfish."
flat frozen ground.
Oh,
Would you
God.
expect that?
Yeah, I'm not interested in chocolate starfishes.
I
No, thank you.
could, yes.
And under what circumstances
Thanks for putting that in my
could
mind.
Yeah.
a
Miss Rhonda,
laceration
don't look it
like
up.
that and
Do
a-
not look
and
it
an
up.
abrasion, all of it together, what circumstances could cause that type from a fall backwards on flat?
It will never
frozen
leave
ground?
your mind again.
Well, the laceration is due to the blunt impact, and so is the abrasion. The abrasion is friction. So depending on the type of surface, you mentioned flat frozen ground, it's quite possible to have an injury as the one depicted. There's nothing inconsistent with this injury
So he
And
slipped
a
and fell and
fall
hit his head and then
on
rose
someone's
to death.
on the back of the head with a blunt surface.
Is there, are you familiar with the phrase pattern recognition in
Blink
medicine?
rate sure has gone
Yes.
up.
And isn't pattern recognition something that requires training with regard to being able to recognize certain patterns and determining what could be causing that pattern?
Yes,
And just merely recognizing whether there is a pattern takes certain specialty training, etc.
correct.
And isn't pattern recognition a principle that you apply in the medical examiner's office?
Yeah, we do.
And so example of pattern recognition could be a knife wound, correct?
Yes,
Could be a gunshot.
correct.
And there's certain patterns that you see on a decedent that can be consistent with those types of causes of injury, correct?
Correct.
She has no idea what he got hit with.
Assuming a fall backwards onto frozen ground, and there being on a lawn with grass, would you expect to see any grass at all in the injury site?
It's possible to have grass.
Is it possible to have well, are you familiar with the height and weight of the decedent generally? And if you need to look at your notes, please do so.
Yes. Mr. O'Keefe was approximately 6'1" and 216 pounds.
So, assuming a fall backwards and an impact to head on, a ground with,
Assuming
with
a
grass,
completely spherical surface,
a person who's
perfectly
6'1",
spherical,
there is
frictionless
going to be
surface
significant acceleration
uniform
forces
density.
that occur as they're going backwards. Is that correct?
That's fair to say, yes.
And therefore, the more acceleration forces, usually there's a correlation with the force of the impact.
Correct.
And in terms of force of impact and assuming grass on the ground, would you, do you believe it's more probable than not
simpler.
that one would then see some grass
But where's the fun in that?
on the head?
Yeah, we wouldn't be here.
Sustained is that form.
I knew it was coming.
Given what you testified regarding the height of Mr. O'Keefe,
His objection, I've lost the will to live.
and
is that-
assuming the what I just gave to you as a fall backwards and acceleration
searched in
and
the
forces,
eyeballs.
would you expect to see anything
man.
else on the back of his head?
Hair?
You have to be more specific than that.
Right, I thank you. So, would you expect to see?
Thank you. I fucked that question up. I'm so sorry.
Is it possible, if that was the manner of the fall, that there should be grass on the head? Is that possible?
Sustained.
I thought the manner of the fall was
Did
eating
you
from the forbidden
consider
tree.
at all in your evaluation
No? Okay.
the?
Man.
Well, let me back up. Do you see any evidence of grass in this depiction?
No, I do not.
Did you recall ever seeing any evidence of grass when you were performing the autopsy?
I did not see evidence of grass.
Did you consider at all in performing your
You probably got the grass
autopsy
stains when they
whether or not
Thank
grass
you,
should
Linda.
be present given what was reported to you by law enforcement?
Sustained.
Did you make any considerations at all regarding grass in regard to your autopsy report?
Damn it.
I did not see any grass. No, I did not make any determinations.
And was grass at all even a consideration in your analysis?
I had very limited information as to the exact nature of the surface at the time of autopsy.
So the answer is no to that
No.
question. Thank you.
Do you know the difference between different kinds of grass? Was it Bermuda grass or?
Did you have any
Bluegrass or-
information regarding the circumstances that you said you look at in trying to determine manner of death as to whether there were
Why would the
any
grass be
stones
green in
or
winter?
rocks around the scene?
That I did not have any information.
So meaning you didn't have any information, you saw no information that there were any stones or rocks by the scene, is that correct?
Sustained in
Oh,
that.
look at the judge.
What, if any, consideration
another
did
one?
you make in your assessment of cause and manner of death with regard to stones or rocks?
I did not make any.
With regard to any other potential causes other than ground, did you consider any other possibilities that could cause the type of injuries that are depicted on the screen?
There's a number of possibilities that could cause the injury.
My question is, did you consider, not whether there are, but whether you considered them at the time you were performing the autopsy?
I'm always considering at the time of autopsy what could have caused a certain injury.
Did you put in your notes or your autopsy report any of those considerations? Are they documented?
No.
Now, in terms of differential diagnosis that we talked about, did you determine whether there were any other possible explanations for the injuries to the decedent other than what law enforcement presented to you?
I'll allow that.
Internally, I consider all kinds of other explanations. I have to look at the findings and the possible ways that those injuries could have been sustained and decide whether I have enough information and whether I am satisfied with the information that I have in order to conclude or determine a manner.
Did you make any notes at all about the considerations you were just speaking about, other considerations? Any notes whatsoever in any document in your autopsy report?
Not in my autopsy report, no.
Did you make any other notes of those considerations in any document that you created for this case at all?
No, these are considerations that I've had and discussions I've had with colleagues in terms of evaluating these injuries and...
And I don't want you to go into what other people said, but I want you to finish your answer.
Right, no, I did not make physical notes of my considerations.
Your Honor, I'm going into a different category, so I just wanted to alert Your Honor to it.
All right. And it will take more than 10, 15 minutes?
Oh, yes.
Okay.
All right, jurors. Oh, the lunch is over. We'll take the lunch and recess.
Oh, here we go.
45 minutes.
45 minutes equals about an hour and a half.
Well, you know, there'll be an immediate sidebar, and so
Yeah, as soon as I come back, another 20-minute sidebar. Another sidebar.
Sidebar.
Jesus. I wonder where he's trying to go with this. I have a feeling I know.
Are we done, or we're doing more bullshit?
It's like psych.
Goodbye.
I'll take that as a clue.
Yeah, I guess that's it. Weird. Well, what do you think? I think that was a bunch of nothing.
Yeah, not really. Not much.
I have a feeling he's headed somewhere. I just don't know where. I think I know, but I'm not sure.
I think he's just trying to head to like all the things she didn't think about, and then he's going to get to the pressure that was put on her by Proctor.
That's what I'm thinking.
And that's where that's going to go eventually.
And that maybe hypothermia caused it.
Yeah,
which is possible. I mean, he could have lived with the head injury and died from hypothermia. I mean, I've seen numerous death certificates with contributing factors. I'm kind of surprised she didn't write it that way. It's just, it was a blunt force trauma. You know, you'll get it all the time with drug overdoses or something. You know, you might, they die of a heart attack, but contributing factor, large amounts of heroin, kind of does it. So,
yeah,
it's kind of weird. Well, I appreciate you having me on, man.
I appreciate you being
today.
Yeah, I mean, that's sort of the working plan. I appreciate you being here because I need the company to make it less horrible.
Yeah, I can stay a little while longer. I'm prepping for a trial, which is a breach of contract trial.
A breach of contract? Oh, that's exciting.
Oh yeah. Well, they have no case, but that's beside the point. It's over a house. So
tell us about the case.
They enter a contract to buy a house for, we'll just say $1 million, with an option to buy it. And instead of it being an integrated contract, it's a lease with a separate option agreement. It's a nightmare because the option agreement says that they pay a $25,000 option at the beginning, or they could do it at any time within the 3-year lease, even though it specifically says it's a month to month. The lease is a nightmare in and of itself. They pay the $25,000 option. So they've technically got the right to buy the house. Then it says further on that they have to exercise that in writing. They never did. So that's another contention. And oh, by the way, they've been in the house. Let's see. The lease ended in 23. They've been in litigation since 23. It started out as just an unlawful detainer, and it's now ended up in this, like, well, you breached the contract. We tried to buy the house. You wouldn't let us buy the house. And there's no proof. There's literally no proof, and they have never been approved for the loan. So my only answer to him was like, do you have $90,000? Because it was 10% down for owner finance. Well, no. Well, then why are you in the house? They're still in it. Yeah.
Yeah.
So that's why I tell people, it's just, the law is not as sexy as people think it is. It's a lot of boring
Often
stuff.
it's not.
No, just boring stuff. These folks, I feel bad for them, but there's really nothing we can do in it. Even if we won it, they don't have a way to specifically perform and buy the house.
Which kind of makes the whole thing moot.
Exactly. Which is why I'm pissed. I'm having to go over to Georgia to do it. So it's like, just move. Just move.
Yeah, if you can't perform on the contract, the validity of the contract from your point of view is kind of immaterial. It's like I can't perform on, so what does it matter?
Right. I mean, I could see the judge going, okay, yeah, you probably screwed them, not selling the house. You had no intent, it's bad faith, blah, blah, blah. I'm going to let you buy the house. Do you have the $90,000? No. Well, then you got to leave.
Yeah, kind of like, and that's one of the things I always like try to find is like, what is the easiest way to resolve the problem? It's like, how do I resolve this case in the easiest way? It's like, how do I just like, okay, let's skip all the steps and be like, do you actually have the money? No? Okay, great. Then I don't care.
In a lot of businesses, I thought about doing just how to avoid litigation. I just teach them how to avoid it. Swallow your pride. A lot of it is just pride, ego. That like, I'm not going to lose money. I have I do in-house work, and the guy I work for started out, it was a fraud. She was literally trying to defraud him about $51,000. Take that $51,000, it's now $560,000 in legal bills. Just to stop.
That's more.
It's much more. And I mean, she's good. She's a very good fraudster. But again, it's 10 times the cost. What's the point? You could have just paid her off. I mean, I hate to tell them that. I hate to tell people that, but it is what it is.
You can pay me. That's fine too. I mean, it's good for me.
No, I'm not stuck on Karen's responsible. No, I said I think she may be, and she may still be, but they can't prove anything.
I mean, I'm not beyond the possibility that that she could be responsible. It's just, but it's like, what is the easiest way for me to resolve this legally? It's like, this is again like just keeping my life simple. The question is, can the state prove it beyond a reasonable doubt as to each and every element? If they fail as to one element, they failed. It's like, okay, so I don't believe that the actus reus occurred. Well, that makes my life real easy. End of analysis. I'm done.
Even at I think the best they probably could have gotten would be manslaughter. I mean, what is she charged with? First or second degree?
Second degree.
Is it second degree?
Yeah.
Yeah, it's still pushing it. That's pushing it. And they have nothing except a broke taillight. I don't even know why she's on trial. I wouldn't have brought the case. It wouldn't have been brought but for him being a police officer.
Yeah.
And he was active as a police officer, or was he like retired?
No, he's active. He's on the job, I'm pretty sure.
I remember reading a comment, something about they said, "Don't fuck it up," or is he going to catch? Is this guy going to catch the owner of the property?
Yeah. Proctor said that like in the text messages.
Yeah.
No, he's a cop. He's not going to catch anything. Or talking about the Alberts, that is.
Yeah.
The homeowners.
And did he know the Alberts?
Did the victim know the Alberts?
Yeah.
No, I don't believe he's ever been over to that house before.
That's very bizarre. Huh. I mean, just because there's bizarre stuff that's unanswerable doesn't mean squat. I mean, it's interesting, but it doesn't prove anything,
Yeah. Well, if you need to go, that's fine. I'm just going to put the Core TV logo on the screen and see if I can get myself some lunch. I've got some chicken cooking in my crock pot.
Well, enjoy it. And thanks again. Thanks, y'all.
If you want to drop by tomorrow or something, just let me know.
You got it, man.
And everyone, check out our friend at his website, Bama Law. Check him out and subscribe and all that YouTubey stuff.
YouTubey stuff is good. YouTubey stuff is good. Hopefully. All right, guys.
All right.
Thanks, y'all. I appreciate it.
Yep.
Have a good day.
Bye. All right, bye. All right, well, that was our guest, Bama Law. He's a nice guy. So, yeah, we'll definitely have him on again because I need the company. Uncivil needs a friend. Uncivil needs many friends. Uncivil needs all the friends to help him deal with this level of stupid. You know, sometimes in our lives, we need a friend. Someone to lean on. Lean on me. Yeah, that's what we're doing right about now. All right. Well, I've got chicken cooking in my crock pot. It's been cooking for 4.5 hours, so it's probably ready about now. So I'm going to check that out and put it on some rice and have some chicken. So you guys can enjoy the wonderful music of Court TV hold music while I'm doing the chicken thing. We'll be back in 35 minutes ish, whenever the court returns. Talk amongst yourselves. Hello again. Welcome back to Uncivil Law. We are just waiting on the court to resume. That's exciting and fun. Should be starting any tune, probably, of course, with an immediate sidebar, because how could it not be an immediate sidebar? But, in any event, we are here for it. We are here for more of the medical examiner and the stupid relating to the medical examiner. So that's all fun. Thank you for the 230 of you who are here and spending time with me. It's appreciated as always. You guys rock collectively. And then tomorrow's Friday and we get a break. Yay, break. And that's fun. OnlyFan continues to spin, of course. Continues to seek justice as it does. We patiently wait for the court to resume. What's on your mind? Let's take a look at what people are saying about the Supreme Court oral arguments, I guess, while we're waiting. Struggling to focus? I feel you. I feel you. Let's see what people are saying about the connection today. The Supreme Court issued an opinion. We could cover that while we're waiting. I have no idea what it's about, but let's find out. Barnes versus Felix. All right, this is interesting, I think. Let's take a look at this. This will be fun. We might as well have some fun while we're waiting, right? Supreme Court's fun. That's what I keep telling people. All right, this is an opinion that was released earlier today. United States Supreme Court in the case of Barnes versus Felix. Respondent Roberto Felix, a law enforcement officer, pulled over Ashton Barnes for suspected toll violations. Felix ordered Barnes to exit the vehicle, but Barnes began to drive away. As the car began to move forward, Felix jumped onto its door sill and fired 2 shots inside. Feels pretty aggressive. Barnes was fatally hit but managed to stop the car. About 5 seconds elapsed between when the car started moving and when it stopped. 2 seconds passed between the moment Felix stepped onto the door sill and the moment he fired the first shot. That feels pretty aggressive. Barnes' mother sued Felix on Barnes' behalf, alleging that Felix violated Barnes' Fourth Amendment right against excessive force. The district court grants summary judgment to Felix, applying the Fifth Circuit moment of threat rule. The Court of Appeals affirmed, explaining that the moment of threat rule requires asking only whether the officer was in danger at the moment of the threat that resulted in the use of deadly force. Under that rule, events leading up to the shooting are not relevant. Here, the precise moment of the threat was the 2 seconds when Felix was clinging to the moving car. Because Felix could then have a reasonable belief his life was in danger, the panel held the shooting was lawful. So the question, of course, one of the questions is, what is the relevant time frame? What is the relevant time frame for making these kind of determinations? All right. The Supreme Court says, held, a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. The inquiry into reasonableness of a police force requires analyzing the totality of the circumstances. That analysis demands careful attention to facts and circumstances relating to the incident. Most notably here, the totality of circumstances inquiry has no time limit. While the situation at the precise time of shooting will often matter most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. Prior events may show why a reasonable officer would perceive otherwise ambiguous conduct as threatening, or instead as innocuous. A prior case illustrates the point. In that prior case, an officer's use of deadly force was justified at the moment, partly because of what had transpired in the preceding period. The moment of threat rule applied below prevents that sort of attention to context, and thus conflicts with the court's instruction to analyze the totality of circumstances. By limiting their view to 2 seconds before the shooting, the lower courts could not take into account anything preceding that final moment. So, for example, they could not consider the reasons for the stop or earlier interactions between the suspect and officer. And because of that limit, they could not address where the final 2 seconds of the encounter would look different if set within the longer time frame. A rule like that, which precludes consideration of prior events in assessing a police shooting, is not reconcilable with fact-dependent and context-sensitive approach this court has prescribed. A court detailing use of force cases cannot review the totality of circumstances if it puts on chronological blinders. Nice. The court does not address the separate question of whether or how an officer's creation of the dangerous situation factors into the reasonableness analysis. The court below never confronted that issue, and it was not the basis for certiorari. Kagan delivers an opinion of the unanimous Supreme Court, 9-0. So it is not just the literal moment of that the shot is fired. The entire context must be considered, which has no potential time frame limitations. While the exact moment of the shooting may be the most relevant and the most critical, it is not necessarily in all cases positive. So go back to trial court and look at the relevant analysis and let us know what is going on with that. Is the chat still with me on any level? Because no one is chatting, which makes Uncivil sad. All right, cool. Some of you at least are here. That's nice. Thank you, by the way, for those of you who subscribed and crossed 147,000. That's very nice. We appreciate it. Thank you. My chicken dish was pretty tasty. Thank you. Everyone's on lunch? Fair. Totally fair. Let's see if there's any news articles relating to the oral arguments that happened today. You're working on some emojis? Cool. I will accept more emojis. We're having fun with emojis. Emojis are fun. I don't know if there's any discussion. There was an oral argument live blog. We can try to read the live blog and see what people were saying from Scottish blogs. Try to find out stuff. Did I miss Kurt talking about Laurie Vallow? What's there to talk about? She was convicted. So is there something more to talk about? I mean, that happened a while ago, though. It was mentioned during the break. Yeah, there's nothing to talk about. She was convicted. She did a pretty good job as a pro se. And, you know, that's really all there is to really say about that, to be honest. Laurie Vallow had a hearing, went off on the judge. Not surprising. Looking sharp? Thank you. It's very kind of you. I will accept your nice compliment. Thank you. I'll complain about something that was irritating. So I got my insurance company to cover testosterone, which I probably should have done long ago. I'd been paying for it to be done by a compounding pharmacy. And then I was like, wait a second, can't I just get it covered by insurance? And the answer to that question was yes. So putting aside that, you know, I wasted a lot of money on compounded when I probably could have just got it covered by insurance the whole time. But putting aside that issue, I've now have it covered by my insurance. So my doctor wrote a prescription for the testosterone, as one does. And, you know, and that was all she wrote the prescription for, which will become relevant in a moment. So I go to Sam's Club to pick it up because that's where I get my medication filled, because I found that Sam's Club pharmacy has the best of, they regularly have availability of medications. And I found problems, for example, with Vyvanse. You guys were on calls before. I don't know the degree to which it's still a problem, but Sam's Club seems to not have problems. So it's like, okay, I'm going to get it picked up at Sam's Club. I'm not a member of Sam's Club, but that's okay. Either by operation of law or Sam's Club policy, I'm not sure which, but one of the two. By operation of law or Sam's Club policy, Sam's Club is required to allow me to use their pharmacy, you know, for the purposes of prescription drugs. So, you know, I can walk right in and be like, go into the pharmacy. You can't stop me. Ha ha ha. Right. So it's like, great. So anyways, I go to Sam's Club to pick up my testosterone. And it's like, oh, okay. And it's an intramuscular injection because that's what I'm used to using, intramuscular. And being an injection, I say, oh, and by the way, I'll also need you to sell me some needles because, you know, you kind of need that for the injection. And the clerk starts to ring me up, and the pharmacist actually interrupts him and says, well, we can't sell them to you unless you're a member. I was like, what do you mean? We can't sell you the needles unless you're a member. And I'm like, but I need them for the prescription because it's an intramuscular. I can't take the drug without the needles. And it's like, well, your doctor could write a prescription for the needles. I'm like, this is ridiculous. You know, incidentally, by the way, some states require, in case you care, some states restrict the sale of needles. Texas is not one of those states. So Texas has no law on this issue. Some states do. So Texas, as a matter of Texas law, it's not because Texas law requires. They can give needles to anybody, prescription or not. So you don't need a prescription to get needles in Texas. Ironically enough, we're apparently progressive on that issue. But as a matter of their own state policy or their own corporate policy, like, we won't sell you the needles unless you're a member, and so you can get your doctor to write a prescription. I'm like, this is ridiculous. So I was like, well, we can fax your doctor for the prescription. I'm like, why don't you do that? It's like, do you want your testosterone? I'm like, well, no, it does me no good. The prescription does me no good without the needles. So you hold on to it and get back to me. I thought this was ridiculous. I thought this was so ridiculous. I filed a complaint with the Pharmacy Board of Texas. I don't know whether or not they're required by law to do it or not, but it's like, this is ridiculous. So, you know, they have these wonderful signs, right, at the pharmacy. It's like, if you have a complaint, you can file a complaint with the pharmacy board. So I did. I filed a complaint with the Pharmacy Board of Texas.
Someone told you want to see me, I'll see you at sidebar.
Because of the stupid. So that's my story. So we are currently fighting that issue. And they said, okay, you can go to another pharmacy and get them. You could just go to a Walgreens and get them, which is legally correct. But as I mentioned, despite the fact that the law doesn't prohibit it, some pharmacists and some pharmacies get really sketchy about giving you needles if you don't have a script. There's nothing stopping them. They don't have to. But some pharmacists are like, I'm not going to sell you needles unless you have a script. I've actually run into this problem before and had to fight with a pharmacist before. I'm like, you can do this. Just give me the goddamn needles. So, anyways, that is my story time. The frustration continues. Maybe I can find a medical supply shop or something and they can sell me some needles. I don't know. But I was annoyed. I was annoyed because the needles are necessary for the prescription. You know, so the prescription is kind of incomplete without the needles. So I was just irritated. Walgreens, yeah. Again, in principle, I can go to any pharmacy, and they're allowed to sell me needles, but I might have to have a fight with the pharmacist, and I don't want to have the fight. It depends who the pharmacist is and what pain in the ass they want to be that day. You know? So, yeah. Why not use a gel? Well, I don't know. I'm used to using the intramuscular, so that's what I asked my doctor for, because that's what I'm used to using. So that was the end of that. That's the reason. I'm used to using the intramuscular, so I'm just going to keep doing it. So it works. And yeah. Just take the script in to show them, and they'll sell them to you. Well, I don't have a script because the script was sent to the pharmacy electronically. So what do I ask them to print it out? Yeah, this is annoying. Yeah, I could take the bottle of the medication to the pharmacy and be like, I need needles for this. And then they'll ask me, well, why didn't the other pharmacy give them to you? And I have to tell them the story, and I might have to have a fight. I've decided to make this Sam's Club problem. I've decided to make this Sam's Club's problem. It's like, you get me, you figure it out. The whole thing is dumb. It's a behind the counter item at the pharmacy too. I mean, you know, unsurprisingly, the needles are behind the counter, and they still want something without a membership. I'm like, this is dumb. I'm sure the gel works fine, MG Law. I'm just used to using the needle, and so I'm just going to keep doing that, okay? I'm sure the gel can work fine. I want the needle injected into my body.
You are unmuted.
Excuse me, please.
There's no law for me to fight. There's nothing for me to fight legally. There's nothing. This is just them being a bitch. They don't have to. They're just being a bunch of bitches, and I don't like it very much. They have the right to condition it. There's nothing for me legally to fight. I'm just going to yell at the void. Unless, of course, they're required as a matter of law in Texas, which I don't know if that's true or not, unless they're required as a matter of law to make it available because it's a behind-the-counter item. I don't know that to be true, but there was a sign that said if you have a complaint, you can contact the pharmacy board, so I did. And the pharmacy board can figure out whether or not it was illegal. Probably not, but yeah. Minor annoyance. Minor annoyance. I looked on Amazon. I couldn't really find the needles that I was looking for on Amazon. But maybe I didn't look very hard. You would think Amazon would sell them, but they sold some needles, but not the ones I'm used to using, so I don't know. They sold insulin needles, but those are too small. Yeah, I mean, they're not breaking. Well, they might be breaking the law, but probably not. Yeah. So unless there's a regulation that requires them to make it available because it's behind the counter, then, but probably not. So they're probably not breaking the law. But I still complained because it was annoying. It was stupid. Walgreens curbside pickup. I don't know if that would work or not.
Court is in session. Please be seated.
Can you get alcohol from Costco without membership? In some states, you can.
Whenever you're ready.
In some states, yes.
Good afternoon, Dr. Scott.
And Texas, I believe the answer is yes, as a matter of
Thank
fact.
I want to move on to a slightly different aspect of the hypothermia discussion. So you've acknowledged previously that hypothermia is a very difficult diagnosis to make, correct?
Correct.
And you acknowledge that in your grand jury testimony in this proceeding, correct? Do you recall that?
I do.
And you indicated in that grand jury proceeding generally that diagnosing hypothermia is based on contextual clues. Is that correct?
On autopsy findings and investigative information, yes.
Right. And the last part, investigative, and that's that legal part, sort of the law enforcement contribution. Is that correct that you're referring to?
Correct.
You diagnosed Mr. O'Keefe with hypothermia based upon certain medical data that you believe you observed in the gastric area and the pancreatic area. Is that correct?
Correct.
And just for, I think most people will get this, just be clear, gastric is sort of synonymous with the stomach.
Stomach.
And then we know the pancreas is a separate organ. And in your autopsy, you observed for example, the lining of both the stomach and the pancreas. Is that correct?
I'm sorry, what was the word you used?
Let's start with the stomach. Did you observe the lining of the stomach as part of Mr. O'Keefe as part of the autopsy?
Yes, I observed some hemorrhages in the lining of the stomach.
We'll get to that, right? But I just want to talk about the organs and what aspects of the organs first, and then we'll get to that. And with regard to the pancreas, what aspect of the pancreas did you observe?
I examined both the external surface and the tissues around it, as well as the pancreas itself by making several cuts.
And there was also a histopathology report that was relevant to both the stomach and the pancreas, correct?
Correct.
Histopathology?
Spell it, Mr. Lasser.
Histopathology. So that histopath information informed your hypothermia analysis, is that correct?
The histopathology was done to further confirm my finding or my determination of hypothermia.
So, do I have it correct, and let's start with the pancreas, that you noted the pancreas was congested and diffusely hemorrhagic? Do I have that correct? And you feel free to look at your report, please.
I will.
And I specifically, if it helps, I'm
Yes.
looking at
Page 4.
the report of autopsy. It's not numbered pages, but it would be 4. And you see liver, gallbladder, and pancreas is 1, and then you go down a couple more and you see digestive system. That's what I'm focusing on.
Okay.
And then, and the next page is the histopathology.
Yes.
All right, are we sort of oriented in the same location?
Yes.
All right, so let's start with the pancreas. So if you look at the histopathology page, it says endocrine and exocrine pancreatic tissue with vascular congestion and patchy parenchymal, that's parenchymal hemorrhage, autolytic changes. Did I read that correctly?
Yes.
And I want to go at these one at a time, so now I'm going to jump back to the previous page where you discussed the heading liver, gallbladder, and pancreas. Do you see that?
Yes.
And you see the last sentence says the pancreas is congested and diffusely hemorrhagic. You see that?
Yes.
So now what I'd like to do, and is that what you're rooting in, if you will, the analysis of hypothermia?
The determination of hypothermia was made, yes, based on these findings and the circumstances I was provided. Yes.
Right, and thank you. I'm going to get to the circumstances, but in sort of the medical legal construct that we were talking about, I want to just start first with the medical, if that's okay with you.
Yes.
So then let's now move to the organ of the stomach, a synonym gastric in terms of your report. So let's go to, please, back to the histopathology section. And under that, under pancreas is stomach. And there's a bulleted one sentence that says gastric tissue with vascular congestion and focal mucosal hemorrhage. Did I read that correctly?
Yes.
And then let's go back, as we did with the pancreas, for the stomach, go back to the previous page in your report under the heading digestive system. And the second sentence states the gastric mucosa shows focal areas of linear hemorrhages. Did I read that correctly?
Yes.
So we've got hemorrhage discussion with the pancreas. We've got hemorrhage discussion with the stomach and the gastric area. Your diagnosis of hypothermia was not based just on gastric and pancreatic hemorrhaging alone, though, was it?
No.
And you did fairly refer to other circumstances just moments ago in your answer, correct?
Correct.
And we're going to get to that. So that means that your diagnosis of hypothermia was also informed by the information we discussed earlier that was provided to you by former Trooper Proctor in his investigation. Is that correct?
Correct.
And one aspect of that information is that he was found, Mr. O'Keefe was found in the snow, correct?
Yes.
So let's go to the death notification report. Am I generally correct that you were, I'm sorry,
Rephrase it.
I will. Thank you, Your Honor. Do you recall the death notification report in this matter?
I do recall, the very initial first information that comes in. That's the death notification given to our intake staff.
Do you recall the contents of that death notification report?
Would you like me to summarize? I don't recall I don't have it in front of me, but I can tell you what the gist of it was.
Would it be helpful recollection on what that, a document that may refresh
She
your
said
recollection?
sure. I don't
Thanks.
think you heard her.
I did. Thank you, Your Honor. May I approve? Yeah, approach, Your Honor.
Yep,
Thank
just
you.
show Mr. Brennan.
Yeah.
Yes.
Dr. Scordi-Bello, what I'd like to do, you can read anything you want, but I'm just going to reference to the section that says circumstances of death.
Yes.
What I'd like you to do is read it to yourself, not out loud, and then when you, just that section, up to here, and once you're done, if you could kindly look up and let me know.
Okay.
Dr. Scordi-Bello, did that refresh your recollection with regard to the circumstances of death section of the death notification report?
Yes.
And you could please state now what your refreshed recollection is on that topic.
Yes. The initial intake death notification was made by a physician at the hospital, and it stated that we were dealing with a adult male that was found in a snowbank. There was note of having been at a party. There was some information as to the decedent was walking to a house. There was reference to some sort of altercation or dispute with
Sustained.
Strike.
Jurors disregard that. Move on with this, Mr. Leslie. With this, but just move on.
Yeah, yes. In terms of the differential diagnosis concept that we were talking about before, based upon your refreshed recollection of circumstances of death as discussed in the death notification report, based upon that, did you consider whether Mr. O'Keefe could have been injured and died somewhere other than the front lawn of 34 Fairview?
Objection.
I'm going to allow that.
Initially, no.
Let's go to significance, if any, of hemorrhaging of the two organs we were talking about, the pancreas and the stomach. Is it correct that the hemorrhaging of a pancreas can be caused by many different things?
Yes, it is.
And to be clear, you found evidence of hemorrhaging of the pancreas of Mr. O'Keefe in the autopsy, correct?
Correct.
And is it correct before the grand jury, you yourself were evaluating whether the injuries had been sustained in a different environment? Well, let me ask it this way. Do you recall what your testimony was in the grand jury about hemorrhaging of the pancreas and possibilities of injuries being sustained in different environments. Do you recall any testimony on that subject?
All right, I'll see you at 10.
Sidebar. Sidebar's best bar, baby. Thank you all for joining me. Thank you for tolerating me. I love you. Most of the time, chat, you're great. Thank you for the 354 of you who are joining. Just a friendly reminder, hit the like button if you haven't already, and also the retweeting and stuff also helps. Tomorrow is Friday, thank God. And we all get to have a break. That's nice. That would be epic. Sidebar. Lighting is looking good. Lighting is looking good at the moment. Thank you. It's nice when everything sort of comes together. Also, in random personal news, I put up some paper sort of blinds on my window because I was getting too much spill light. So I bought these paper accordion style blinds. They're very cheap, but they keep the light out, and so they accomplish the objective. So I had those on last night, and I was much happier for it. So hooray, random blinds. Grand jury testimony is admissible. It's admissible for the purposes of impeachment. Thank you, Snacks 1999. It's appreciated. Thank you. Yeah, they're working they're working perfectly adequately. So I'm happy. Got to get that light out. Also, congratulations to my parents. Is it today? I think it's today. I don't know if it's today, but if it wasn't today, it was in the last couple days. They've celebrated their 52nd wedding anniversary. So congratulations to mom and dad for that. You're the best. I love you guys. It might have been this past Sunday. Yeah, somewhere in there. I love my parents very much. They're very good parents. I still talk to them and I love them. They're good parents. I did pretty well on the parent lottery, all things considered.
May I, Your Honor?
Yes.
Thank you. At the grand jury, did you testify as follows? If the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. You recall that?
Yes.
Hemorrhaging of the pancreas can also be caused by blunt force trauma, correct?
Correct?
Hemorrhaging of the pancreas can be caused by CPR, correct? Cardiopulmonary resuscitation.
It's possible.
Do you know what a Lucas machine is?
Yes.
And a Lucas machine is an automated CPR machine, correct?
Correct.
And it's a rather large device, correct? It gets strapped down to the chest of someone. So instead of someone having to exercise, etc., you put on a Lucas machine that goes over the chest and it automatically does the compressions, right?
Correct.
Lucas machines can cause hemorrhaging, correct?
Yes.
And in fact, wasn't a Lucas machine applied to Mr. O'Keefe?
I believe so.
And wasn't the Lucas machine applied from when the first responders came to the scene and he was in the ambulance continually and through when he was in the hospital?
I believe so, yeah.
So, when a Lucas machine is used in resuscitation efforts, you'd actually expect to see some hemorrhaging, wouldn't you?
Where?
In the stomach? In the pancreas? Would you expect to see it there?
Not in the mucosa of the stomach and not as extensive in the pancreas.
Let's talk about and pick the pancreas first. So you would agree that from the use of a Lucas machine, you would expect some degree of hemorrhaging in the pancreas, correct?
Not always.
But it's certainly possible that a Lucas machine causes hemorrhaging of the pancreas, correct?
It's possible.
And now let's move to, and there was evidence of hemorrhaging in the pancreas of Mr. O'Keefe, correct?
Correct.
Now let's move to the stomach. Isn't it possible that a Lucas machine could cause hemorrhaging in the stomach?
Personally, I have not seen it in that context.
But do you rule that out?
I can't rule it out. I can only tell you my experience.
So your personal experience is you don't believe you've seen that, but you can't rule out that a Lucas machine causes hemorrhaging to the stomach. Is that correct?
I don't believe a Lucas machine causes hemorrhage to the mucosa of the stomach.
Right. I'm not yet at the mucosa of the stomach, which is a subset of the stomach, right? You're talking about the gastric rugae.
Talking about the inner lining of the
inner
stomach.
lining, and another name for the inner lining of the stomach is the gastric rugae, R-U-G-A-E, correct?
Yes.
So I'm just talking about the stomach in general, not a subset of the stomach. Is it possible that a Lucas machine could cause hemorrhaging in the stomach?
Not in the stomach, around the stomach in the soft tissues of the torso.
Okay. So you've said that you're aware that Mr. O'Keefe was hooked up to a Lucas machine, correct?
Yes.
And are you aware of the length of time that Mr. O'Keefe was hooked up to a Lucas machine?
No, I am not.
Do you know how many compressions per minute a Lucas machine causes?
I would have to say close to 60.
Would 100 compressions per minute be a reasonable amount of compressions for a Lucas machine to cause?
Sure.
So assume 37 minutes of a person hooked up to a Lucas machine, and assume 100 compressions per minute. That would result in 3,700 compressions from a Lucas machine, correct?
Correct.
Could 3,700 compressions from a Lucas machine explain hemorrhaging in the pancreas?
You could.
And that explanation could be why there's hemorrhaging in the pancreas as opposed to hypothermia causing hemorrhaging in the pancreas, correct?
Possible.
Did you consider that at all in your autopsy report, the effect of the Lucas machine? Is it written anywhere in your autopsy report?
I do consider changes due to cardiopulmonary resuscitation. The rib fractures that were observed were attributed to CPR. Usually we will see some amount of hemorrhage in the soft tissues, but in this context, with the gastric findings, the pancreatic findings, and the information that he was found in the snow with a body temperature of 80 degrees, my opinion was that those hemorrhages, along with the gastric hemorrhages and his body temperature, were consistent with hypothermia.
My question was, does your report state anywhere the words Lucas machine?
No.
And you agree that a Lucas machine could cause hemorrhaging to the pancreas,
It can cause hemorrhage in a lot of tissues,
but including the pancreas.
including the pancreas.
If you see hemorrhaging of the pancreas and you believe that hemorrhaging is a contributor to hypothermic deaths, wouldn't you also expect to see Wisniewski ulcers?
I did note gastric hemorrhages.
So the court reporter needs to have a spelling of that. Doctor, can you give us the spelling of that?
Would you like to give it?
If you'd like me to, I'd prepare
Go
to give
ahead.
it. Thank you. Wisnewski. So,
I can spell.
can you just tell the jurors what Wisniewski spots or Wisniewski ulcers are?
Wisniewski spots are small hemorrhages, small areas of bleeding in the mucosa of the stomach.
Don't ask me to spell anything
that
ever,
are
chat, by the
thought
way.
to
I
be
can't spell worth a damn.
associated with hypothermia, among other things. They're believed to be either a reaction to stress due to the hypothermia or some form of what we call reperfusion injury.
Is it correct that if someone is believed to die, at least in part, from hypothermia, that in 90% of the cases of death from hypothermia, you would find Wisniewski's ulcers?
I do not know the exact number.
Is it that you're not recalling what the percentage is for the percent of cases for death of hypothermia that you would expect to find Wisniewski's ulcers?
I don't.
Do you recall?
Hold on. Move on. The objection sustained. So
Okay.
you're asking it, yes, go
Okay.
ahead.
Thank you. There were no Wisniewski's ulcers present in Mr. O'Keefe, is that correct?
I believe there were.
Can you point anywhere in your autopsy report where the word Wisniewski appears.
I did not call them Wisniewski spots, I called them gastric hemorrhages.
Right, so you didn't use the term Wisniewski and you didn't use the term ulcer, correct? In your report at all?
No, I used gastric hemorrhages under the title of hypothermia.
Do you believe that all hemorrhages in the pancreas are Wisniewski ulcers?
You mean the stomach?
I want to start with the pancreas.
Wisniewski ulcers are, the term is used to describe the gastric hemorrhages.
Right, so I wanted to clarify that, so now I want to move to the stomach.
Okay.
This is a little tedious, I'm not going to lie. Okay, it's a lot
Hemorrhages
tedious.
in the stomach are Wisniewski ulcers.
Not all of them.
Therefore, there can be Wisniewski ulcers and not be hemorrhaging, correct? Just by logic?
And not be hemorrhaging?
Correct. You can have a Wisniewski ulcer but not have hemorrhaging.
You could, but ulceration would manifest in what we call hemorrhage, the actual appearance of it.
What I'd like to do now is, Mr. Wolf, what has been in evidence, what I'd like to do is to, with your Honor's permission, publish some depictions of first the gastric mucosa, and then start with that, Your Honor, publish that.
All right. So this is the one that we have not introduced into evidence openly, but at sidebar, right?
What I'd like to do is I'll start out with the one that is in evidence, which is the gastric mucosa.
Okay.
Start with that.
What number?
Your Honor, just to...
Okay, so that was the one I was referring to that we did at sidebar, not in open court. Okay.
Yes.
It's for identification.
Pardon me?
It's N for identification.
And I'd like to move NN into evidence at this time.
All right. All I'll say about this, jurors, is that this may be considered graphic. You satisfied with that, Mr. Alessi?
I'm satisfied with that, Your Honor.
Okay, Mr. Brennan, you satisfied with that?
Yes, Your Honor.
Okay.
164.
May I, Your Honor?
Yes.
Dr. Scorbello, I'm handing you Exhibit 164 in evidence, and I'm going to also, with the court's permission, have it published on the screen. So whatever one is best for you to look at the screen, please feel free to look at either one. Mr. Wolk, if you could publish 164. Dr. Scorbello, do you recognize 164 as well, you describe what 164 is.
This is a picture of the stomach of Mr. O'Keefe after it was removed and opened and the contents were removed. And what you're looking at, this pink-red surface is the mucosa. That's the lining of the stomach. And you had used the word rugae before. These are the folds. The stomach has a lot of folds. And what you can see here are small areas that are redder than everything else. That's hemorrhage, that's blood. And these are the gastric hemorrhages that I described.
Right, so those are what you just show there's darker areas, there's just a few of them, that is what you refer to as hemorrhages, correct?
Wisniewski's was, correct.
Well, you didn't use Wisniewski's in your report, correct? You referred to
Correct.
them as hemorrhages.
Correct.
Okay. So what I'd like to do now is to, if I may approach, Your Honor?
Yes.
For the chalk.
Chalk.
Exhibit MM.
With your Honor's permission, may I show Dr. Scorti-Bello the chalk that's marked for identification? Is that it?
Yes, and let's see what she answers before we use it for more questions, okay?
Understood. Yes. May I hand it to you?
Yes.
Dr. Scorti-Bello, could you please take what's identified as Exhibit M and see if you can identify what that depicts?
Yes, this is a picture of a stomach, again, the mucosa with hemorrhage.
Just hold for these, sorry. Not your fault.
Your Honor, can we take a break?
Yes,
Jurors.
yes.
Please rise for the jury. Jurors, right this way, please.
Break time. Break time is glorious time.
I'll see counsel at sidebar, please.
I bet you will. More sidebar. Too much sidebar, man. Too much sidebar. Lolly needs to smoke. You and me both, man. I'll tell you what. I don't smoke, but why was the bailiff requesting a I don't know who was requesting a break. The only logical conclusion is because the juror signaled to the bailiff that they needed a break. And so the bailiff said it would be the logical conclusion. So let's go with the logical conclusion. Perhaps it was very graphic and the person needed a moment. It was odd. I don't know if it was odd, but I need a break too. When the court comes back, I'm going to put the court on and step away for a moment myself. I need a minute. Spinny fan. Spinny fan is best fan. Spinny fan is greatest fan. Spinny fan. Perfect stomach with the amount of drinking he did. Hungry for sashimi? I doubt that, but okay. Well, it was graphic enough the judge thought that they had to give a special warning about it. So it was probably pretty graphic. If the judge had to give a special warning about it, it was probably pretty graphic. So I don't know what Alessi's trying to do. It's very tedious. I need a break. Yeah, I was just waiting for the court to come back so you didn't have to like not have something on screen that was entertaining. Do you think he's trying to get the fact that Proctor called her a whack job? Yeah, maybe. But I'm so tired, I might have to take the break anyway because I was trying to have something that was vaguely good television. All right. I'll take the break then. I need a couple minutes away or more. Where's my streaming tab? Too many tabs open.
Please be seated. Court is in session.
All right, Mr. Alessi, you can continue where you left off.
Thank you, Your Honor. May I reapproach the witness?
Yes.
Dr. Scordi-Bello, you have in front of you, which has been marked for identification as MM, and you were discussing that. Do you recognize that document since it sort of started over to reorient the jury? You recognize that?
I recognize what it is, yes.
And what is it?
It is a picture of a stomach, of the mucosa of a stomach with multiple hemorrhages.
And does that exhibit fairly and accurately depict a stomach with what you have referred to as multiple ulcers?
Yes.
Your Honor, I offer that into evidence.
I object to agree as a chalk.
I'll, you know what, if I can use it as a chalk
Yes, you
publication.
can.
Yeah, that's what I'll do, Your Honor. Thank you, Mr. President.
So you can have it displayed.
Thank you. And again, I'll leave this hard copy with the court reporter, and we'll use the screen.
Oh, so it's not in evidence?
It is not.
It's marked for identification?
Yes, marked for identification, and we are with it. Mr. Wolf? Dr. Scordi-Bello, is that the depiction that you were just describing at your witness stand?
Yes.
And could you please, with the laser pointer, state what you see in this depiction?
So this is a stomach. This is the mucosa, the fold of the stomach. They're not very folded in this particular picture, but you can see these distinct areas that are that have a darker coloration. That's blood. These are hemorrhages.
And to be clear, this is not the stomach of Mr. O'Keefe. This is a medical reference depiction to sort of generic, or some other depiction other than Mr. O'Keefe's stomach, correct?
Correct.
If we could, with Your Honor's permission, Mr. Wolk, put side by side this chalk with what is in evidence as the actual gastric mucosa of Mr. O'Keefe.
The objection sustained.
Could we, with Your Honor's permission, publish simply Mr. O'Keefe's
Yes.
gastric mucosa?
Yes.
Isn't it correct, Dr. Scordi-Bello, that there are much less dark spots in this depiction of the gastric mucosa than there were in the chalk that we just displayed? In other words, that green depiction of what I'll just refer to as a generic stomach. Is that correct?
That is correct.
So, you can take that down, Mr. Wolf. Isn't it correct that for hypothermia in the presence of Wisniewski's ulcers or spots, that you have to have a predominance of the stomach covered by the spots for them to be Wisniewski ulcers?
I think there's different levels and different grades.
In hypothermia, particularly death from hypothermia, wouldn't you expect to see a predominance of those ulcers, meaning they take up most of the stomach lining? Isn't that what you would expect to see?
Not always. I have seen that. I have also seen cases with much fewer spots, as you refer to them.
But isn't the majority of the cases that you have seen where someone has actually died from hypothermia that the ulcers predominate, take up greater than 50% of the stomach?
Yes.
And what percentage of the, and I'm trying to avoid putting it up again. So what percentage of the gastric mucosa of Mr. O'Keefe would you estimate is taken up by the ulcers that you have identified?
I would say somewhere between 10, 15%.
Just 10 and 15%. Thank you. Now, if we could look to the issue of continuing with hypothermia. Let's go to frostbite. Did you note any evidence of frostbite on the decedent, Mr. O'Keefe?
No, I did not.
Do you know what the weather conditions were in Canton, New York on the early morning? I'm sorry, I keep saying Canton, New York. My apologies. Do you know the weather conditions in Canton, Massachusetts, starting at midnight on January 29, 2022, going through 6 a.m. on January 29, 2022?
It was very cold. There was a blizzard coming.
They called it a nor'easter, right?
Correct.
And when you say very cold, in addition to very cold, do you recall whether there were gusty winds?
I believe so.
And do you understand that when there's a very cold temperature in Fahrenheit and you add gusty winds, that is called, when you apply the two together, that's called wind chill, right?
Correct.
And with wind chill, doesn't the phenomenon of wind chill mean that the wind combined with the temperature brings the actual temperature down, and in addition to bringing it down temperature in a wind chill calculation, it also has a physical effect on the body, correct? Wind chill. Doesn't wind chill also cause greater effects than if there was no wind?
Correct.
So in medical terms, the wind synergizes with the temperature and exacerbates the effect on a human.
Correct.
And with a wind chill, isn't it correct that you would have a greater chance of frostbite than if there was no wind chill effect at all?
Yes.
So, you saw no signs of frostbite on Mr. O'Keefe, correct?
At the time of my examination and at the time of autopsy, no, I did not.
Did you see frostbite at any other time with regard to Mr. O'Keefe?
I only examined him at the time of autopsy.
So at the only time you examined him, which is at the time of autopsy, you had zero signs of frostbite, correct?
Correct.
Dr. Scordi-Bello, now that you have gone through this part of your examination here today, would you like to amend in any way your opinions as to whether hypothermia was any cause of the death of Mr. O'Keefe?
No, I don't. I still believe that there were hypothermic signs.
Hypothermic signs, correct?
Yes.
I'd like to move to another topic area, please. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not.
In fact, there were no injuries consistent with a motor vehicle impact on Mr. O'Keefe, correct?
Sustained.
Did you evaluate it all in your autopsy whether Mr. O'Keefe had any injuries consistent with a motor vehicle accident?
Objection.
I'll allow that.
Yes, I did examine his lower extremities. That is protocol in any case of suspected impact with a motor vehicle. So I did examine his legs, and I did not see any evidence of an impact site.
And could you elaborate to the jury what you mean by no evidence of an impact site?
Objection.
I'm going to sustain that objection.
What do you mean in your answer, no evidence of impact injuries?
Objection.
I'll allow that.
What I look for is some sort of bruise, either on the outside of the leg or bleeding on the inside after the skin is reflected in the soft tissues, or any fracture of the bones of the legs. I did not observe those things.
That was going to be my question. You did not observe any of those things, correct?
Correct.
I'd like to turn to, please, the face of the decedent in your analysis that you discussed on direct examination of that area of the decedent. You talked about ecchymosis, you recall that?
Yes.
In medical literature, there's a synonym for ecchymosis. It's sometimes referred to as raccoon eyes. Is that correct?
Correct.
Ecchymosis doesn't cause a laceration to an eyelid, does it?
No.
Ecchymosis does not cause a laceration to a nose, does it?
There was an abrasion on the nose, but no, the answer is no.
Correct. So ecchymosis doesn't cause a laceration to the nose. Correct?
Correct.
Did your report at all evaluate whether there was any significance of the laceration to the eyelid that you spoke about in your direct testimony?
What do you mean?
Other than just noting that there was a laceration to the eyelid, did your report at all evaluate the potential significance, if any, of that laceration to the eyelid?
I noted it and photographed it, and it was part of the totality of the blunt impact injuries that I noted on both the face and the head.
Do you believe that the laceration to the eyelid could be caused by a blunt impact injury?
A laceration, by definition, is a blunt impact injury.
Do you believe the eyelid laceration was caused by a blunt impact injury from falling backwards and hitting one's head?
Not from falling backwards and hitting one's head, but that area at some point came in contact with a blunt object or surface.
Okay, if I could follow up on that, please. So you agree that if a person falls and hits the back of their head, that they cannot sustain an eyelid injury, is that correct?
Correct.
All right. And if somebody falls backward and hits their head, they can't sustain, from that impact to the back of the head, a laceration to the nose, correct?
Correct.
So if we could, Mr. Wolk, and with your Honor's permission, publish which is already in evidence, which are depictions. Let's start out with, please, the laceration to the right eyelid. And Dr. Scortibello, is this the laceration to the right eyelid that we've been talking about of Mr. O'Keefe?
Yes, it is. Yes, it is.
And that injury could not be caused by a fall backwards and one hitting their head, correct?
No.
I'm sorry, we'll just need, and then I'm going to repeat the question. Can you state your answer again? Let me that injury to the right eyelid, that laceration, could not be caused by someone falling backwards and hitting their head, correct?
Correct.
Bear with me one moment, Your Honor. May I approach, Your Honor?
Yes. Show Mr. Brennan.
Your Honor, I erroneously assumed that that picture was in evidence, and I would like to now properly lay the foundation if I could.
Okay.
Dr. Scortibello, you see what's in front of you. Can we mark this?
So, Mr. Brennan, are you objecting to that coming into evidence? Okay, so let's just put it in evidence.
Exhibit 165.
Thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Scortibello, I place before you what is in evidence now is 165. And Your Honor, may I have Mr. Wolk publish
Yes.
165? Thank you, Mr. Wolk. So, Dr. Scortibello, that laceration to the right eyelid could not be caused by a fall backwards where someone hits the back of the head, correct?
Correct.
So that injury, you've called, what do you label that category? Traumatic, did you use that phraseology?
Blunt impact.
Blunt impact. So that's a blunt, in your opinion, that's a blunt impact injury, correct?
Correct.
So is it correct that that injury had to occur in some manner other than falling backwards and hitting one's head?
Yes.
And is that injury consistent or inconsistent with a punch?
I'll allow it.
Could be consistent.
If we could, Mr. Wolk, have the laceration to the nose. I'm sorry, hold off on a moment. Your Honor, Mr. Brennan has agreed to stipulate that this going
Okay,
into
so
evidence.
like we can mark it.
Exhibit 166.
Oh, thank you.
Thank you. May I, Your Honor?
Yes.
Thank you. Dr. Scortibello, I have put before you what is in evidence is 166, and Your Honor may, Mr. Wolk, publish.
Yes.
Thank you. Dr. Scortibello, does that exhibit fairly and accurately depict the laceration to the nose of Mr. O'Keefe?
Yeah, it's an abrasion. I described it as an abrasion, as a scrape.
So you would classify that as a scrape?
Yes.
That scrape could not be caused by someone falling backwards and hitting the back of their head, could it?
Not by a single event, no.
You can take that down, Mr. Wolk. On your direct testimony, you talked about injuries to the right arm of Mr. O'Keefe. Do you recall that?
Yes, I do.
And is it correct that you, in your autopsy report, did not determine the cause of those wounds to Mr. O'Keefe's right arm?
That's correct.
With your Honor's permission, I would like to Mr. Brennan. Your Honor, Mr. Brennan has agreed to
Okay.
stipulate into evidence these two photographs. May I please have them marked
Yes.
as next to evidence?
Exhibits 167 and 168.
Thank you.
I'm going to do the same thing, if I may, Dr. Scordi-Bello. I'm going to leave these with you, but I'm also going to, with the court's permission, have them published.
Okay.
Use whatever one best allow you to answer the question. Your Honor, may I have Mr. Wolf publish those two? Thank you. With regard to what is on the screen, am I correct that you noted these injuries and these wounds to Mr. O'Keefe in your autopsy report?
Yes,
And am I correct that you noted that there was a pattern to those wounds?
correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those patterned wounds. Is that correct?
That's correct.
Are those injuries consistent with a dog bite?
Based on our answer to the last question, ask something else.
I'm sorry, couldn't hear you.
Ask another question, sustained.
Can you identify any cause of those injuries that would be consistent with what is depicted on the screen? Objection.
So, can you answer that, Doctor?
I cannot.
You can take that down, Mr. Wolf. Thank you. Do you recall discussing at all on your direct examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
So, were you aware that there was clothing associated with Mr. O'Keefe when he came as part of the autopsy?
He did not have any clothing that came to us. The clothing was removed at the hospital and was packaged and I believe submitted as evidence.
So the clothing of Mr. O'Keefe, a t-shirt or a hoodie, didn't make its way to you?
No?
You were unable to reach a determination as to the manner of death of Mr. O'Keefe, correct?
That is correct.
So you have doubts about the manner of death of Mr. O'Keefe, and you consider those doubts reasonable?
Sustained. Sustained.
You were not able to reach a determination as to the manner of death of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed. Okay.
I'm sustaining it, asked and answered.
Thank you for answering my questions, Dr. Scordi-Bello.
You're welcome.
All right, thank you, Mr. Leslie, Mr. Brennan.
Doctor, how many autopsies have you performed in your professional career?
At this point, more than 1,200.
When the person is brought to you, are they usually clothed?
It depends on the circumstances. If a person comes directly from their residence, they may or may not be clothed. If the person comes from a hospital where they went first for treatment, many times the person is unclothed. They may be wearing a hospital gown, but in most cases that clothing has already been removed.
If that clothing has already been processed, is it common that it would be brought to you for inspection?
Objection, Your Honor.
Sustained as to the point.
Is clothing that is not accompanying the person's body commonly brought to you for observation?
Objection, Your Honor.
So let's move on. Or ask it.
You were asked questions about your opinions relative to spots in the organs of Mr. O'Keefe, and you were asked about part of your statement in the grand jury. When you provide statements, is it important to have the statement in context to understand it?
Yes.
Is it important to have a complete statement rather than just part of a statement?
Yes.
And when you were asked the question that counsel asked you, do you remember that grand jury testimony you gave?
I remember it was a long time ago.
Okay.
But I do remember most of it.
Do you remember when he read part of your answer? It was in response to a grand juror's question?
Yes.
And he read part to you, right, I understand your question, and my answer is that I don't know, but given the environment, so if the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you remember that?
Objection, Your Honor.
The doctor can answer that question.
Do you remember Attorney Alisi read you that part of your statement?
Yes.
Do you remember that you had more to that statement that was left off when he confronted you with it?
I'm sure there's more to this.
To complete your statement, you said, but in the whole context, I believe that those are signs of hypothermia and not caused. Do you remember that completion to your statement?
Objection, Your Honor.
Sustained. You can show her the statement.
Okay. I can approach. I'm going to ask you to take a look at part of your grand jury testimony. Do you remember Attorney Alisi reading part of your answer back?
Objection, Your Honor.
So I'll strike that. Have the witness look at it and go from there.
Were you asked about your entire answer or just part of it?
Objection, Your Honor.
Sustained.
Did you read the rest of the answer that you weren't given when it was read to you?
Objection, Your Honor.
So this is phrased as refreshing recollection, so follow it appropriately.
Do you now remember there was more to your answer?
Yes.
Could you share with us the rest of your answer?
Without reading it.
Objection, Your Honor.
Without reading it. Turn the paper over, please.
I can take it, Your Honor.
Ask the appropriate question, Mr. Vernon.
Do you remember the part that was left out?
Objection, Your Honor.
Sustained.
Does it refresh your memory to the rest of your statement to the grand jury?
I'm sorry, what was your question?
After looking at this, does it refresh your memory to the rest of your statement you made to the grand jury?
Yes.
And could you share the rest of your statement with the jury, please?
The rest of the statement was that I have to take those findings in the context which was presented to me. So in the case of this particular case, those hemorrhages, in the context of a body found in the snow, I believe they were due to hypothermia.
Is your answer more complete in context?
Objection, Your Honor.
Sustained.
You were shown a photograph of two individuals that were in the room at the time of autopsy. Do you remember that photograph?
Yes, I do.
And you were asked about certain names.
Correct.
You said that there would be a log identifying names.
It would be a log, yes.
A log. Do you remember exactly who logged in to that autopsy?
No, I don't remember their names.
May I approach?
Show Mr. Lesson.
It's part of the end of the report. It's in there. Possibly take a look at your report. You have it.
Your Honor, if we need sidebar to explain, we just need a moment to take a look.
I can move on and we'll come back to it, Your Honor.
Thank you, Mr. Brennan.
You mentioned that Mr. O'Keefe's body temperature was a little under 81 degrees when he was brought to the hospital.
Yes, that's what the hospital records stated.
And again, a normal body temperature is?
98 degrees.
So there was, is it fair to say there was over an 18-degree drop in his body temperature?
Correct.
You shared with us that you generally understood it was a blizzard and cold outside. Do you have any experience on how rapidly a body temperature will drop outside?
The body temperature?
Yes.
Objection, Your Honor. Scope.
No, it's within the scope. Let's see if she's got the basis for it.
The rate that the body loses heat depends on a number of factors. Depends on conditions, weather conditions. It depends on the original temperature of the body, and the higher the gradient between the body temperature and the environmental temperature, the faster the drop will occur.
You were asked if there was any signs of frostbite. There was no type of freezer burns or anything on Mr. O'Keefe's body, was there?
Objection, Your Honor.
Sustained.
Was there any type of burns on his body that would suggest that he was put in some type of machine or environment where there was cooling, mechanical cooling?
Objection, Your Honor. Will be
Sustained.
approached.
Sustained. Move on, Mr. Brennan.
You were shown a photograph, a chalk, that had spots on them. Do you know where that photograph came from?
I do not.
Do you know who that was from, what person that was from?
No, I do not know the context of that picture.
Do you have any information on the circumstances which led to that condition?
I do not.
Do you have any information about what caused the condition that you saw on that chalk?
I have seen similar pictures in textbooks depicting gastric hemorrhages or Wisniewski spots.
You were asked about your role as a medical examiner, and there were a number of questions about your assessment from a legal perspective.
Yes.
You mentioned that you had information from a police report. How many police reports were you given?
There was a a preliminary police report, I believe, the day of the autopsy, and communications with law enforcement in the days and weeks following.
May I approach?
Yes.
Showing you a document. Do you recognize that document?
Yes.
What is it?
This is a police report on this particular case.
Is that a police report from your file?
Yes.
And that police report, is that the police report that you considered?
Amongst other information, yes.
How many lines is that police report?
11.
What's the date and time of that police report?
This was initiated on January 29th. It says at 1941.
I have this marked for identification, all right?
Okay,
And in the, what's another document?
let us mark it.
Oh, sorry, let me have that back.
Yeah.
QQ for identification.
Thank you. May I approach, Your Honor?
Yes.
Second document, was that another document in your file?
Yes.
And is that another report that you considered?
Yes.
How many lines is that report?
5.
I'd move to have this marked for identification, please.
Okay.
Thank you.
Exhibit RR for identification.
May I approach again?
Yes.
I'm going to go back to the questions I asked you about logging in and refreshing your memory.
Mhm.
I'm going to hand you a document. I'm not going to ask you to read it aloud. I'm just going to ask you to look at it. Does it refresh your memory on the people who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Corner.
Are you part of the criminal investigation team?
No, I am not.
Did you go to the scene and evaluate any evidence?
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role as the medical examiner in your medical evaluation of Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Yes.
You were never, well, let me ask you. You submitted the death certificate on April 14th?
Correct.
I want to talk about some of the things that you may or may not have known about or considered at the time you wrote your death certificate or filed your death certificate. Were you informed or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that the defendant,
I'm going to allow it.
that the defendant said, I hit him, I hit him, I hit him. Were you aware of that
I became aware of it at some point.
during your 90-day window?
I believe so.
Were you aware that there was another first responder by the name of McLaughlin who provided information that the defendant said, I hit him, I hit him, I hit him, I hit him?
Yes.
Were you aware of statements made by the defendant, to Miss McCabe, that she said, may have I hit him? Did I hit him?
Judge, may we approach, please, briefly?
Okay. Thank you. So jurors, I want to let you know that like other evidence that was let in previously, this is not coming in for the truth of what's in the statements. It's coming in so that as it goes to Dr. Scordi-Bello's knowledge and state of mind at the time of her report.
Thank you. At the time of your death certificate that you filed, were you informed that a Jennifer McCabe had reported that the defendant said, "Did I hit him or could I have hit him multiple times?"
Objection, Your Honor.
I'm going to allow it.
I don't believe I knew about Miss McCabe.
Did you learn that Ms. McCabe reported later that the defendant, while speaking to first responders, reported that she had hit him? Did you know that?
That, yeah, I was aware of that information later on.
Were you aware of the investigation regarding alcohol consumption?
Yes,
Were you aware that the police or Massachusetts State Police spoke to other witnesses about their observations that night?
about their,
Their observations?
yes,
Were you aware of an interview by Trooper Buchanan with firefighter Daniel Whitley on February 7, 2022?
I don't remember.
Were you aware that Mr. Whitley told the police that the defendant had expressed that she had gotten into an argument with the defendant that night?
That was part of the information I was given, yes.
Were you aware of a report from first responder Anthony Flamate about statements made by the defendant to him?
I don't recall that particular first responder, no.
Were you aware of statements provided by Kerry Roberts to the police that the defendant had called her,
Were you aware?
citing Kerry,
That I hate
John
you.
is dead?
Yeah, I was given.
Were you
that
aware
information.
of the channel
And the
Uncivil
questions of
Law
did I
and
hit
its
him? Were
brilliant
you aware
legal
of that?
analysis?
Yes,
Were you aware of
Were
information
you aware that portions of your testimony are being used to interrogate prisoners at
troopers
Guantanamo?
had an opportunity to go and speak to the defendant?
yes,
Were you aware of the statements that she made to the troopers?
not in detail.
Were you aware that if you had 5 apples and I took away 2 apples,
Were you aware that when
you
they
still
spoke
have
to her
3
on January
apples?
29th, she informed that she had a broken taillight on her vehicle but did not know how it happened?
Objection, Your Honors.
I'll allow that.
Yes, I was provided
Were
with
you
that
aware that
information.
Were
Istanbul
you provided the
was once
information that she had never
Constantinople?
observed John enter the residence?
I believe that was part of the original information, yes.
Were you aware that she informed relative to the broken right taillight she didn't know how it happened?
Were you aware
Yes, I was.
that rubber duckies
Were you aware
made
that
bath time lots of fun?
members of the Massachusetts State Police obtained John O'Keefe's phone and did a forensic data analysis on it?
I was not aware of that until much, much later.
After you filed your report?
Correct.
Were you aware of location data
Were you aware
that was
that your testimony
obtained from
is
John
being
O'Keefe's phone
investigated by the Center
before
for Disease
you
Control
filed the death
and the
certificate?
Alzheimer's Foundation?
No, I was not.
Were you aware
for brain
of
damage?
healthcare data on John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of battery temperature data on Mr. O'Keefe's iPhone before you filed your death certificate?
No, I was not.
Were you aware of voice messages left on John O'Keefe's
you
phone
aware-
from the defendant before?
that
filed
the
your
jury
death
was
certificate?
conscious at the
No, I
start
was
of
not.
this, and
Were you
probably
aware
not
of
so
text
much
messages
now?
between the defendant and John O'Keefe before you filed your death certificate?
No.
Were you aware of statements from the defendant to various media outlets before you filed your death certificate?
No, I was not.
Were you aware
Did anybody ever come to you after you filed your death certificate and
that
ask you
C
to change
is for cookie,
it?
and that's good
No.
enough for
Did
me?
anybody ever provide you any of this additional information you weren't aware of at the time, ask you to evaluate it, and then reconsider your finding?
No.
You were asked some questions about impact injuries. In your experience, are most pedestrian collisions where there's injuries to the lower legs, either frontal or rear impacts?
Objection, Your Honor.
I'll allow that because, I'll allow that.
Most pedestrian fatalities that we see are with impact with the front of the vehicle.
When you gave the perspective that you looked for impact injuries,
Were you aware
was that with
that
consideration of
Mercedes-Benz is
your
often
experience that
credited
most
with
collisions
having
are
the
frontal
first
impact
automobile?
injuries?
Did you
Most
know that?
collisions involve frontal impact, yes.
Were
How
you
about
aware
cases where you
that
had an
Mercedes-Benz
opportunity
was
to
originally
observe
called Daimler?
people who sustained injuries
Did
from
you know that?
being clipped?
And
Not
the
hurt, but
company
just
was
being
then
clipped.
named
Is your
Mercedes
opinion any
after
different in
someone's
your
daughter.
experience?
Objection, Your
I
Honor.
forget who.
Sustained in that form.
I want to say it was
How
a
about
customer's
side
daughter.
swipe injury? Is that
It was named.
different
It was renamed. The company was renamed
relative
after
to your
some customer's daughter, I
expectations
think.
to lower
you know
extremity
that?
injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee, is that consistent with a side swipe impact?
Could be.
Did you do any type of biomechanical analysis of any alleged collision in this case?
No, I did not.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision,
Were you
are
aware
you in part
that
speculating about what
BMW
could happen
stands
to
for
somebody?
Bavarian Motor Works?
Sustained in that form.
Are you
Because they're from
giving
Bavaria?
a direct
Did you
opinion
know
in this
that?
case about
Did you know? Were you
how
aware the
injuries
BMW
were
logo is meant to look like a propeller plane
you were
because they
asked
originally
questions
designed
about
engines
a nose
for airplanes?
laceration?
Were you
Yes.
aware
And you
that
offered that was not
Lamborghini and
consistent
Porsche
falling
made
backwards on the head
and
alone?
I believe still
Correct.
make
You were asked if that was
tractors?
consistent
Did
with
you
a
know
pump.
Lamborghini started as a tractor company?
Correct.
Did you know that?
That's not the testimony. That's your objection, Mr.
That is,
Lacy.
Your Honor.
And they still make tractors today? Did you know that?
Did you provide an opinion that it could be consistent with a punch?
I did provide that opinion.
Could it be consistent with broken glass?
It's possible.
Could it be consistent with sharp shards from broken plastic?
Possible.
Could it be consistent with first aid?
I'm sorry, what was
Could
it?
it be consistent with first aid treatment?
Anything is possible.
Do you have any firsthand knowledge of how
Were you
the
aware
laceration on the nose happened?
That if you
I
put
do
your
not
right
have
foot
firsthand
in
knowledge.
and then your right foot out and then
Did
your
you
right foot in, the
know
next thing you're supposed to do
At
is
the time
shake
you
it all
filed
out?
your death certificate that there was
Do you know what that's called? Do you?
plastic pieces
Do you
of
know what it's
taillight
called?
found near Mr. O'Keefe's body around 5:45 p.m. on January 29, 2022?
I do believe some of that information was communicated to us, yes.
Thank you.
All right, Mr. Lacy.
Were you aware that there's probably no amount of drugs
Thank you, Your Honor.
that will bring my happiness back at this point?
Dr. Scorti-Bello, this Attorney Brennan just asked you questions about alcohol consumption. You had the opportunity to evaluate the medical records of Mr. O'Keefe, correct?
Correct.
And you had, in terms of the medical records, information with regard to the medications that Mr. O'Keefe had taken, is that correct?
I believe I reviewed those records at some point prior to issuing my report, yes.
Do you recall the list of medications that were in the medical records that Mr. O'Keefe was on?
I do not
Were
recall.
you aware
If
that
I were to
Rolex
show you a
started as a
document,
British company?
might that refresh your recollection as to the list of medications?
Were you aware that Rolex comprises 30% of
I'm going
Swiss
to allow
sales
it in connection with alcohol.
and
too,
sells
you said.
1.2 million
Go right
watches a
ahead.
year? Did you know that?
Yes.
Dr., may I, Your Honor?
Yes.
With Dr. Scordi-Bello, may I stand by the witness here?
Yes.
Thank you. Dr. Scordi-Bello, I am providing you with a document. Up at the top it says John O'Keefe, and I would like to draw your attention to medications. And to expedite it, I am going to focus on the fourth item on that list. Can you state what that medication is?
The fourth item is omeprazole.
Does that
Were you
refresh your
aware
recollection as
the
to
land
one of
dweller
the medications
is a poorly named
Yes.
piece of
and
shit
that medication is
It's
that
an
Rolex is
antacid.
trying to convince
And so
people is the
omeprazole
next thing?
is
And it's actually some bullshit.
the trade name of
Did you know that?
omeprazole Pepsid?
I believe so.
And Pepsid is a proton pump inhibitor.
Correct.
And a proton pump inhibitor stops the proton pump in the stomach from releasing acid, correct?
Yes.
And we're going to come back to that in just a moment, but do you also recall testifying at the grand jury with regard to alcohol consumption and potential alcohol consumption of Mr. O'Keefe?
I do remember testifying, yes.
And do you recall what your testimony was with regard to alcohol consumption and small ulcers in the stomach potentially associated with alcohol consumption?
Alcohol consumption, I don't recall my exact words at grand jury, but alcohol consumption can lead to gastric ulcers.
Yeah, wow,
And
genius.
Alcohol
leads to
consumption
ulcers. That's
can
great
lead to
news.
gastric
Thanks.
ulcers.
Tell me a
and
different story.
What medications
Any different story.
can treat gastric ulcers?
Well, they don't treat them, they prevent them, but that would be a proton pump inhibitor such as omeprazole.
Right. So, isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption,
It's possible.
as opposed to hypothermia, correct?
Correct.
Attorney Brennan asked you questions moments ago, and actually several
Were
of
you
them,
aware
of which
that only fan
included
knows the truth?
the words, "Did I hit him? Could I hit him?" Do you recall those questions?
I do.
And isn't it correct that you had that information before you
Were you
issued
aware that
your
uncivil law has kind of lost
final
it?
findings
to
in
use the
this
parlance?
matter in April of 2022?
Were you aware of that?
Yes, I did.
So,
Assuming he had it in the first place, which,
even
to
though
be fair, is one hell of an
you
assumption.
had all that information, you still were unable to conclude the manner of death of Mr. O'Keefe, correct?
Correct.
Thank you, Dr. Scordi-Bello.
All right, doctor, you are all set. I'm
Yay.
going to see counsel at the sidebar.
Boo. Were you aware that a trained pigeon could have probably conducted a better investigation than the police did in this case? I have a trained pigeon with me if we want to put it up to put it to the test. The trained pigeon's pretty good though, I gotta warn you. Were you aware? I'm running out of things to say at this point, to be honest, because I'm just kind of like delusional. Were you aware on civil law has gone bye-bye? We miss on civil law, yeah. Yeah. What other things should we be aware of, chat? Help me out. What other things should we be aware of? I'm open to suggestions. We're aware that VW owns Porsche and Lamborghini. Yeah, and it's even more complicated than that because like VW owns Porsche and Porsche owns Porta VW. It's kind of weird. Were you aware the handicap stall is the Cadillac of pooping stalls? That's a very good point.
That is it for today. I'm told that we are on schedule.
Uh-huh.
So with that, I'm going
What
to-
schedule is that, incidentally, at this
Please
point?
do not discuss this case with anyone. Don't do any independent research.
Do you think it's a violation of the judge's order to discuss it with my
If you
therapist?
happen to see, hear, or read
Probably.
anything about this case,
What is the law on that, MG law or Bama law? What do you think? If the judge says don't discuss the case with anyone, and then I discuss it with my therapist because it's hurting me emotionally, am I in violation of an order? And also, do I have to admit to it? What is the rules on this? Anyone have any ideas? I need help. My brain hurts.
All right, so Mr. Lessie, I'll hear you.
Yay.
I'll hear you, Mr. Lessie.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes. That
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in
Are you aware
reports
that we have some really
right
cool
up
merch
until not established,
that's
they
available for
stated in
sale?
the reports of Aperture, particularly
Were you
the
aware
slide
that it is
presentation of
discounted from the
Dr.
price
Welcher,
that the site recommends to make it a little bit cheaper for you guys?
1162.2 that they have associated in the report of Dr.
Were you aware it's
Welcher
pretty good
with
stuff?
a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming
that information, and this is from best memory, but I believe it's slide 137 or so, where this statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. Now, I'm just going to get. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffen's analysis. And Mr. Whiffen's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before
You think we're
the
approaching the
testimony
end?
of Aperture. And we are
You think we're approaching the end of the
in
trial?
a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May
The only
8th
way we're
report that we
approaching the end of the
received on
trial
May
is in the Nick Rekieta
11th
sense of it.
be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it.
I don't like to use
So,
hyperbole,
Your Honor,
but
our request is
okay.
that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation, remedy be that this is not allowed, and that the Commonwealth proceed with its, the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACA or have them go by their old report, right?
Right, and Your Honor, I'm going to answer your question, but with just the quick point that this is really much different than ARCA because two reasons. We are the defense, and ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you
Right,
have
so-
another
so-
option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion and a Rule 14 violation.
And you're not waiving that?
I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a
Right.
chance to talk to ARCA at
All
all.
right, so tomorrow morning, let me know that. All right,
In Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen, I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense in theory is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
all right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. And if you recall in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they potentially called. Mr. DeSorga wrote a report, and in the report he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the text stream data, the black box data,
His phone ran late?
has a event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate that the variance means that these times would never align. And that's what he did. He studied the data, he studied the Waze, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned from his opinion is that Mr. DeSorbo was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to
I
25
understand this
seconds.
issue about 60%, so I'll do my best when we get to a break. But I'm not at my best. I don't understand it 100%.
21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moment when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text stream data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now the defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
In my case in chief, because we now have this available data. As I said, this wasn't ambush, it isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said, he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert
That can't
report
actually be someone's
within
name.
the reciprocal discovery
Mr.
deadline.
DeSorbo, right?
Okay.
And he provided that report months ago.
Okay.
So if, as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DiSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DiSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report
went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it, he already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first
All right, I thought Burgess was, no?
No, neither.
Okay.
No one from Aperture was.
I knew
Your Honor.
Aperture was, and I thought he may have been something. The name just sounded
Neither
familiar.
Burgess nor Welcher were part
Okay.
of the first trial, but they were retained. Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay, so what I'd like to do, because I want to address the other issue and I don't want to keep people here too long, can you wrap it up, Mr. Alessi, or is that?
There's no chance in this world, Your Honor.
So,
We both know the answer is no.
Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding, fetching reason to not allow it, because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay, thank you. The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, the efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled government's objection and has stated that it is going to allow the defense to proffer two expert witnesses in a very complicated field, in an issue that is the heart of this case. That you're going to allow them to testify, despite the fact that we have not had adequate time to review, and to prepare, and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt.
You sure do.
And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wexler. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of
I
work,
am not
effort,
keeping
and
track
expense
of all
went into
this.
preparing our case to the jury.
I understand this issue
He is
40%.
still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple four opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis,
Yeah.
testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first review of material.
Okay.
Some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARPA witnesses. That's going to take time. We've heard from the ARPA witnesses themselves that the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday. We were going to try to begin to prep at the end of the weekend. There is no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what would we like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARPA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now, so by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. So we ask that he be able to continue his review, offer rebuttal opinions on anything that is new, and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess's information and material.
Right.
It will make no sense. I thought about it. It makes no sense to the jury, this presentation, unless Shannon Burgess has an opportunity to provide the background information.
Right. Mr. Lassie, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARPA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that.
So if we're focusing just on the quote new information bucket, Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of Aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA. When Dr. Rentschler was on the stand, and with Dr. What you said, when can you get me the information?
And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double rebuttal, surrebuttal to the defense. I believe, Your Honor, the final point is, if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely, that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Lessie. Are you still thinking that if the defense puts on a defense, that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this, because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay.
It's
All right,
logical.
I needed all this information now, so I appreciate it. All right, thank you.
Court, all rise.
All right.
Goodbye.
Goodbye indeed. All right. Here's what I think is happening. But I'm not at my best. I'm pretty fried. And that was a lot of information at the end there. But here's what I think is happening. Okay. I think responsive to... All right, so The Commonwealth hired Aperture to rebut ARCA. Aperture produced a report. Aperture produced a report to the defense. The defense turned that report over to ARCA. ARCA has been working on rebutting Aperture. What I think happened, and Aperture was supposed to turn over its report to the Commonwealth, I think by the 7th. I think. So I think what happened, if I understand it correctly, is that part of Aperture's response to part of ARCA's response to Aperture, now the Commonwealth is trying to rebut the rebuttal. Because they're like, no, that's not right. So they're trying to rebut the rebuttal. And in the process of rebutting the rebuttal, they have synced time clocks between the SUV and the cell phone. And what the defense is claiming is that's unfair surprise, because the fact that the time clocks would not be in sync would be something that would be known the entire time. They're independent devices, right? There's no particular reason to believe that the SUV's clock is the same as the cell phone's clock. So to the extent there's a discrepancy, this discrepancy would have been known. It's not a new thing. And the prosecution's witness wants to argue the data is synchronized, but the defense is saying that we weren't provided sufficient notice of this, and the discrepancy in the time has been part of our defense. Part of what we've built our defense on is the discrepancy of time. And now you're arguing that they're actually linked, but that isn't a new issue. It shouldn't have been a new issue. So you have changed the evidence in a way, including in a report, because one of the reports was like, we did this to sync the clocks. So you've actually changed the reports, and you didn't provide disclosure of that to us. I think that's what happened. The times and ARC are separate issues. Okay, in that case, I fucking give up. If they're separate issues, I fucking give up. I have no fucking clue what the issue is. I throw up my hands completely. I fucking give up. I have no fucking clue what's going on. Sorry. I thought they were related issues, and I have no fucking clue what's going on. I have nothing. I got nothing. I've got it. Eric said they're separate issues. Are they separate issues or aren't they? If they're separate issues, I have no fucking clue what's going on. I thought they were related issues. Because it makes sense in the timeline. It makes sense in the timeline that that's what happened. You think they're two different issues? If they're two different issues, then I have no clue. If they're not connected issues, then I have no clue what's going on. But they're separate. If they're separate, I have no clue. I have no clue. I have nothing insightful to offer. I give up. I have no clue. Sorry. I have no idea. I have no idea. I have no clue. The issue is Aperture updating the report after the 8th and dropping on defense the 11th. It's supposed to be done already. Well, Aperture updated the report because of ARCA, right? So that would mean I was right. Aperture updated the report because of what ARCA was doing, right? Prosecution is asking for a rebuttal of a rebuttal. Well, that's what I said. Isn't it? Isn't that what I said? How's that different than what I said? Aperture just updated it willy-nilly. Aperture just updated it for no particular reason without any particular impetus. They just updated it. Okay. So Aperture just decided to update the report with no particular reason. They just updated the report for no particular reason. It wasn't responsive to ARCA. They were just updating it for the hell of updating it. Okay. Wasn't responsive to ARCA, but it... Okay. All right, so it wasn't responsive to ARCA. They were just updating, presumably in anticipation of ARCA, but not in response to ARCA. Okay. So, yeah, so Aperture provided a report about a month ago, and presumably in anticipation of what ARCA would say, they updated their report in a way that is providing a disclosure that's not fair, because the disclosure was not provided to the defense, and so the changing the report is changing something in a material way that's providing an unfair surprise. Okay. Should we listen to it? Absolutely not. I do not have the mental bandwidth to listen to that again. Absolutely not. That would not be a bad suggestion under normal circumstances, but I simply do not have the mental bandwidth at this time to listen to it again. We could listen to it again, and I'd probably know less than I know now by listening to it again. It would be counterproductive at this point. It's hard to believe that it's that like massive a thing, but defense is going to make it seem like the end of the world. Okay, and what did the defense want? A continuation was their second option. What was their first option? What did they want? What remedy did the defense want? What was the first thing they asked for? I forget. What did the defense want? Exclusion of the new info? Yeah, that makes sense. They want exclusion of anything that wasn't in the original report that was turned over, right? Yeah, it makes sense. Yeah, okay. Yeah. I buy that. Yeah, they didn't have this information. Part of their questions, part of their cross-examination, the Aperture stuff, was based on the report. They're changing the report in some sort of way that is, to the defense's mind, material. We'll put aside the materiality of it for the second, but whatever. And so they want the new stuff excluded. Okay. Brennan argues it's not a Rule 14 violation because he didn't know about it. Which, okay, fair enough. He didn't know. So Rule 14 basically requires him to disclose what he knows, and he didn't know. Aperture just decided to, provide revision. So it's not a Rule 14 violation. Okay. But basically, it still amounts to unfair surprise in any event, whether it's a rule violation or not, which is what Alessi was talking about with like burden of proof, right? Because it's like, they're supposed to respond to what the Commonwealth says, and they're, weren't given, the information correctly, and so they want the new stuff excluded. Yeah, I mean, that seems fair. That seems fair to me. So, assuming I understand the issue at this point, the defense's ask seems pretty reasonable. Yeah. Okay. Yeah, that makes sense. They changed their report. Somehow it's material. We were basing our defense and on our questions and our cross based on the report, at least in part. They changed it in a way that compromises our defense, it compromises our posture by changing the theory of the case. We didn't prepare with that in mind. So we caught a little flat-footed. It's unfair. Fundamental fairness, basically. So exclude it. Okay, that kind of makes sense. Yeah. And Bev's like, yeah, I'm not going to do that. What else do you want? Continuance? Yeah, you're not going to get that either. Bev probably is like, oh, you have plenty of time now. Because you're not, they're not, especially if they're going to call ARCA at the end of their case. If they're planning on calling ARCA at the end of their case, that's not going to happen for quite some time at this point. So probably not sufficiently prejudicial. Is probably where Bev goes on that one. It's not sufficiently prejudicial. There's plenty of time. Yeah. Okay. Fair. Yeah, trial by ambush is definitely what's happening. I'm going to see if I can get some really good solid sleep tonight. In fact, I think I'm just going to go to bed now, get myself a nap, and then go to bed again later. I think I'm just going to go to bed now. See if I can get myself some sleep. I'm tired. I will see you tomorrow. Hopefully a little bit more chipper. I am totally fried right now. I am completely fried. So hopefully tomorrow I'll be a little bit more chipper. Later.